Good morning. I'm so excited. I have been waiting for this for like the last 7 hours. We are going to be catching up with the last bit that we missed from this week's hearings in it. Everyone's calling it the Holly Bobo case. It's Tennessee versus Zachary Adams. This is one long extended hearing on a petition for post-conviction relief. Most importantly, a new trial. And we should be getting to Jennifer Thompson first. So this is going to be the trial attorney we're going to be watching. It's going to be a great time. We did do a watch party last night over in the Discord. It was really cool. The functionality worked really well. Let me get the link over there. Drop the Discord link in the chat. It should be in the description as well. But we watched, what did we watch? We took a look at the 2020 episode. There was a composite image that Clint Bobo helped put together, and it certainly seems to look like Terry Britt and not any of the four. Heard some other interesting things like voice identification. Clint Bobo identified Terry Britt by voice. We also took a little bit of a look at the podcast. So remember, Trial and Error is a podcast with Dr. Katie Spirko. She's been investigating this case. She's also a forensic neurologist, I forget what her term is. But she thinks, after deep diving, she believes that the Adams brothers are completely innocent. And she and her co-host, a criminal defense attorney, put together a podcast with everything that they found as they looked through the case. So that was really cool. Thank you to everyone that came and hung out in Discord last night. And excited to see what we've got here. Don't forget, tomorrow we'll be starting with day 1 of the trial rewatch. Speed this up a little. Skip the eagle. Well, I can make this bigger for you guys. Sandwiches to eat or to throw, FFS? I actually have a biscuit here with me, Aaron. Sorry to say that out loud.
Circuit Court 9 section, all right.
All right, good morning, everyone. Be safe.
And this judge's name, by the way, is also Brent. So we've been talking a lot about how there's a lot of duplicate names in this. We got Jennifer Nichols last night on the stand when we were watching. This morning we have Jennifer Thompson. This is Brent Bradbury, the judge, but we also had Brent Booth, the ex-TBI agent, the retired TBI. So good times.
All right. Anything we need to bring court's attention before Mrs. Scholar?
No, Your Honor.
Ms. Bates, you call Ms. Thompson?
Yes, Your Honor.
Yeah, we'll stand right there. Here's.
Do you swear or affirm that testifying you give will be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Yes, absolutely.
State your name, please.
My name is Jennifer Thompson,
And can you spell your last for the record?
Thompson.
I'm going to ask you questions about your professional background. When did you obtain your law license?
1996.
And you've been a lawyer in good standing ever since.
Yes.
In 2014, I'm going to ask questions about your practice at that point. Where were you practicing? What city?
Nashville.
And how was your practice divided?
Well, I did mostly criminal defense with some family and divorce law.
How many years had you mostly done criminal law?
Since 1996. So to 2014, that's
that 18 years?
Okay. Federal and state, or just
Federal and state, yes.
divide it geographically between cities and rural?
I did mostly Nashville area, but I had been hired to do some cases in surrounding counties and some more distant counties in Tennessee.
Had you ever had a felon case in West Tennessee?
No,
How many murder cases had you had?
I don't know. Many.
Death penalty?
This is my first death penalty case.
How many assistants and paralegals did you have?
At that time, I had one assistant, a paralegal.
Did you have any more assistants through the case of representing Zach Adams?
She was the only assistant that I employed.
Describe the process of being retained by Zach Adams.
Well, I was on the board of directors for the National Association of Criminal Defense Lawyers at the time. I was very dedicated to defense and indigent defense. And so I had been going to the national meetings for the National Association of Criminal Defense Lawyers, NACDL, I'll call it. And I had got a call from a cousin of Zach's in Atlanta, and she had gotten my name from an attorney in that organization as someone in Middle Tennessee that did criminal cases.
How soon in the process was this?
It was after Zach was arrested, but before there had been any court.
Okay. And did you charge a fee?
Yes, I did.
Was he in general sessions case or in circuit court?
No, it had been indicted. It was a direct presentment
Okay.
indictment.
What fee did you charge?
$50,000.
Was that a flat fee?
It
or
was a
were-
flat fee.
Okay. And you were paid that.
Yes,
At some point you became appointed.
yes.
And how does that process work?
I think it was about a year in, and I had done work. I had done enough work where if I had been billing at an hourly rate, I would have run through the retainer. And Jim Simmons had already been appointed. And I think that somebody told the judge they needed to appoint me in order for me to keep making a living while I was doing the case.
When you charged the $50,000 flat fee, did you have any idea how voluminous discovery would be?
I had no idea.
Had you charged a fee that much in your past?
Yes,
When you were retained, was it a death penalty case?
no, it wasn't a death penalty case.
When it became a death penalty case, were you appointed or still on a flat fee representation?
I was appointed, I guess. Maybe that's what it was. It became a death penalty case about a year after in May. I think it's May of 2015 that it became a death penalty case. And that's when I think I got appointed.
When you came on, who was the district attorney at the time?
Hansel McAdams
Then you were present,
and Beth Boswell.
you were on the case during the time Matt Stutt was.
Yes, so that was a complete crazy happening.
Then
Can't wait to hear why.
General Wyrick's office, ADA Nichols and Hagerman prosecuted till the end.
Yes. I think that was in the fall of 2014.
Take the court through your initial work after being retained in Zach's case.
Well, it kept saying that they were going to get me discovery, and they kept saying, we're going to get you discovery. We've got the discovery. We're going to get it. And so I was retained, I guess, in late February, early March
Of what year?
of 2014. And so then the district attorney, Beth Boswell, mostly, said that they were going to have DNA evidence because they had searched Zach's house and they had done all this testing on things. And she said, we're waiting for the DNA evidence. We're going to have DNA evidence. And so that's when I got Jim Simmons to come on board as co-counsel. Jim Simmons there's a lot of death penalty cases, and he is excellent at getting a guilty plea out of a case that normally might go to trial, and he tried to end. And at that time, I believed Zach Adams was guilty. I assumed that because the state had charged him with a crime and they had been doing intense investigations, that he was guilty and there was going to be evidence of his guilt. So it wasn't.
Let me stop you right here for a second. Are you aware of Zach being arrested in a general sessions case?
What he had a lot of arrests in general sessions.
In March of 2014? Were you aware that he had been arrested and the victims were Tara Carrington and Amber Bray?
And what was the case about?
Statements they made. Valerie Trout was the affiant
And he was arrested for assault.
in general sessions court.
I'm sure I was aware of it at the time, but it doesn't come to mind right now.
All right, so
Yeah, you heard that right, Gwennon. You heard that right. And what's the most important, and I'm a little bit jaded to it because I saw a clip of that exact soundbite over on X and just already had my anger stewing for like a few hours after hearing it. What's the most interesting part to me, though, is she says that tidbit about, well, I already thought he was guilty because the state brought charges and they were doing the work. She says that right after saying the state's going to bring her DNA evidence, but they searched Zachary's home 3 times and they don't find any evidence of any like blood, anything that would indicate Holly was there, no sign of foul play. And I saw videos from the Trial and Error podcast. They have stuff on their Instagram page where they walk through the house. You see the floorboards are still torn up. Like they took samples of the flooring and everything. And here she is already not just going in there saying, well, obviously this is going to be another bad guy that I'm just representing and getting my $50K retainer. It's going to be my first death penalty case. But I'm also believing them when they tell me they're going to give me DNA evidence, even though she made us aware that when they told her that, it wasn't, we already have it. They said, we're going to get you DNA evidence. We just have to test it first. And yet that was still good enough for her. Why weren't you sitting there like, all right, well, we'll see what the results show. I'm not just going to take you at your word that you know that this stuff you're going to test is going to come back as a match to my client. Yes, first death penalty case. So, and then because of the discovery, that's how we get like this hybrid. Some of the billable hours start getting billed to the state of Tennessee. Yep, that's exactly right, Gwennon. And I'll get the Discord link. I'll drop it again. Give me 1 second. And oh my God, hey, random girl, good to see you. This case is a doozy.
you were being told search warrants.
There was going to be DNA evidence, but it wasn't until the fall after Matt Stowe had come on board that I think it was after Matt Stowe came on board that they gave me a hard drive. It was a 4 terabyte hard drive full of discovery, and they just handed it to me, and it was a mess. It had 4 files in it, file folders, and they didn't describe anything. It said binder 1 and then had massive PDF files in binder 1. And I think the binders went up to 10 or 12. It had audio tapes and videotapes. I didn't know whose voices these people were. I didn't know who was talking. I didn't know who was being interviewed. A lot of them were interviews that the Bobo family had done. And so I was lost. So for the first 6 months or so, I was lost in the case because they didn't give me the IRs, or they gave me some IRs, but they were mixed in. So there was no narrative that said, this is what happened. Someone came into the yard and took Holly from the carport. There was nothing like that. And I had to figure out, these binders were binders that the TBI had, and they had just scanned them from page 1 to page 500. I guess they were huge binders, page 500, and just scanned them in straight. No naming or labeling what things were, what reports were. And so for the first 6 months, I was lost and didn't even know what had happened. And so I just slowly was eating my way through all this discovery.
This was when General Stowe was the DA, or was this, who was the prosecutor during this time?
I think either Beth Boswell or General Stowe gave me this discovery. It was not provided by Jennifer Nichols.
When Mr. Simmons came on board, was there a division of assignments initially?
Initially, is the microphone not working? Initially, we were both just going through the discovery. We had a hard time even copying it. It took days to copy. So the disk was so slow. I had an external hard drive that we had copied this onto, because 4 terabytes at the time was really high storage termination or volume, and you couldn't find a lot of hard drives that were 4 terabytes. So I had gotten one disk that was 4 terabytes, but I'd gotten it at like Office Max, and it was really, really slow. So if you tried to search on the word, and a lot of these documents were not OCR'd, meaning they had not been converted from just a picture of the page that it was to searchable text. So you had to go in and read each of these documents. You couldn't do a search, but if I were doing a search on something, it would take minutes for the hard drive to come back. So at that point, I did some research, and I ordered online a special hard drive that was this big. So it's about 10 inches long and about 8 inches high. It had 4 hard drives in it, and it was 6 terabytes, but it was really fast hard drive. And we hired a computer expert to transfer the disk that I got from the state over onto this Pegasus hard drive.
And I'm going to hand you your.
I'm not gonna lie. It seems like having to do this tech curve took years off her life. Like, it really stressed her out, just having to figure out different hard drives, how to transfer files. That seemed to take the wind out of her.
Document, if you can please review.
All right, this being handed in motion for discovery in this case, which I'm sure council will mark it as exhibit 126.
Is that your motion?
So this is my motion that I filed March 27th, so early on.
Fairly standard motion.
Standard motion. I got one from a friend of mine that practices law. I rarely change the discovery motion.
Okay. And you felt like that covered what you were authorized to receive under Rule 16?
Yes, it should have been a broad discovery motion requesting any and all evidence that they had against Zach Adams regarding the murder, rape, and abduction of Holly Bobo.
Who were the co-defendants' attorneys?
Well, at that time, there were no co-defendants.
Okay. When did they come on?
I think when the case was re-indicted by Jennifer Nichols.
Okay.
They added charges, and they added co-defendants.
Who were the co-defendants added?
Okay, so Matt Maddox, which I did not know Matt Maddox, Paul Bruno, which I did know, they were for Dylan Adams, and then John Herbison and Fletcher Long, both of whom I knew were attorneys for Jason Autry.
Okay.
And I think that maybe somebody had tried to hire Paul Bruno. I think that maybe Jason Autry had tried to hire Paul Bruno, and they had actually had a discussion, which I'm not sure why there wasn't a conflict of interest there after they had a discussion, but they had a discussion. Jason did not hire Paul Bruno, and then Paul came on as appointed counsel for Dylan Adams.
Did co-defendants' attorneys ever have a joint defense representation agreement or?
We never had a written one, but in the beginning, we were all talking about how there was going to be a joint defense
What is that?
plan, meaning that everybody said they were not guilty. And by this time, Shane had already taken his life. So Luke Evans had been Shane's attorney. And so everybody gets together and says, we're all not guilty. We're going to work together to present a defense in this case and combat these charges.
At some point, did you tailor the rest of your practice to accommodate this case?
Yes,
How so?
I got off almost all of my other cases. All of my federal cases I got off of, and almost all of my state cases. I think I kept 1 or 2 state cases, but I got off of all the other ones. So I filed motions to withdraw so that I only had this one case to work on. I'm not sure that the other attorneys did that.
At what point in this process were you able to devote exclusively to this case?
Probably starting in about summer of 2015 or 2016.
After you got your discovery, what were your thoughts on the case?
Well, I just kept looking for the evidence against Zach, and there wasn't any evidence that they had. Zach had talked to people. Zach had made some statements, and there were reports that Zach had made some statements to people that were wild and crazy. Like, I'll do you like I did that bitch, but I'll tie you up like I tied up Holly Bobo. But there was no evidence of his involvement. And also at that time, I was not an expert in cell phone records and cell phone towers and which tower was hitting off of which phone. And I studied it,
Thank you,
I
Amy.
researched it, and I became a mini expert in cell phone records.
Well, look at the judge's face when she says she became a mini expert.
And I studied it, I researched it, and I became a mini expert in cell phone records.
Did
Uh,
you understood that there was Terry Dicus and Art Viveros and John Walker?
I think at that time, I didn't necessarily understand. So many people in the TBI had been involved in this case, and there were so many different agents that had done IRs. I'm not sure that I understood what Terry Dicus's role was in the beginning.
Do you remember when Dylan Adams got charged?
I think Dylan Adams got charged with the new indictment,
Okay.
the one in the spring of 2015.
Were you provided a video of statements he made?
At some point, we were provided with a video of statements that Dylan Adams had made at the TBI headquarters in Jackson.
And that was in September of 2014?
That sounds, I don't know if it was in September of 2014, but I can't remember when I got it.
Okay. You had the interview transcribed. Do you remember having it transcribed?
Yes, that was much later that we had the interview transcribed, when we were getting closer towards going to court, that we had the interview transcribed. Wow.
he must have pulled out the binder.
But I thought with this interview of Dylan Adams, we were going to be able to win the case, because Dylan's interview was terrible. It was very suggestive. So the investigators, the agents, just sat down and fed Dylan information as he's spitting it out. They're correcting him and they're feeding him information. And some of what he said just could not have been true. And I thought that we were going to be able to win the case by showing the inconsistencies in Dylan's statement.
But then I'm pretty sure, and we're going to watch trial one, but I'm pretty sure they don't call Dylan and they don't play that statement.
You can look at the transcript.
All right, the witness has been handed the interview of Dylan Adams, transcript from the interview of Dylan Adams, September 17th, 2014. At this stage, for this case.
Yes, this looks like the transcript of Dylan Adams.
I move to make it an exhibit.
Objections? Without objections, we make this transcript exhibit 127.
Was it your understanding that Dylan was going to be a testifying witness in this case?
Yes. Dylan, I thought it was more about December. It was after we had gotten the initial agreement, or we had agreed as a joint team that we were going to do a joint defense. And I remember sitting in the jury room in Decatur County Courthouse discussing this with the other attorneys, because Mike Scholl and Robert Paris were from Memphis.
All right, let's pause here, introduce those to the court. When did they come involved?
They became involved in spring of 2015, I think.
Okay. Why did they come into the picture?
Well, Fletcher Long had been tried for crimes and had lost his law license in Clarksville. And I think John Herbison had also lost his law license. And so we had two disbarred attorneys, or if they weren't disbarred, they were on probation and suspended. And so they couldn't represent Dylan. So we had Paul Bruno and Matt Maddox come on that spring. At the same time, they appointed Jason Autry attorneys that were Robert Paris and Mike Scholl.
Had you ever worked with either Mr. Scholl or Mr. Paris?
No, I did not know them.
Was it the still undefined defense agreement when they came on?
So Jim Simmons is a very quiet man. He's very subdued and quiet. Mike Scholl is very outspoken, and he's like, every time we would have a court hearing, he would go out and give a press conference. I didn't speak to the press at this time before all the time it was going through trial. I refused to speak to the press, but Mike
Shout out to
Scholl would
Classy
go
in the
out and give
chat.
statements. And so Mike and everybody was like, yes, we're going to all do a joint defense agreement. And then at some point, Paul Bruno and Matt Maddox kind of began to pull away. Even though we were going to do a joint defense agreement, we weren't having a lot of meetings, like a team meetings and stuff that you would think that we would have. We were having I don't remember having any team meetings with them where we got down and said, okay, let's look at this discovery. What did you think about this report? What did you think about this report? So we never had any of those type meetings. It was just in the jury room at Decatur County Courthouse.
I want to stop here and give. We have not only Classy in the building, but we also have the beautiful Love Amy E. I got to say the full names. We're going back to Classy Beats today because look what YouTube's doing with the names over here. So big shout out. Amy E got here early. Classy Beats came in here. Has apparently been a member for 16 months. Holy moly. Saying how time flies. Says, good morning, gang. Get those likes up. And then very generously just gifted you guys 10 gifts. So thank you for supporting the channel, Classy and Amy E. I want to say Classy Beats, but we're going to shrink it down. I'm going to get used to just saying Classy. So you guys know we've been on a marathon covering all of this stuff, but when I'm done doing like a long sprint, watching a trial like this, I retire for a week or two. And you can catch me always hanging out at Classy's channel and Amy E. So make sure you guys sub up. I'm going to drop their links to both their channels, but super generous, 10 gifted already. Thank you so much, guys.
By this time, had you gone to TBI offices to review physical discovery?
I think that happened in the spring of, I don't know when that happened.
Okay.
Matt Maddox and Paul Bruno were still part of the joint defense team when we went to TBI and began to look at the discovery. By this time, I had looked through the evidence enough to recognize that Terry Britt was a really good suspect in this case and seemed like the person that had committed the crime. And so when we went to go look at the discovery, I already had Terry Britt as an alternate defendant in this case.
Did the other attorneys curtail their practice?
I don't think so.
And what was your rate of pay that you billed?
I don't know, $60 an hour maybe. I was second chair, and second chair gets paid less than first chair on death penalty cases at the time. And so I think maybe I was making $60 an hour. It was much lower than what I normally would charge.
Are you able to bill your assistant's work as well?
No.
You brought on private detective.
Yes. Well, do you want to talk more about the viewing of the evidence at TBI?
We'll come back to it.
Okay.
Who did you hire for a
Lady.
background investigator?
Well, at first, Jim Simmons.
So this is the trial counsel, right? This is who at the original trial represented, made all the arguments, and there are something like 56 points of error in the petition for post-conviction relief, new trial for Zachary Adams. And a lot of those seem to relate to ineffective assistance of counsel. We've already heard testimony that she had no strategy. And we had the prosecutors get up there and say there was a clear strategy, that it was Terry Britt that did it. But we had what I thought was a very respectable, credible witness, Jerry Gonzalez, former Special Forces agent, USA attorney. And he gets up there and is like, I get into this case and they don't have anything organized. They don't have any idea what their strategy is. They don't know how to object, to the point where a paralegal kept telling Jennifer to object, but then she wouldn't know the legal basis. So I said, don't even object then, because you're going to piss this judge off. The trial judge was a different judge. and apparently was very adversarial. So don't go pissing the judge off. And now she's sitting up here on the stand trying to direct attorney Doug Bates, who I'm so impressed by. I think Doug Bates is a great, great attorney, and has been just a delight to watch and learn from for everything that we've watched over the last week. She's sitting up there trying to direct him. You didn't even have your own case together. Like, what are we doing? What are we doing?
Hired Danny Mulligan, and I think it's Brian Smith, to work on the case, because Danny, I knew Danny, I'd known Danny for years. He'd worked on other cases for me. Danny and Jim were very close, and Jim always hired Danny. Jim did a lot of death penalty cases, and he always hired Danny to do death penalty, his investigations.
All right, let's go to the TBI physical evidence meetings.
Okay.
How did they go?
It went very badly. So at this point, there were 500 items to view, and I don't know how many of them were about 500 items to view, and I don't know how many of them were at the TBI headquarters. But I, at this time, believing Zach was not guilty, because the evidence didn't show that Zach was guilty. The evidence was showing me that Terry Britt was guilty. And so at that time, I wanted to go in and see all the evidence. I really felt, I was a very enthusiastic attorney, and I really believed that we needed to look at every piece of evidence in a case before you try it. And that was just a given. And the other attorneys did not want to look at every piece of evidence. And Jennifer Nichols, who I think is very astute at figuring out dynamics between teams, Jennifer Nichols insisted that we start with number 1 and go with item number 1 all the way through item 500. And we go in number order. And we were all supposed to look at this. Well, the other 2 teams were getting irritated and frustrated with me. They actually took me, like I'm the child, they took me into one of the other TBI lab rooms, because we were in a giant room bigger than this courtroom with all the physical evidence. So they took me into another room and said, Jennifer, what are you doing? Why are you looking at all this evidence? This is a waste of our time. And I said, no, I want to see every piece of evidence. And they were like, why do we have to sit here and do this? So they were trying to tell me, so this case involved a lot of people trying to tell me how I should do the case and how attorneys would do the case. And it was against what I believed a good defense attorney would do.
You complained about this to Judge McGinley at a
Well,
motion.
first I complained to Jennifer Nichols.
How'd
I
that
said,
go?
guys, pick out the items that you would like to look at, and then we'll look at those first, and then you all can go, and I'll stay here for the rest of the week and look at all the 500 items. And Jennifer Nichols said, no, we have to go in number order. And I'd never had a case where the DA stood over you and looked at the evidence while you looked at the evidence. And she was standing there right next to us.
Just pair this with the subpoena issue for the ATM video that they didn't turn over. And now we're hearing that DA's breathing down her neck, specifically Jennifer Nichols, who is the prosecutor we watched for pretty much the whole stream yesterday. Drove all of our blood pressure up a wall. Wild, wild watch, wild testimony. Always a good time with the prosecutor on the stand. Breathing down your neck. And this is the same team that doesn't want to go and subpoena this surveillance footage that exculpates Zach Adams. Maybe it's hard to see who it is, but it lines up with, hey, we have the phones and we have an ATM receipt here. Now we also have a surveillance, which corroborates that we're tracking the phone location, and we also see the same truck, and they're at an ATM, and one of them has an ATM receipt, and the 3 of them said that they were together, Shane, Dylan, and Zach. Well, now you can conclude, you can make the solid inference that those phone devices were actually with the individuals attributed to owning those devices. That's why that surveillance footage is so important, whether it's blurry or not, because it's the same truck and it's in an ATM lane outside of the bank, when they also know that one of them has an ATM transaction receipt and their phones are putting them there. So it solidifies, it corroborates that they had their devices on them, which now we can infer that the path that we followed for the minutes before and the minutes after likely also on their person, same devices on their physical persons. Critical evidence that the state's just like, well, it's blurry. You can't tell what kind of car it is. We don't know if that's a silver Chevy Silverado. It's dicey, critical. And now we hear that they're breathing down her neck.
So if I said I wanted to see a pair of pants with a stain on them, then she knows.
And you know what? I'm sorry. If I had to have Jennifer Nichols breathing down my neck, I'd probably be drinking wine too. Like a little bit of grace here. I'm going to give a little bit of grace.
I think that that's important. So the other reason to not single out different items is because then the DA is going to get a hint as to what you think is important in the case and what you want to look at. So she said no. So we sit there and painfully go through, and the other teams are getting frustrated with me.
Can you approximate when in relation to Jason Autry's proffer?
This is well before Jason Autry's proffer.
Okay.
And well before, and this is before Dylan is going to testify and be a testifying witness for the state.
Okay, when was Dylan going to be a testifying witness for the state?
I don't remember when that happened, but when we were at TBI, we were all still supposed to be on a joint
I
defense.
see.
I say it in quotes because we really weren't
This is
working jointly.
crazy.
Did you present?
So what's happening here is they're giving her a hard time trying to look and evaluate all of the evidence, but this is still the time period where they're trying to leverage the death penalty and put a wedge between the defendants. So they have this joint defense strategy at this point in time. They're all saying we're all innocent. Well, why do you need to look at all of the evidence? That's a waste of time. Because they're going to go individually to Dylan Adams. They're going to go to Jason Autry. Shane had already killed himself because they took the immunity off the table for him when the information he gave about where to go find Holly's body didn't pan out because probably didn't actually know where to find it. And then Zach Adams. And they still want to be able to say, probably, we have DNA evidence. We have the cell phone data. We're going to say that it shows that this all happened really close to your home. They don't want the attorneys to be on notice that there's things that make it seem less risky to take it to trial. That way they can force a plea. And then they're going to use when Jason caves and agrees to proffer to get 8 years. Mr. Too Dangerous to Transport, suddenly given 8 years. He's going to be the key witness at trial because he's going to tell the jury, I helped her get rid of the body in exchange for his plea deal. This is how the sausage is made.
Your problems on discovery to Judge McGinley.
Yes, I went to court and presented the problems to Judge McGinley.
How'd that motion go?
Judge McGinley blew it off and said, well, they have a right to be there. They can be there while you look at the evidence. You know, usually there's a neutral person, somebody from a law enforcement agency that's making sure that you don't spit on the evidence and put your own DNA in it, mess up the evidence, but somebody that's neutral and that is not going to go back and report what you're doing to the other side. Judge McGinley poo-pooed my complaint.
Did the defense attorneys take up for you?
No.
Did they? All right. Did your relationship with the other defense attorneys improve or get worse over time?
Well, after this viewing of the evidence, and I've talked with the mitigation expert that we had hired on, a mitigation expert at this point.
Who's that?
Oh, now I can't remember her last name. Lee. You want to remind me?
If the witness could be passed exhibit 34, she could maybe just keep her behind it, and she might refer to others.
You just trying to recall his name?
Oh, we're going to
Her
go through
name.
the memo also, Your Honor.
Well, we included this.
You said
You
34.
are through with the transcript.
Yes, Your Honor.
What's the handed exhibit 34? You said, right?
Yes, Your Honor.
Lee Norton, yes. Lee Norton was a mitigating specialist psychologist that Jim always used in his death penalty cases. And Lee gave me some advice that I really held on to throughout this case. First of all, I was complaining to Lee that they didn't stand up, that everyone was attacking me, because when they pulled me aside at the TBI, all the defense attorneys were attacking me. Not so much Matt Maddox and Paul Bruno, but especially Mike Shull and Robert Paris were treating me like a child and fussing at me for being so picky about everything. And I called Lee Norton, and this is the first time in all the years that I had practiced law that I really felt that there was sexism going on, that the men in the case were discounting what I had to say and the information I had because I was female. And they were all very masculine, not so much Matt Maddox and Paul Bruno, but Mike Shull and Robert Paris were very masculine, man, we're going to do this cowboy type attorneys.
As you reflect on your services at this stage in your representation, do you feel you were competent?
At this point, I still felt I was competent.
You were diligent.
I was diligent. I was going to look through every piece of evidence. I was going to make notes and make sure that I knew what it was. And the things that I thought were important, I was trying not to look at extensively. And I was trying to throw them off a little bit by looking at some things that I thought were not important a little longer, just so that they didn't know what I was
This
interested
is the
in.
defense
So
attorney.
through 2015 through 2016, in a given week, how many hours would you work on the case?
I don't know, a lot,
40?
maybe.
Okay.
I'm not sure I billed 40 hours, but I didn't bill a lot of the time that I worked on it.
At this point, had you talked with Zach much?
I had never talked with Zach much. One of the problems with talking to Zach is Zach did not commit this crime. And he didn't have any information. You know, usually your client's done something and you'll say, well, tell me what happened. Tell me confidentially what really happened. We're going to sit down and go over this. And then you take their side of the story and you look at the evidence to try to see what proves or disproves this. Zach didn't do this and he didn't know anything about this. And so he didn't have much to provide.
All right, let's stop here. And there's two types of criminal defense lawyers, those who say, don't tell me anything, or tell me what really happened. Is that a fair?
Sure.
Which one are you?
Don't tell me anything. So usually it's don't tell me anything, because when you get in there and you're talking to your client initially, the first few times, the client will say, oh, I didn't do this. I didn't do this. So now they've told you a lie that's between you and the client. So usually I say, let's not talk about what happened. Let's get the discovery. And then I get the discovery and I go back to the client and say, look, this is what the discovery shows. The discovery has DNA placing you in the apartment, or, you know, whatever it is. And then I say, how are we going to explain this? Then I want them to tell me everything. But I try to not have them tell me everything before I get the discovery. Does that make sense?
Did you have those discussions with Zach that you just talked about? Review the discovery and say, hey, did you do it?
I'm not sure I did with Zach, because there wasn't anything, you know, Zach early on said, I don't know anything about this. And so I probably didn't have many discussions with Zach about what was going on. And Zach was a little meth high. You know, he was short sentences, up and walking around. He was still kind of, I think his brain was still kind of methy.
Okay.
And he was not easy to really sit down and work with. I would have been happy if he had been, let's sit down and go over this, but he wasn't really in that disposition state of mind.
Any idea how many times you met with Zach over the course of the case up to the beginning of the trial?
10.
At any time did he give you any pause for concern that he committed this crime?
No, never.
You created or received list of digital evidence.
What's been handed in a document? Here's the digital evidence. It's marked up though. Is it the markings accurate? Okay.
I'll ask that. Do you recognize whose handwriting this is?
This is my handwriting.
Okay. And what are we looking at?
I don't know, digital evidence in the master case file.
Is this something that the
provided to me in 2017?
okay? Is this what the state provided you? The typed?
Yes, and this is after Jason Autry, or around the time Jason Autry is going to flip and begin his lies about Zach.
And then there's a physical evidence list on the third page.
Yes,
What is that?
this is a list of evidence that we got showing what was where and saying where it was being kept. A lot of this evidence was being kept in West Tennessee, but they brought many, many pieces to Middle Tennessee for us to review. It's my memory.
And the handwriting throughout on that document,
Is not on my handwriting.
you know whose else handwriting it is?
It might have been Jim's daughter's handwriting. So my handwriting down at the bottom where it says Kevin, that's my handwriting. My handwriting is not at the top where it says Nash office, 6/15/16. So this must be when we went to go view the evidence at the TBI lab.
All right.
So 2 years in.
Are you-
And Simmons, I think that's Simmons' handwriting right there where it says Simmons on the page.
And are you confident these are documents that were prepared or worked with in your course of your work representing Mr. Adams?
Yes.
Your Honor, I move to enter them as the next number exhibit.
Yes. We're 128, correct? All right. Ms. Bates, the witness was handed exhibit 34, and we never.
We're going to go with that now.
So it's at 34. 128.
If you could look at, not that exhibit, exhibit 34, the memo from Dr. Norton. And go to page 4 at the bottom. Where it says ATM.
Yes.
How did you know the ATM, evidence from an ATM machine would be important?
Well, Zach did say what he had done that morning. And he said that Zach, Dylan, and Shane had all gotten into Dylan's truck and had driven down to Parsons. I think they got something at Sonic, and they went to the ATM to get some money because they were going to get some Xanax bars. And so they got money. Shane had been working at a job, and Shane had some money in his bank account. So they were going to go withdraw the money from Shane's bank account, and we're going to go buy some Xanax bars. So I knew that this video was going to be very, very important.
I believe she sort of tried about this video, but I think she's seeming like she's going to overplay how she tried to get this video. But the state was trying to hide it too, it seems.
Read in
So.
discovery where Joe Walker, Agent Walker, had subpoenaed Shane's bank records.
I'm sure I had.
And just so you know, guys, there is a John Walker and a Joe Walker. They're different people. So John Walker, that's Marshall Walker. The one they're talking about now is Joe.
Do you remember going over that with Zach?
I don't have a clear memory of that now.
Do you remember issuing a subpoena to CBNS Bank?
I think Jim Simmons was involved with that, and Brian Smith. Yes, I remember that they were going to get a subpoena for the bank.
And what came of it?
Well, so my memory is that the bank had changed ownership, and that when they had done the transition to the new owners, that they had the day that the money was withdrawn, but they didn't have the time of day. And so that information had been lost.
Did y'all ask for videos of it?
I think we were asking for videos, yes, because showing a video of when he drove through a bank teller window would be great alibi evidence in terms of what he had not done or what he had done that day and where he had been at certain times.
Did you received the video.
No, they said that they didn't have any video.
Had the state supplied you with the hard drive that had surveillance videos on it?
Well, now I know that allegedly they did, but at the time I did not know that they had supplied me with the video.
Did you
Look at the judge writing.
review Terry Dykas's notes of surveillance?
I think so. I'm not exactly sure what you're referring to.
The witness can be passed Exhibit 90.
States, just for a little clarification, I may have heard this name before. I believe the witness this time that Jim Simmons and Brian Smith were involved in something.
I can clarify. Who's Brian Smith?
Oh, do I have his name wrong? So Danny Mulligan had a team that he was employing, and it included Brian Smith was one of the investigators.
Okay.
And is his name right?
Oh my God.
Okay.
Okay. Can you review Exhibit?
Investigators.
Okay.
And is his name right? Okay.
Okay. Can you review Exhibit 90?
Yes, I see Exhibit 90.
And do you remember seeing that in your work?
I don't remember it.
Okay. You can now go to Exhibit 23.
Okay.
And do you remember this IR? Ms. Thompson, do you have a cell phone on? Do you have a cell phone on possibly that's causing that?
I think it was because I was too close to it.
Can we get rid of the second mic?
You see at the bottom third, the transactions for April 13th.
This courtroom has been fabulous with the sound. Compared to
Transactions for
other
April
things.
13th were as follows: $120 from the ATM at Community South Bank, $22 from Shell Service and Holiday, $10 from MAPCO in Parsons, $9.84 Shell Station in Parsons, $6.78 from Sonic in Parsons. A check of video recordings from the date is to be done when a player is obtained for the MAPCO and a BP video from 641. The other places were not covered by our videos. Do you remember seeing this?
I don't have a specific memory of it, but it sounds familiar.
Do you think this is important?
This is very important.
Why?
Well, I mean, it's got some potential alibi evidence for Zach. He doesn't list the times here, but I think it's important that he's saying that what Zach said had happened was being backed up by this IR.
Do you, on the Exhibit 128, it's just newly entered. Can you find any ATM video listed.
Uh-oh. I think the issue is it was like hidden in another name. Or maybe it was just abbreviated BP.
No, I don't see anything that says ATM video.
Did you ever pre-trial file simply a motion that says, we don't have this ATM video?
Is it on this report, the ATM video? I don't see it.
IR 2743 says $120 from ATM at Community South. Says the other places were not covered by our videos. How do you interpret that?
That there's no video.
Dr. Norton told you you need to get this.
Yes.
Did you ever bring it to the court's attention by just a simple motion to compel or bring the bank in to compel them to look a little harder?
No,
Why not?
I don't know. It was very important.
It's the best you can do.
Judge
Say,
is
I
writing.
don't know.
Yes. I don't know why not.
Judge is writing.
I guess I thought that it didn't exist. And I thought that we had searched, we had done due diligence. I thought we had done due diligence and it didn't exist.
I think this is really good for Zach because there's two ways the judge could, this is an issue. I cannot see that when we get to the end of this long extended hearing, because there's calendar dates in January to finish out these hearings, say end of January, he's got to make decisions on certain things. I do not see this judge thinking that this was not a critical piece of evidence and that by not showing it at trial, we could still have confidence in the jury's verdict. But now there's two pathways at issue here. This is ineffective assistance of counsel because it seems like she was aware that there was a transaction. So the judge could decide, well, you could have gone and tried to get this stuff yourself. Or he could say, you know what? You weren't able to pay your assistant. You didn't have the funds to pay for your investigator on a continuing basis. Your funds were limited. You did make some effort. And then this other shady stuff that we already heard about the state doing by opening up an investigation and taking out an administrative subpoena to sidestep and go look for this thing that they knew that the defense had been looking for. They go and get it on their own ahead of time and send an assistant all the way to Alabama to go pick it up. And just to say it's not important, it's not exculpatory now. So it's two pathways there for Zach.
At some point, you filed another motion. I'm going to hand you in the court a copy of.
But this is the record will mark it as exhibit 129. Motion question in the court for time certified.
Well, and can you review this motion?
Yes.
All right. And can you go to page 3 of 9?
Yes.
And paragraph 5, what is that? Can you read that to the court?
Any deal, promise, inducement, or benefit that the government has made or may make in the future to any witness the government intends to call as a witness in this case.
And you went on throughout. Is this a motion? Where did you receive this motion, the template?
I don't remember.
Okay. You're right.
I moved it in as 129.
That's right. Thank you. You were present in the fall of 2016 when there was a series of motions before the court. Do you remember that?
Yes.
And there was a motion to continue by Mr. Schultz.
Yes.
you remember what all motions you had before the court?
I don't remember.
Do you remember when trial was scheduled to start?
Easter?
And what was your takeaway from that motion hearing?
Well, I think the judge was very negative about everything that we wanted. I think that I just got the feeling that the judge wasn't going to rule in our favor on things.
At some point, you attempted to bring in Luke Evans.
Yes,
When was that?
that was in February, I think, of 2017.
Okay.
That was very disheartening.
What took place in between the motion hearing in the fall of 2016 and February of 2017?
Well, Jason then had flipped and had made up this whole story about he was with Zach when Zach shot Holly Bobo.
Mr. Scholl called you and talked to you about this.
Yes, he called. So I was downtown Nashville. They were having the little rally downtown Nashville for women. And I was in downtown Nashville with my family and my phone. And I got a call. I think I got a call from Jim Simmons. But then Jim, I can't remember how it went, if we did a three-way call, but I was in a Jack's Barbecue down on 2nd Avenue. And I went outside upstairs
Out to
to
Jack's
the
Barbecue,
balcony. It was cold.
Avenue.
And I went out to the balcony to try to get some quiet so I could hear what they were saying.
And Mr. Scholl told you what?
That Jason was going to flip.
And did he outline?
He basically outlined the story.
Now let's
Thank you,
put a
KLB.
pin right here. At this point in your representation of Mr. Adams, do you believe you are providing constitutionally effective counsel?
At this point, yes, but my heart sunk.
Okay. Why did your heart sink?
Well, because Dylan had already flipped. Jason was going to flip. And these guys were innocent. I just didn't understand why 3 guys or 2 other co-defendants that were innocent and had not committed this crime would flip to say that they did and put themselves somehow in this. It just stirred me to no end. It disturbed me to no end that his attorneys were having him do this. I felt at this point, I felt that the other attorneys did not really know the case. I had quit doing other work and I was doing this case only and was
I think this is
super
real.
absorbed in this case. I came down to Decatur County. I drove the roads that were in maps. I drove different roads. I went by different people's houses. I studied everything. I had been down here trying to get to know some of the people. I'd been involved with the family. I had completely immersed myself in this case. And the other attorneys were still doing other cases and weren't reading the evidence. They kept saying, well, why? I mean, he's guilty. Why doesn't he just plead? And they put in tremendous pressure on me to get Zach to plead guilty. I've never in my life had so much pressure put on me by other attorneys in the defense to have my client plead.
And don't forget, we had the testimony from Jerry Gonzalez saying that the judge at the trial judge, caught him in the hallway and hinted that he should, urged that he should take a plea to save his client's life. His client should take a plea to save his life before sentencing, right? So this is the same person that's going to be in charge ultimately of the final judgment, final sentencing call. And judge is saying your client should take a plea to save their life, hinting that they've already determined if the pathway is there to sentence your client to death, I'm going to do it before the conclusion of the proceedings.
This was the worst case that I've ever done, the most pressure that I had ever been under, and it was horrible. But I knew that Zach Adams did not kill that woman. He did not kidnap her, and he did not rape her. And I was going to stay in the case regardless of how they treated me, because I knew that justice needed to come forward.
You were in court in February.
Let me ask you a question. You just asked a question of this. At this stage, were you providing effective assistance of counsel in essence? Are you alleging that prior to this stage that she was not?
No.
So from here forward, is your IAC claim
The,
from Mr. Autry's
When they turn.
proffer. And the telephone call from Simmons and Shoal.
And this kind of makes sense because if the strategy was a joint defense and now the other two flip, now what do we do? Everything just goes chaotic and goes up in the air.
Informing Ms. Thompson on the scene.
well, let me clarify. There are points prior to this that lead up to trial that are ineffective, as alleged.
I'll let you point those out close.
Do you remember February 2017's motion hearing?
This is for Zach Adams or to have the judge recused?
Court's recusal.
Yes, I remember the court's recusal,
And did you have it transcribed?
probably. Because we appealed it.
All right, witness has been handed a transcript. I'll let you go and respond more. It is exhibit 130. That will be the objection to this transcript.
So it's at this point that Jim Simmons and I really severely parted ways.
Describe that.
Well, Jim Simmons did not want me to file a motion to recuse the judge
Why did you file it?
because the judge absolutely was biased in this case.
How is the judge treating you?
It's shortly after this, they tried to put me in jail. So I would say they were treating me terribly.
How are they trying to put you in jail?
Well, I had been going to the evidence reviews and I had been recording them. It was no secret. I had those little cameras that you used to put on everything. I've forgotten what they're called.
We heard testimony from Jennifer Nichols, the prosecutor, that thought this was highly, did you say unethical, immoral, maybe both? But did not say that it was illegal.
But a little sport camera that you could set down and film. It had a wide angle view. A lot of sports people use them and put them on their helmets and their bikes or their motorcycles. And I had one of these little cameras, and I wanted to go see, there were some items of evidence that were still in Jackson, Tennessee at the TBI headquarters there. And I wanted to go see these. None of the other attorneys wanted to go. Jim Simmons didn't want to go. I was the only one that went. And Jennifer Nichols was there, and we were opening up different items. And I had the video camera sitting there on the table, and it has a red light when it's on. It's on. I had been recording at the office, the TBI office in that summer in June when we went to the main TBI office in Nashville to look at the 500 items. And I had been recording there. Everybody knew I was recording. So Jennifer Nichols, at some point in the middle of this review, said, "Are you recording this?" And I answered honestly, yes. And so she blew a gasket. She had a fit. She went out and got the head of the TBI office there in
You
Jackson.
blew a gasket for like
Came
7
in and
hours
said, "How
yesterday.
dare you record this?" Well, first of all, Zach had a right to see this if he had wanted to see any of this material. And I needed to remember what was there if something came up. So she came in and said, "How dare you record this?" And the TBI head of the office said, "How dare you record this? We have all kinds of cases in here. You're not allowed to record in here."
I believe
Nobody
all
said
of
I was
this.
not allowed, and I wasn't doing it secretly either. And so I stopped recording. I think we kind of stopped the evidence review at that point. And we went back to Nashville, and Jennifer Nichols filed a motion saying that I had been surreptitiously recording things and that that she wanted me to be found guilty of this and to be put in jail. I think that's how I remember it.
And do you remember Mr. Scholl's conduct of this motion?
Oh, so we had this hearing back in the judge's chambers. He didn't have this hearing where the public could see. And he took us all back into chambers, and Jennifer Nichols spews out, she's just so hateful and mean. She just spews out this tirade about how I've been secretly recording everybody and how this is against the law and how I need to be disbarred for this. And I can't remember. There's a transcript of it, but she's just pouring out this poison. And Mike Scholl and Robert Parrish got really, really upset. And they began to say, well, were you recording me? Did you record me? And Jim Simmons took a step away from me. He was standing next to me. We were all standing up. He was standing next to me, and he took a step away from me and said, Your Honor, if they're trying to put her in jail, I think she needs counsel. Nobody ever said it's legal. It is legal. What I did was legal.
Did you ask them to point to the rule of professional conduct that says you can't record evidence to show your client a death penalty case?
Look, guys, look at the camera pan. This is comedy. This is very serious, but this is also comedy. Look at this camera pan.
Point to the rule of professional conduct that says you can't record evidence to show your client a death penalty case? Did you say?
You know, at this point, I was so beaten down. Now I'm getting beaten down. I was so beaten down.
Can you help the court with the timing of this?
Well, this is after Jason has flipped and the case is going to go to trial. Right now we still have an Easter deadline for trial. And everybody is turning on me. At this point, Jim Simmons and I are not working together at all. We are not communicating hardly, and we're not working together.
I'm going to ask you some personal questions now about your mental health.
Yes, my mental health was declining.
When did it start to turn?
Oh,
Well, it started to turn early on when Jennifer Nichols came into the case.
Look, I feel her on this. Think about how the chat yesterday when we watched Jennifer Nichols on the stand, the chat. We have Lil Montana in the chat saying, like, I had to take my BP medication just in case we get the same thing today. Yeah, I can relate. I think this is I can understand it.
So aggressive. Usually, even in criminal cases, I can be in the worst criminal case, but you talk to the DAs and they're polite to you outside of court. They're nice to you. You have nice chats, and nobody takes it personally. Jennifer Nichols was hateful to me at all times. And so I had gone to a doctor and said, it's really bothering me. I'm really getting depressed because this case is bothering me. First of all, the TBI had been coercing witnesses, I think. And the state
Nichols had the same concern.
Doing all kinds of wrong things. I've never in my life had a case where if I put my mind to it and I worked really hard, that I couldn't get a good outcome. And in this case, where I knew the facts were on my side, I could not get a good outcome. And I worked harder and harder and harder. And it just got worse and worse and worse.
How was your mental health?
I was suffering from depression, and I got some antidepressants, and they weren't enough. And I went back and I got more antidepressants. Now, I was having some anxiety also, but I never got anxiety medication because it can decrease your mental acuity. And I didn't want anything that was going to interfere with my mental acuity.
When was this?
This was the whole time. This is from 2015 on through the case.
When did it get increased?
It increased every time I saw the doctor. At some point, I was taking Zoloft and Wellbutrin, and I was taking so much Zoloft and Wellbutrin, it was over the FDA recommended dosage.
Did you ever tell Zach, my mental health is declining?
No, I never told him my mental health was declining.
Do you agree he was entitled to that information?
Probably.
Did you tell the court?
No.
Did you consider withdrawing at, say, when Jason Autry changed his proffer, or provided his proffer, January 2017?
I think the real turning point was when the judge didn't let Luke Evans be an attorney.
When was that?
That was in February, perhaps, of 2017, after Jason had turned. Luke Evans had from the Board of Professional Responsibility an all clear. They said it is not a conflict for you to represent Zach Adams, that Shane Austin had died, that there was nothing further that the state could do against Shane Austin, and there was no way that anything that Luke did in Zach Adams' case was going to affect Shane Austin's criminal outcome. And so they said, you may represent Zach Adams.
Why did you ask to bring Luke Evans?
Because Luke Evans is a dynamite attorney. He was like me. He fights for everything. He fights for innocence, and he was going to fight.
We should use that descriptor. He was like me. Although, you know what? She did try to fight to get this evidence. I do really think that she was trying to get evidence and the other attorneys just wanted their clients to plead because that's a heck of a lot easier. I mean, we heard that she ran up her $50,000 retainer, couldn't pay her assistant because the state wouldn't fund it. So I can totally imagine. I think there's truth behind the other attorneys just thinking, oh, my client wants to flip and take a plea for 8 years. That's actually not a bad deal if they're facing life. So be it. Good enough for me. But yeah, I don't know if we should be making this comparison if we're also making an ineffective assistance of counsel argument.
Fight this case and make it he was going to help me win this case. And there was a turning point for the judge because the judge had been saying, I've talked with the AOC, we're going to get you a third attorney because we had 2 attorneys. Simmons wasn't doing any work on the guilt innocence part. He was only doing the mitigation work at that point. I was the only one doing the guilt innocence. That had not been my choice, but that's something he decided he would do that would give the jury more credibility. He would be more credible if he didn't take part in a guilt innocence trial. And so the state had 4 attorneys that were working on it. And so Creed McKinley had said, the AOC is going to let you have another attorney. This is an extraordinary case. It's out of the ordinary. It's like no other. It's the biggest investigation in TBI history. It has so much information, and we're going to let you have a third attorney. And Creed McKinley had said this to me.
That's the judge, a trial judge.
On Jennifer Nichols.
Creed McKinley, trial judge.
And we had a telephone call. I usually recorded my telephone calls with my recording pen. I had a very nice, I still do have it, pen that will record as you write down. As you write things, it'll record what's being said. And so I almost always turned it on during telephone conferences with the judge, but I didn't on this occasion. And but my assistant, it was a call in, it was a large conference call. And I was in West Tennessee at a Cracker Barrel with Luke Evans and an investigator or 1 or 2 investigators. And we'd eaten breakfast, and then the judge said he wanted to have a conference call. And we went out, and the judge said something to the effect of, well, I talked with Jennifer Nichols about this. And so right then I knew something was wrong. He had been talking to Jennifer Nichols about this. And what they had decided is that Luke Evans, if he came onto this team, this case was never going to settle. I fully believe that she said, if you bring Luke Evans
Your
on.
Honor, to what Ms. Thompson fully believes might have been said. This is total speculation.
This is speculation.
It is, Your Honor.
Objection sustained.
So the judge said, I talked with Jennifer Nichols, and I'm not going to let Luke Evans come on. There's a conflict. And so at that point, we had a big hearing about it.
No, right. I can picture this happening, just saying. They think that they're going to have a rock star come in that's actually going to competently and, they're in a good headspace, be able to take the evidence that, oh no, she's been recording it. She hasn't just been limited to what we hover over her shoulder and she can look at real quick. And we're going to get someone competent, even though she's dealing with some stress in her life. She isn't in the right headspace. And then Jennifer Nichols has a conversation with the judge, and the judge is like, nope.
This is speculation.
It is, Your Honor.
Objection sustained.
So the judge said, I talked with Jennifer Nichols, and I'm not going to let Luke Evans come on. There's a conflict. And so at that point, we had a big hearing about the conflict. The Board of Professional Responsibility, which is the board that decides whether or not there's a conflict, said there's no conflict. And the judge still refused to let Luke Evans come on to the case.
Did you feel you needed another attorney?
Wow.
I needed another attorney. I tried to find other attorneys that would come on to this case and try this case with me.
How many other attorneys did you try to find?
Multiple.
What did you do?
I called people that I knew were death penalty qualified, and I called people that I knew were good, hard fighters and could take a case to trial, try it to the end, and get a good outcome. And so 2 attorneys that I know that I called that spring or that winter, I called Jody Bell, who's an excellent attorney in Nashville, who's just been appointed judge. And I cried on the phone with Jody, and I begged her to please come do this case with me and replace Jim Simmons.
Why were you crying?
Because I was so exhausted and so worn out from all this. And she said no. She said, Jennifer, I've gotten out of death penalty and I cannot do another death penalty case. And I called Kim Hottie, who is an excellent attorney in Nashville. And she does excellent work. And I said, will you please come on this case with me?
The last name
And then I
Hottie?
talked to several other attorneys. And I think word got back to Jim that I was talking to attorneys trying to get people to come onto the case. But nobody would come, nobody of quality attorney skills that I thought could really try a case would come onto the case with me.
After the February hearing date, the April 3rd date, was it moved?
Yes,
And it was set for when?
July.
All right.
And at this point, after Jason Autry changed his story, I went back. He now is talking about a white truck. So the Adams family had a lot of cars available. They were on and off working and on and off available, but they had a lot of cars, trucks, really. And so Zach had been driving a black truck, a little kind of beater truck, and Dylan had a nice gray, I don't know if it's an F-150, but it was a nice gray full-size pickup truck. And so Jason Autry now says it's a white truck, which I knew that the white truck was not available to Zach at that time because he had run through the fields, gotten arrested at the Natchez Trace, and his grandfather had taken the truck from him. So Zach did not have transportation at that time. And so I knew that these were not available. And so when Jason Autry says it's a white truck, I start from beginning then. He has a whole new story. Dylan Adams' story was that they raped her at the house and he walked in and they were raping her and they forced him to anally rape her. And Dylan's story was so incredible. It was unbelievable. Jason now has a story that starts at the Tennessee River. Jason has seen the discovery and he has crafted a
I'm
story.
going to object to her speculating about what people have seen. She has absolutely no proof of that.
I do have proof of that.
Do
He
you have,
testified.
Hold on. So all she said was that he saw discovery. He presumably, if he did not get a discovery packet, then that's a problem of the state. That should not be speculation. It should be indisputable that a co-defendant that is giving a proffer and has agreed to cooperate should have been given a discovery packet. So it should not be speculation that someone has seen discovery. She didn't specify that he saw a specific piece and looked at it. But maybe they'll mince hairs here.
The objection is sustained to the way the witness was answering, so I'll let you rephrase or ask some questions.
what makes you say Jason Autry had the discovery?
Well, because he was giving
Had the
Rita
discovery.
Austin and Jimmy Austin he was showing them pieces of his discovery, printed material that he had.
How does she know this, Ron? Is it based on hearsay? Did she witness it? Again, it's speculation.
I did research.
Speculation is just sustained.
Jason Autry testified at trial that he had some of the discovery.
This is so desperate because the only explanation otherwise would be that it's not that the judge has to sustain this. It's the fact that she's objecting on this basis. When the only other alternative would be, you don't know that they have discovery. The only reason he wouldn't have discovery is because we didn't turn it over.
In his cell.
Did you see Mr. Scholl's motion to continue in August of 2016?
Yes, I'm sure I did.
What is the pass? Exhibit 123B. Can you review this motion?
Francis, it's a 12-page motion.
Yes.
You got some specific you want to
Page
go through?
3.
It's already been authenticated, entered.
Can you read page 3, Ms. Thompson?
Drew Carey Bates is hilarious.
You see where Mr. Scholl says where they meet,
Yes,
and Mr. Scholl provides discovery to his client.
yes,
Now, did you bring that motion out to the jury at any time?
no.
Right.
I should have.
After Mr. Autry's plea, and you said that we're talking about the truck, the white truck.
The white truck.
You then received in discovery a recorded conversation between Brent Booth and Victor Dinsmore.
Much later.
Okay. And you had it transcribed.
Yes,
Why did you have it transcribed?
because it was so significant.
What made it significant in your opinion?
Brent Booth was absolutely telling Victor Dinsmore how to testify. Victor Dinsmore had denied that the white truck was parked in his garage, his shop. And throughout the interview then, Brent Booth continually says, this is what Jason's going to testify to at trial. And so Victor Dinsmore then changes his story and says, yes, now he remembers it. It was a terrible example. It was a perfect example.
Your Honor, I'm going to object to her characterization of what witnesses intended. The jury heard all of this proof, and Ms. Thompson has not been offered as an expert for the
Okay,
court.
you measured this.
Thank you.
Her characterization is
Your Honor, if I respectfully submit this evidence, her opinion of the evidence and her failure to bring it in is important.
failure to bring it in, I understand. Significance, okay, but not her continued
I understand that.
characterization.
I understand that.
All right, so objection sustained.
Okay.
You can rephrase the question.
All right. In your opinion, it was important.
It was very important because it showed,
It,
it was very important.
Okay. and any,
Witness has now been handed a transcript of the Brent Booth. It says call with Victor Dinsmore.
what it says, Paul.
We'll mark for identification at this stage. 31.
Is this a transcript from the May 18th, 2017?
Yes.
And do you remember it was a phone call or was it an in-person meeting?
I know Brent Booth went up there to meet with them. So at one point, something was in person.
Okay. And who is Denise Parker Gonzalez?
She's a court reporter.
She verified it at the end.
Yes.
Into it.
Objection to this transcript.
No, sir.
It's exhibit 130. But let's do clarify so there's no confusion. This is the interaction between Brent Booth and Victor Dinsmore. It's already been entered as a recording.
Yes, sir.
We could figure out which exhibit number that is, and I'll reference it for the record.
103 is the first meeting.
All right, court's in agreement after looking at the numbers, exhibit 58. So this exhibit 131 is a transcript of the audio interview. This marked as exhibit 58. All right, thank you, Mr. President.
Did you, now we're in spring, they find a 32 revolver. The state finds a 32 revolver, remember that?
Yes.
And did you remember the prior statements of other people about possible weapons?
To some degree.
What was your understanding of prior statements regarding weapons?
Well, my memory is that Jason Autry had said that the revolver was much bigger caliber.
You know what he said?
Maybe he said it was a 36.
Okay. Do you remember reviewing IRs of his proffer?
Yes.
Do you remember what Victor Dinsmore said the gun was initially that he had interactions with Shane Austin in a recorded conversation with Dennis Benjamin?
I think he said that it was a bigger caliber weapon also.
Do you remember the recorded conversation between Victor Dinsmore and Dennis Benjamin?
Not specifically.
So Dinsmore and Benjamin are talking.
Do you remember if Mr. Dinsmore referencing a 32 revolver?
No, he didn't reference a 32 revolver. Maybe he said that he had thrown one in a pond.
Okay.
At some point, I know that Victor Dinsmore said that he had had a 32 revolver that did not shoot, that would not fire right. And so he threw it into a pond at his cousin's house, I think.
Do you
What?
did you have a strategy leading up to the trial now, May 2017?
Not really. I was still trying to go through all the evidence and put everything together because the discovery was given to me in such a disorganized fashion. And I, being hesitant to really change anything that the state had given me and reorganize it, had not reorganized the discovery. And because it was such a large terabyte and I had to spend so much, I spent several $1,000s buying the hard drive, the big hard drive that would spin really fast. I didn't have enough space to copy it onto another hard drive and then manipulate it. So it was still in the disorganized manner that the state had provided.
At some point, Jerry Gonzalez comes on the case?
Yes.
When?
That spring,
Why?
I begged Jerry Gonzalez and he said, okay.
Jury selection began in July.
Was it July or April? I can't remember, but jury selection began well before trial.
And who performed voir dire?
I did most of the voir dire. I did most of the beginning voir dire. And then at some point, the judge had yelled at me so much, I refused to get up and do anymore. And I made Jim get up and do it. The judge, one of the witnesses was crying. And I said, I'd like the record. One of the potential jurors was crying. She was on the stand and she was so bothered by the taking of Holly Bobo, she began to cry. And I said, I'd like the record to reflect that the juror is crying. And the judge snapped at me and said, I'm sitting right here next to her. Her voice is cracking, something like her voice is cracking, but she is not crying. She was crying. And he snapped at me so much. I just, at that point, I gave up and I didn't want to do any more voir dire.
So we just don't do the rest of voir dire.
How would you assess your mental health at this point?
And at one point, Jim Simmons wasn't even there for part of the voir dire. He had another case in another county and the judge insisted we go on without him. So at some point, Zach had only one attorney present. My mental health was declining.
Did you consider withdrawing at this point?
I didn't because I felt that because of the mess with Luke Evans and Luke being so eager to try the case and to really work on the case tough, I felt that if I withdrew, that the judge was just going to point somebody that he knew that was going to just take this case and plead it out. Because Jim Simmons had tried very hard to get Zach Adams to plead guilty. And he had come to me and said, on one occasion, he said, I've talked with Zach. He's ready to plead guilty.
Was Jim working on guilt innocence?
No, he was not working on guilt innocence.
And did Mr. Simmons file a motion to withdraw?
Well, Zach, after that, Zach told him he wanted him to withdraw. And Jim Simmons filed a motion to withdraw under seal where he said something to the effect that he believed the client was guilty and that withdrawing in the case would be detrimental. I couldn't believe that his affidavit said he thought that the client, something about the client's guilt or that evidence was overwhelming and that it would be detrimental to the client under the ABA standards
To go to trial.
withdraw as attorney of record, something like that. And the judge didn't let him withdraw. And the judge should have had him withdraw.
Your office then filed a motion to continue prior to the September date.
Yes.
And what was the purpose of that motion?
I was not ready to go to trial. The state had given us all the IRs. So I can't remember at what point the state gave us all the IRs, but they've never given us all the IRs with the materials attached to them. And the state had dumped on me all these hundreds of IRs and the materials attached to them. And so I had gone back and I was chasing butterflies at this point. I had gone back and I was reading the IRs. They'd given us a witness list of 200 something witnesses that they said would testify. And these people had names I didn't even recognize. And I could sit down and search in the discovery and not find their names because it was not OCR. And so we were desperately trying to figure out who these witnesses were going to be.
OCR is like sometimes when you scan a PDF, some applications will automatically make it so you can search on page or like copy and select and highlight different terms. OCR is the functionality that lets you, I forget what it actually stands for, but it lets the words on a document be highlightable, selectable, searchable.
So instead of doing my witness prep like I should have done,
So she's saying she can't keyword search this dump of documents.
down and thought about each witness and what I was going to bring in and what evidence I was going to put in, how I was going to get it in, how I was going to cross-examine them. I was out looking at these new materials. They gave us lab reports shortly before trial.
Thanks, Matt.
So all these materials were fresh to me and I was desperately trying to digest them.
And I've handed you the motion to continue. Is this your
It
motion?
looks like it.
And who argued this motion?
I don't remember.
And you attached the various complaints you had about discovery in an affidavit.
It looks like it.
Your Honor, I'd like to make this the next numbered exhibit.
All right, this is Zachary Adams, motion to continue the trial. That August the 8th of 17,
Yes, Your Honor.
and March of June 132.
And the motion was denied.
Yes.
Were you ready for the trial?
No. I still thought up until the day of trial, I still thought we were going to ask for another continuance. And I was hoping we were going to be granted an additional continuance.
At this time, had you communicated to Zach that you did not feel prepared?
No.
Did you communicate to him that your mental health was declining?
No.
Wasn't Nichols on the stand yesterday, like talking about how continuances are so normal and they're granted all the time? I wonder if they like urged the judge, because we heard that the judge based its decision to not allow Luke Evans to join the case on a conversation he had with Nichols that did not sound like a proceeding, an open court proceeding that all parties were allowed to be present for. But I can imagine Nichols being like, don't continue, don't give a continuance, don't give a continuance, based on everything else that I'm hearing so far. And yet yesterday she told us it's so normal to continue and stay and get extensions.
Did you
So
communicate
it sounds like
to the
projection
court
yesterday, like getting ahead of it.
there still are these videos of an ATM that nobody has seemed to have found?
Probably not, because at that point I thought that the videos didn't exist. They had converted to a new company and that the system had been wiped out.
Had you talked at this point to U.S. Marshal John Walker?
Yes, I had. I
When
think.
did you talk with him?
I don't remember.
Do you remember meeting with him during the trial?
Yes. Well, I have a vague memory of it.
Okay. Had you met with him before trial began?
I'm not sure I had met with him before trial began.
What was your understanding of Marshal Walker's qualifications?
Well, he was the one that did cell phone tracking for the Marshal Service. So when somebody would disappear, they'd run off and he couldn't find them and they had a federal case. He would go in and he had secret methods, which he wasn't going to disclose. He would go in, search their phone and figure out where they were. He could do it kind of by figuring out what road they were on or what area they're most likely to be in. And he had said made a report that said that Holly was most likely going to be found above north of the cell phone tower where she was found. She was found north of the cell phone tower. And he said she most likely had been in that area.
Do you remember seeing, I'm going to project exhibit 5 on the screen behind you. Do you remember seeing this map of John Walker's?
I think so.
All right. Do you remember discussing it with John Walker before his testimony?
I don't have a clear memory of it, no.
Were you drinking alcohol when you met with Marshall Walker?
I don't think so, but I can't say for sure.
Did you drink alcohol the nights after court?
No, I didn't have any alcohol during trial. I don't think so.
Oh, I mean,
What was your understanding of the significance of determining the route Marshall Walker surmised Miss Bobo's body and cell phone went on?
Well, he had come up with streets, and I think he had worked with Terry Dicus and AT&T, and they had come up with streets that they thought was most likely that Holly had been taken on and driven, and that her phone had stopped in an area where her body was eventually found, but her phone had pinged in that area.
You remember what time?
What?
You remember what time
eating
the
Tic
phone
Tacs.
was stagnant?
About 8:30, but I don't have a clear memory.
And I don't believe we have printed exhibit 5. Could the witness be passed exhibit? We have it.
And remember, Amy Wyrick, who is the lead handling this petition, the one that, like, see, everyone says yells, I agree, yells when she's questioning somebody on the stand. Amy Wyrick gave us a whole speech about Jennifer Thompson's one of the most decorated, credible attorneys. She's amazing. She's the bee's knees.
4, 6.
Is it open?
Oh.
You see it?
Yes.
Okay. Now, Ms. Thompson, do you understand the significance of the direction of travel from the Swan Johnson Road being clockwise up to the no activity where her remains were found?
I think I did.
What was it?
Well, that she was traveling north and a little west of her home, and that, and I drove those roads myself, and that she was not where Zach Adams' phone was.
You remember, did you believe there was significance in her death occurring between 8:26 and 8:56 where her remains were found?
Yes, I believe there was significance there.
In your opinion, what was the significance?
That she had been taken there, whatever happened to her had happened there, and that she was killed there and left there. And that then the person that took her, Terry Britt, as he was driving back, he was throwing things out of his car window. He drove back a different way, and he was throwing things out of his car window that had belonged to Holly.
And the last ping of Holly's phone was at 9:25 where the lunchbox and other things were found. Do you remember that?
Yes.
Did you understand the importance of qualifying Mr. Walker, Marshall Walker, as an expert?
Yes. I mean, I thought it was important that he testified to that.
And what were the words you attempted to qualify him as?
I don't remember.
Remember attempting to qualify him?
Objection, Your Honor, deleted.
All right, objection sustained.
I remember we tried to get him.
All right, hold on. The question that was asked was objected to, sustained. So we're asking another question.
I remember trying to ask him. I'm sorry.
This is hilarious because we heard from Jerry that she had trouble stating a legal basis for objections. And now she's also not understanding, even though she's a defense attorney, that she can't keep trying to respond after an objection was raised and then it was further sustained. So just kind of proving Jerry Gonzalez's credibility.
Ask you a question. If the question was asked, the objection was sustained.
What do you
I'm
remember?
allowed to answer that question. You can ask another question.
What do you remember?
Look at the judge.
I remember trying to have him testify about these cell phone records and not being able to get his testimony in.
Did you ask Judge McGinley to tender him as a tracking 2G expert?
Probably not.
Objection, Your Honor, to the meeting.
All right, I'm gonna allow this question. Objection.
Did you?
Probably not.
Why not?
I don't know. Maybe I didn't understand that that's what his expertise was in, is tracking 2G phones.
Did you go over with Marshall Walker his qualifications?
I think I did.
Did you make a proffer of evidence?
Probably did not.
At the site where Marshall Walker said there was no activity, there was a .380 casing from a pistol round found.
Okay.
Do you remember that?
Yes, I remember that. I don't remember that was from a pistol. I remember it was a .380 round found there.
And again, Your Honor, for the record, it was a casing, not a round.
Casing. Correct. Apologize. Do you understand what a casing is?
It's the shell that's over the bullet that in a automatic spits out.
Did you, at the time of trial, understand what the diameter of a .380 bullet is?
No.
Did you think it was important?
Yes.
What did you do to find the diameter?
Well, I had some other people on the case with me. David Hopkins knew a lot about guns, and I was listening to what David said.
Did anybody in your team suggest scientific ways to measure these rounds?
Yes, well, we had some discussion about whether or not a 32 could make the hole in Holly's head. And I think we looked for an expert. We're not able to find somebody that would say a 32 would not make a hole that big in Holly's head.
You remember?
So at trial, the state puts on a witness that says it could be, and then there's nobody that counters this point at trial.
For Dr. Ross's testimony.
Vaguely.
Says it anything, you remember 0.36 or below?
Yes.
Were you aware that the .380 was below in size 0.36?
No.
You were present when General Nichols, at her closing argument, told the jury 0.38 is excluded.
I was present. Yes.
You did not object.
No, I did not object.
Is it your understanding that a prosecutor can misstate evidence to a jury?
No, they cannot misstate evidence.
If they do, what do you do as defense?
Hey,
You
Chuck.
object, saying they're mischaracterizing evidence from trial.
Did you object?
I didn't understand the bullets enough to know that I should have objected. So no, I did not object.
Do you understand the significance
Look at the judge writing.
a casing next to the remains?
Yes.
What is the significance?
The significance is that's
Not there.
most likely the bullet that killed Holly Bobo is right there next to her remains.
The casing. Look at the judge's face.
You never put Dylan Adams' interview into evidence.
No, I did not.
Oh boy, yep.
Your Honor, if the court would indulge to seal the portion of the
Oh, they're
next
kicking
bit
us
of
out.
testimony.
They're kicking us out.
All right, it's a good time to take a break then.
Okay.
All right, ladies and gentlemen, Mr. Bates has alluded to the fact that we're going to address, put your board down so he's spoken behind you can see. Mr. Bates will be asking questions about the testimony that was previously sealed by other judges, and this court's going to honor that sealing. So I'm going to ask that you step outside the courtroom for this next bit of questioning. When that is completed, back in the court. So we're gonna recess for 15 minutes. Also, the cameras will have to be off. There's no microphones. So we're gonna recess for 15 minutes.
All right.
So we're gonna skip this. We've heard this have to be like when they talked about it with other witnesses, they kicked us out as well. When I looked at the court documents on TN courts, there's like a counter that's like how many transcript volumes and sealed. And sealed just had the number 1 next to it. So I'm wondering if this is the only thing, at the trial time period that was sealed, or if that means what sealed exhibits were put forth in the file to transfer for appeal. But yeah, apparently this is the only thing. This might be the only thing that's sealed. So, and the interesting part, after watching the 2020 episode yesterday and a little bit of the podcast, I think the state is in a bind because, and it's really been telling the things that Wyrick seems to freak out about. I think they have Jason Autry as a key witness at trial that's saying, look, we take Holly and Zach says, hey, I need you to help me move a body. They get into this pickup truck. They drive off to this wooded area near the bridge where there's the boom, boom, boom. They have her body in a blanket in the back of the pickup bed. And they put her out in the wooded area. And Jason Autry's testimony is that he sees a foot moving. And he's like, hey, she's not dead. And that Zach Adams goes to the back of the pickup, gets a firearm, shoots Holly. The boom, he says he sees all the birds fly away from the bridge. And it was only 1 shot, but the boom is the reverberations, the echoes from the structure. But then they pick up the body in the blanket and put it back in the truck, go somewhere else, and then dump the body there. And I think that's, we have the cell phone data that's an issue that doesn't really line up with what the defense is aware of now and failed to present at trial. But we have an issue because why is the shell casing in one place if Jason's saying we went to 2 different locations? And now the issue is, what is the state going to do? The state has the cell phone data and more competent counsel. If you do get a new trial, how's the state going to reconcile that with the prior testimony of Jason Autry? And then you didn't want to call Dylan because Dylan's a bad witness. Are you going to try to not call Jason? Because I don't think this defense attorney is going to let certain things fly if there's a new trial. I don't think we're going to play that game where you can just finagle the bagel. So I think the state's in a real bind because their 2 most critical pieces of evidence, or something that did not come in as evidence, conflict with each other. And if a new trial is granted, I don't see how they're going to make it fit, how they're going to make it work. So, but yeah, all of this stuff with Dylan's interview being sealed, I think a good portion of that is because there's probably a lot of inconsistencies in there, things that don't look good. And the state requested to seal it, and judge obliged that request. Trial judge, Creed McKinley. Okay, looks like they come back like here. Also, I tried to catch KLB in the chat because she said she was heading out, but I want to read this out loud. KLB said they were popping in to join with us. Said, good morning. I watched this mess on Friday, so I'll pass for today. See you all tomorrow morning for day 1 of the trial rewatch. So KLB has already taken off to enjoy her Sunday. But again, guys, we will be gathering tomorrow morning. We'll be doing a trial watch, even though it's going back in time. We'll treat it like it's a live trial, go through it. It's going to be a good time. So hope you guys can join us. And thank you in retrospect here, KLB.
Your Honor, I have the transcript of the proceedings for the witness.
All right.
We'll be referring to it.
Transcript's been passed up. While that's happening, I want to address something relative to an application of the rules of evidence. The court's interpretation of 804 and the unavailability of the witness, the requirement for cross-examination is when the state would attempt to introduce a statement against its source. In this case, not the defense.
Correct.
So I'm not sure how that, but I'll give you an opportunity to respond if you wish.
Well, I'll defer to Your Honor's more recent research than mine, but the state's position is consistent that it wouldn't qualify as a statement against interest. It would have to meet both of those prongs, and that statement was self-serving and was not a statement against interest.
That's a part of that rule as well, but there potentially were parts of that interview that could be taken as statements against interest. And the point of this was that you never attempted to do that.
And I'm gonna clarify that with the witness as well.
Staying off our
It's not gonna be,
issue. All right.
Ms. Thompson, do you believe any part of Dylan Adams' September 2014 statements were true regarding who raped, abducted, and killed Holly Bobo?
Well, they weren't made in September 2014, right?
The recorded statement.
The recorded statement was made back in early January or February or so of 2014.
Jeff Jackson, Brent Booth interview.
Yes. Do I believe it was what?
True.
No, none of it was true.
could you have asserted a video if the statements were not asserted for the truth of the matter?
Yes, because I'm not putting it in to prove that what he saw was true and that Holly was at Zach's house. I would be putting it in to show that he said the words.
Was there a connection to the future proof in this case?
Yes, because now Jason Autry was saying words that were going to get Jason out of trouble.
Did you ever
Cross-examine the TBI officers and ask this question: when did you realize Dylan Adams' statement was not true?
No,
Did you ask the jury how they would feel awaiting the death penalty on a statement that wasn't true?
no,
Do you think it was
Relevant for why Mr. Autry engaged his proffer in 2017.
yes. I think Mr. Autry decided he could come up with a better story than Dylan.
Transcript, page 1624, and it's small print. Hopefully you can.
Oh my.
I'm with it. I agree with her. I think that's probably what happened. They realized Autry could come up with a better story than
Can you see the
Dylan.
page numbers?
Barely.
Like, I'm all the way on board with that being what happened. Hello, Broken Baker. How are you?
Okay, which page did you say?
Start with 1,570.
Oh, 15.
1,570.
I feel like Broken Baker and I like to meet up for trials with like ridiculous alternative suspects, third-party culprits that the state is just like, nope, don't look at the Waffle House. Don't look at the neighborhood sex offender that has an MO for taking people into the woods and doing what he does. Don't do that. Don't look that way. Make sure you guys check out Broken Baker. Good to see you.
1570.
Hang on. Is that at the end of a volume?
Should be the beginning of volume 38.
Okay.
Or volume 11, day 6. May I approach you, Honor?
I think I'm here. 1570. Yes.
Okay. And who is being the examined witness?
Brent Booth.
And who is in charge of cross-examination?
I was.
And now, can you go to the end of his direct on page 1,624?
Yes.
Question by General Hagerman: was there pressure to solve this case? Answer: self-imposed. Yeah, there's pressure. That's my friends and neighbor. You don't get in this line of work for the money. I don't do what I do for the money. I do what I do because I love people. I fix things. I am a hands-on kind of guy. Take charge and fix things. What's solving this case mean? Does it mean just picking somebody? No, because there's all this pressure being self-imposed. No, I would never do that. We never would do something like that. We pride ourselves on doing the right
Is
thing.
there a question for Ms. Thompson here?
Yes, yes.
Okay.
If I can get to it. We pride ourselves on doing the right thing and always the right way. We make mistakes in this one, yeah. One I'll take with me the rest of my life. That's all, excuse me. But I got the right person. I didn't charge the wrong. You objected, line 23. Objection, Your Honor. I object. We're giving opinion testimony right now. I object to that. Then General Hagerman, I think that's enough. I'm not going to ask any further. Thank you, Agent Booth. And the court said cross. All right. Do you remember this part of the trial?
Yes.
Do you believe Agent Booth opened the door to whether he did things the right way?
Yes.
At the time, you had the recording of Agent Booth and Victor Dinsmore just several months before, correct?
Yes.
You did not hit him with that on cross-examination, did you?
No, I didn't.
For the
You
judge.
did not hit him with the Dylan Adams interview that he could have authenticated because he was there.
No, I didn't.
You agree he could have authenticated it?
Yes.
You could have gone through Jeff Jackson's behavior against Dylan to get a statement the state said they don't believe.
Yes.
Why not?
I don't know. I think I was overwhelmed at that point. I think that I didn't,
Judge.
we didn't know who was coming to testify. I should have also in advance, not just the night before, but in advance should have sat down and gone over these things and really thought out how I could get this material in. I don't know why I didn't do it. I can't explain it.
Do you think that was competent counsel?
No, I think I should have put it in. I think that the fact that the TBI was willing to go with one lie when it really didn't meet the facts, and then they were willing to go with Jason Autry's lie, which didn't meet the facts, would have been telling.
The jury never heard any of the Dylan stuff, did they?
No.
They had no idea there was a 4-hour interview that the state traveled on for how many years?
2014, 15, 16, so 3 years.
You didn't ask Agent Booth if he felt he coerced Victor Dinsmore, did you?
No, I did not.
Did you ask Agent Booth whether Victor Dinsmore told you what kind of gun it was?
No, I did not.
You're tapping it.
You
Crazy.
Do you
Hey, Ruth.
understand the importance of the timeline of that morning as it relates to a window for a white truck to be hidden at Victor Dinsmore's?
Yes.
What is it?
Well, it's going to take them 30 minutes to get back to from the river to Shane Austin's house
On what alleged route?
on really any route, unless it was the interstate. And Jason said they didn't take the interstate.
What was the importance of not taking the interstate?
Well, because they didn't want somebody to see the dead body in the back.
If they took the interstate, what would the significance be?
Well, they would have gotten back faster. They might have gotten back in less than 30 minutes.
Would they have had a body in the back?
Yes.
You think they would have driven the interstate with
Objection,
the
Your Honor,
body?
to the speculation.
Fair enough.
Objection sustained.
Did you had your investigator run the routes from the alleged spot Zach and Jason were at the river?
Yes.
And do you remember the belief that there was enough time to get from the river along Autry's route back to where they were at Austin's house at the time frame they provided?
Before 11 o'clock,
Yes, ma'am.
because Jason had to go eat
Yes.
lunch with his girlfriend at 11. I don't think there was enough time. No.
What route do you think they actually took?
Well, they didn't go. There's no real route. They didn't do it.
Do you understand at some point, do you understand where the cell records put Dylan, Zach, and Shane in Parsons that morning?
Yes.
What time?
11:20.
Okay.
I'm guessing. I can't quite remember.
Do you understand what was your understanding of the state's timeline when a truck was hidden at Victor Dinsmore's?
I don't know what the state's timeline was. I'm guessing from Victor Dinsmore's trial testimony, the state's saying they did it before they went to Parsons.
Did you explore when there was time to do that?
No, I didn't. I should have.
Did you discuss with the jury this timeline that the state was bound by?
No,
Why not?
I don't know.
Do you remember having discussions with your internal team, Mr. Simmons, your background investigators?
Simmons didn't discuss any of it at all with me during the trial, I don't think. The investigators, I don't remember specifically. I remember showing that they couldn't get there within the 30 minutes that Jason said, or it would take them over 30 minutes. And so that Jason's timeline was off. I don't specifically remember putting the truck being hidden at Victor Dinsmore's, moving tires, getting it in there, and then going to Parsons by 11. I don't think I specifically remember that or put that together.
Did you emphasize to the jury the cell records from 10:49 beyond?
No,
Why not?
I don't know.
You remember, do you remember Jennifer Nichols's examination of Victor Dinsmore?
I've recently reviewed it.
And if you could go to page 1536.
1,536.
I apologize. It's going to be sooner than that. 1,490. 1,505. Final answer.
Final answer. So the reason, if you haven't tuned into the rest of the hearings that we watched this week, the reason the jury at the trial didn't get to see the cell mapping is because this defense attorney, who was lead attorney during the trial, didn't understand the difference between someone being a cell phone expert, like someone that could analyze the actual devices, do extractions of the data on a device, and what a U.S. Marshal came in and did as far as testing using the 2G data and taking the locations of the device of the victim and the device of those that were charged, those that were being investigated, and looked at some locations of what I think is a very likely third-party culprit, mapped it all out using the 2G towers. And because she didn't understand the difference between that and tried to qualify him as an expert in just cell phones in general, prosecution and what seemed like an adversarial trial judge, it's a different judge than we're looking at right on the stand right now, on the bench right now, say, nope, can't qualify him as an expert. So the jury doesn't get to see the cell phone information, the location information. And then this defense attorney isn't pressing key witnesses, the TBI agents, on how the story they relied on from the co-defendants who took pleas to testify and cooperate against Zachary Adams. She doesn't press them. Like, didn't you notice inconsistencies and how the details they gave you do not fit the evidence? So the jury doesn't get to hear how the pieces can't fit. So it's a good time. Nice, messy time.
Let me know when you're there.
I'm there. I haven't reviewed
right.
it yet.
Line 17, question to Victor Dinsmore. And while they're on the property, did Zach make statements to you about speaking to your wife or going to your wife's house and putting a car in your shop? Answer, no. He did not say anything. No. At any time did he tell you that? No. Then it continues 1506, but you don't recall him mentioning it there on the property. No, I don't remember him saying anything. I was trying to get them out of there before Mr. and Miss Doug or Dottie showed up. You recall, of course, being interviewed by law enforcement several years after this happened, correct? Answer, correct. And in that statement, just a minute, in that statement, if you told and then there's some objections, it continues on 1507. Question line 3. So my question is, did you make the statement to TBI agent Trout that Zach Adams hit his grandfather's white Nissan post-abduction? Yes. Do you remember this?
Yes, I mean, first of all, it's terrible. She's leading him terribly. He's asked and answered and said he didn't remember. I mean, the objections I should have made to that, but
Did you
it's
have
hearsay.
Did you have Valerie Trout's statement, IR statement?
I probably did, but I don't remember.
Did you have Valerie Trout under subpoena?
No, I did not.
Are you aware of Rule 803-26?
Is that prior inconsistent statement?
Yes.
Yes, I reviewed it last
That's
night.
one.
Okay. A statement otherwise admissible under 613B if all the following conditions are met. The declarant must testify at the trial or hearing and be subject to cross-examination concerning the statement.
No, she's testified, she's familiar with it.
Last night.
Was that met?
Yes,
Were the other conditions met?
yes.
Why did you not then go to your computer and show the jury the Brent Booth, Victor Dinsmore conversation at that point?
I don't know.
Was there any strategy involved in not showing that to the jury?
No,
Anything that you think that was hurtful to Zach, you didn't want to present?
no.
Victor Dinsmore prior had said that at the fight in the afternoon of April 13, 2011, what did Victor Dinsmore said they were arguing about? Do you remember?
I get confused. Did he say that they were arguing about who was going to hit that, or he'd let Shane hit that?
Was it your understanding Mr. Dinsmore was referring to a future event against Miss Bobo?
Yes,
In this recorded statement, do you remember what Brent Booth said Miss Holly's condition was at the time they were arrived that afternoon?
I think he said she was dead.
Does
In-
that make Victor's
talk-
statement make sense?
No.
Why didn't you present it to the jury?
Gosh, I don't know, Mr. Bates. I think, at the time, I should have had this all prepared out in the beginning. I didn't realize how much everybody was going to lie. I thought that I would be able to use the cross-examination of their prior inconsistent statements against them. And I thought that they would just admit that they'd made these prior inconsistent statements. But everybody just lied about it and said they didn't remember. Usually in a case like this, the state goes over the witness's prior statements, so the witness will testify consistently. But in this case, witness after witness was saying, no, I didn't review my prior statements. So the state hadn't gone over it with them to review their statements, and they came in not remembering, some of them not even remembering they had given statements.
Victor Dinsmore's cross-examination, page 1554. Line 16. Now, you also talked to Brent Booth about the gun that you just. Line
I get for you,
16.
laundered Amber.
Now, you also talked to Brent Booth about the gun that you disposed of that you got from Jason Autry, didn't you? That I had my wife dispose of. I got it from Shane. Your wife disposed of it because you suggested she dispose it, didn't you? Yes, I did. At first, you told Brent Booth also that it was a 357 or a 38, didn't you? Answer, yeah, I wasn't really sure what it was. Had you listened to the second recording of Brent Booth and Mr. Dinsmore when you cross-examined?
Yes.
What do you remember what Mr. Dinsmore said to Mr. Booth regarding the gun?
Not off the top of my head.
Your Honor, I'm going to play from the May 18th video recorded. Exhibit 64, the May 19th.
Okay, so the other day we tried, I think this is the same interview we started to hear some of, but it was from a hearing from either May or August that was only a clip, and the clip just ended. I think we're going to hear a little more here.
We go to your question on page 1554 was a 357 or a 38.
Yes.
Why did you phrase it that way?
I'm sure that's because that's what he had previously told law enforcement.
I'm going to play beginning at minute 7:02 of Exhibit 64.
Because she was going to the doctor, because I told her to go through, on the way down through there. She didn't, because there was too much traffic, came back, and that's when she pulled off and did all day road.
So he's just gonna keep it and hide it somewhere home. And I thought, that must be that.
She was gonna take out that boat that I haven't even, I put on even my property, to the dirt, which I ain't over it. She was gonna dig a little and put it in there. I kind of wish she would have been, it'd be dead, sitting right there still, so.
So you pulled up to Holiday Road
And she,
right there in the water.
and she laid it down, I know what she did. She laid it down, she didn't wear prints on it, and I heard her talk, she laid it down in water, and she took this brush and stuff over the top of it, so she.
Why did that not go to the meeting?
There might be a bottle, we don't know.
And remember that?
I remember him sitting there and telling me to get rid of that guy and make up a body on it. It came from Adrian.
Because A-Train has hands on it. And I remember when I told you guys about the other guy was a junky little piece of shit 32, and I took it myself and threw that in my cousin's ball. Okay, because I was ready to fire. And I didn't want to keep those around.
Did you emphasize with Mr. Dinsmore, he had already thrown a 32 revolver away?
No,
Did you emphasize when he made this statement in relation to when the gun was found?
no,
Do you know how many days before this statement was made?
no, but it was made before the gun was found.
You know how many days?
No. A few weeks, a few days.
We're now going to go to minute 6:04 of this same exhibit.
Revolver, or Shane, and A-Train, or Shane, trade your
I
revolver.
remember Shane, I remember now that Shane traded me a black 38 revolver. And this revolver, but it was when he switched the cylinder back 357. He came to me and wanted to get some pills for it. And I said, I can't remember how many I gave. I think I gave him some one time. The next time I got some, I paid him off, for the pistol. But then we started talking, and I remember when Jamie Darnell moved in, was mom and dad threw him out.
One gun, 38 revolver,
Yes,
interchangeable 357.
yes.
You made it seem like he mentioned possibly two guns. Was that a good question?
No,
Did you ever ask how is it that at one point Autry and Dinsmore both gave a 357 as the murder weapon? And then they both said at trial it was a 32 revolver. Did you ever connect that to the jury?
no, I didn't.
Why not?
I don't know.
You continually say you don't know.
Well, sitting here today, I do not know.
Would a competent, effective attorney had made these mistakes?
Badger her.
No,
You had poured your life into this case. What's going on? What was going on at this time?
I think at this time I wasn't prepared for trial. I thought we were going to get a continuance. I even thought when we showed up for trial on the day of trial in September that the other attorneys were going to ask for a continuance. I had been chasing all these other leads that they had dumped on us in May and July. And I was looking up like all these other witnesses. So instead of sitting down and doing my prep on the witnesses that were going to be the really tough ones that I should have done, I was trying to figure out who these unknown people were that were on the witness list. I was still reading through IRs, trying to find the white truck. And so I wasn't prepared. And I had nobody in that trial. I did witness after witness after witness. If you watch, the state breaks theirs up among 4 different attorneys and they take turns. Nobody goes twice in a row, or not very many times if they go twice in a row. I was going time after time after time, day after day. And I just wasn't prepared to ask good, hard cross-examination questions.
Keep going.
Well, I mean, I am a good attorney and I did know the facts of the case. But just the way that it's set up and it came to trial, it was a cluster.
On page 1542,
Fair.
you asked Mr. Dinsmore, page 1542.
And
line 4. So
it's a bit interesting because like these are really post-conviction proceedings. But this isn't like at a higher court of appeals level. This is still down in the circuit courts. So it is new counsel. This is all stemming from a January 2024 petition for post-conviction relief that's encompassing a request for a new trial, as well as other things like sanctions against the prosecutors. So different types of relief are being sought as remedies in that petition. But these extended hearings, there's a set of days from May, a set of days from August. We're watching the last day of the November hearings that took place this week. And then there's 2 more sets, December 29th and 30th, and then January 7th and 8th, where I think we're going to hear a lot more. The state's going to start calling their witnesses and putting on their opposition. They're going to argue against the petition. And then the judge, presumably by end of January, beginning of February, will have a lot of orders to make, and can't wait to see how this plays out. But yeah, so it's similar to what we'd expect, like after a conviction, but it's really not at the Court of Appeals level. There's been a few interlocutory appeal moments where, for example, the May hearings, one of the state's motions in limine in regard to these proceedings, they wanted to keep out an interview that Dr. Katie Spirko, who is, she's going to be an expert witness that's going to testify. She wanted to testify. I don't know how that's going to play out, about the conditions in which someone might make false confessions. But she started investigating this case. She also has a podcast with her co-host, a criminal defense attorney. The whole podcast is about this case and why, after they looked at the evidence and they know the details, like their podcast is incredible. It's the Trial and Error podcast. We took a little bit of a deep dive in the Discord yesterday to look at that. They went in, they make this podcast. They go to the Tennessee Department of Corrections and they go and interview. Katie goes and interviews Jason Autry. Jason Autry is someone referred to by the state as being too dangerous to even transport between court and facility. But somehow, when he gives a proffer and agrees to cooperate, they give him a plea of 8 years instead of death penalty, taking him to trial and leveraging the death penalty over his head. This podcast, Katie Spirko, they go and interview. He recants his testimony, tells them why he gave the story, and tells them he just worked with the evidence that they had and made it fit. And now he knows it doesn't make sense. But they filed a motion in limine at this May hearing to exclude that from these proceedings, these post-conviction proceedings. Judge granted the state's motion in limine. Agreed, can't come in, but granted a certificate of immediate review. So there has been some appellate court involvement just for like review matters on decisions that have kind of like taken place, punctuating these proceedings. But this is all still like circuit court level. So, and that's why we're seeing so much of it, right? There aren't these like 5-minute clocks that one side makes their argument, the other side gets to make their argument, and then they get cut off. So we're really, really seeing the process. And I don't think a lot of this is surprising. It's just, it's unique to be able to observe somebody saying what's usually the quiet part out loud. But that's really where we are, Random Girl. It's extremely interesting.
Oh, I'm not understanding. When did you and your wife talk, before or after Brent Booth came to talk to you May 18th, 2017? Answer: we talked before, after. We talked last night. We talked on the way to court this morning. When did you and your wife talk about the fact that the white Nissan truck was parked in your shop? Answer: before Brent came up. Question: before Brent? Answer: yeah.
So I did a very bad job when I went back and reviewed. I did a very bad job of pointing out that there was no break in that interview from the time he said there was no way that white truck was in my garage to the time that he said, oh yeah, now I remember it was in my garage. There was no break for him to talk to his wife.
Did you?
I didn't make that clear to the jury.
Did you ask for a recess and say the state has an obligation to correct perjured testimony?
No, and they had an obligation to correct it.
Did you ask for a mistrial?
No.
Did you ask for a mistrial at closing argument when General Nichols said the white truck was put in Victor Dinsmore?
No.
Why not?
I don't know. I had asked for a mistrial before, and the judge had just belittled me so much. I just didn't want another opportunity for the judge to belittle me in front of the jury. I mean, he treated me like a second grader over the evidence materials. When I said it was hearsay and the state said it's not hearsay, they're not offering it for the truth. And I asked for corrective instruction to the jury. He gave the jury a little mini lesson about hearsay. And he said, every law student knows this. So every time I objected to things, he was so belittling to me that I thought I just got punished enough that I stopped making as many objections as I should have. And all kinds of hearsay came in and all kinds of irrelevant material came in, and I should have objected to it.
Look
When Greg
at the
Booth
judge.
says, we got it right. You objected to his opinion.
Yes.
At the time of your objection, did you know that he had sworn to the Judge McGinley there was probable cause that Terry Britt committed the crime?
Yes, I knew that.
You had search warrants.
Yes, I knew that.
Why didn't you say, okay, you want to give your opinion? Here's your prior opinion.
Gosh, I should have. I don't know why I didn't say that.
You had Terry Britt on a wiretap being told there might be a wire in this house.
So with the search warrants, I mean, I did bring up the fact that he had done hundreds of search warrants, and I did ask Brent Booth about that. But I should have gone through them each one and said, you know, you at one point said it was the Bobo family, and you at one point said it was Terry Britt, and all the different search warrants he had done for all the different people that he had sworn on oath that they were guilty. I should have been much more organized and laid things down like that in a solid. I should have just gone through one by one by one and just shown how the state had changed their theory of the case so many times. But, you know, it was hot in the courtroom. First of all, it was very hot those weeks. The jury was sweating.
The water bottle.
The judge kept saying, let's speed it along. Let's move it along. Let's get going. And
Did you ever make this point? Sheila Kilzer has a phone call. It reshapes the investigation. Culminates in death penalty being requested after Dylan provides a 4-hour statement that's not true. But now, ladies and gentlemen, we're supposed to trust this last round of TBI's effort. Did you ever make that point?
not clearly, no.
Did you ever ask any state agent, tell me where the cell phone and the body was separated of Miss Bobo?
No.
Did you ever do the timeline of Jason Autry showing up at Shane Austin's house 20 to 30 minutes after the phone call at 8:52 and ask if Dylan's there with his shirt off the entire time, how is he taking a cell phone along the route that ends at Gooch Creek?
You know, I thought our cell phone expert was going to make that point, but clearly the expert didn't make those points to the jury, clear enough for the jury to believe it.
Did you have a demonstrative aid, however crudely designed?
No.
The expert doesn't get to just pontificate. You got to ask questions, right?
Yes.
Did you ask questions to go through the rest of the morning to say,
Get her.
the state wants you to believe at 8:52, they have no idea what to do with the body after pulling off a crime that has escaped investigation. So they have to bring in Autry to drive to the river only to just come back. And at that point, they say, well, that didn't work. Let's go to Sonic. Leave the body at Shane's house knowing the satellite installer's coming. Did you ever work through this with the jury?
No.
Did you ever say for years TBI thought Holly was alive for several days?
No.
Did you subpoena the prosecutors and say, what are you going to give Jason Autry for this testimony?
No.
You asked for it in your Brady motion, didn't you?
Yes. Mike Scholl had told me what Jason expected to get.
What was it?
Little or no additional time past his federal sentence, which is what he got.
Did you ask Mr. Autry how many years are you willing to receive for your testimony?
No.
Mr. Autry repeatedly, when confronted with something, he would say,
Hey, Allie.
if your records show that,
Reflect. Yes.
if your records reflect that. Did you ever ask, who told you to say that?
No.
Did you ever ask Mr. Autry, what was it like sitting through waiting trial for a death penalty case you didn't do?
No, I didn't ask him that on trial.
There were statements Zach made, correct?
Yes, there were statements that Zach made.
Did you talk with him about Zach? Did you talk with Zach about them?
No, Jim Simmons, I think, talked with Zach about the statements.
Did Zach tell you he wanted to testify?
I don't remember that.
Do you remember talking to the news after the verdict?
Not exactly. I remember that I walked
Exactly.
outside and made some statements to the reporters, which is really about the first time I'd made any statements.
You
Did you ever prepare Zach to testify?
No.
Oh, here's the part.
Why not?
Well, because there were some accusations that Zach had tried to rape his stepsister. And
What?
I thought if we got him on the stand, those accusations were going to come in.
Did you discuss it with Zach?
No.
Oh,
Did you? Do you?
so she's hinting at strategy there, which normally, if this was just like why I didn't raise an objection, cool. But strategy and not consulting with your client about something that's ultimately the client's decision only, you having the strategy in your own mind and not using that as part of an informed discussion with your client about their right to testify, I don't think that's going to fly.
Ever allow your clients to testify?
Not usually.
How many clients have you allowed to testify?
Oh, maybe just one.
How many trials?
Many.
How can you make a decision as to the wisdom of the client testifying if you don't see how he does in preparing him?
Well, I guess I made the decision based on the fact that these accusations, which I did not believe were out there, and I didn't want them to come in.
That's the only reason.
Well, also, Zach was a little methy. Even still then, he's not the man he is today.
You had been advised in these proceedings that there was shared in discovery a video from the ATM machine
No.
in the post-conviction proceeding.
Oh, yes, I've now know that the state knew that there was a video of the ATM machine.
And did I ask you to follow the file path that was provided in a motion by General Boyano to find this?
Yes. Yes.
And-
So on my Pegasus hard drive that I have, that was several $1,000s, I pulled it out, fired it up, and went through the process and followed the path that you said it would be to open up the video.
Were you able to open the file path from BP 413?
No, I could not get it open.
And did you take a screenshot of what your computer had? You can look at the document been passed.
I guess I did.
And did you send it to me?
I guess I did. But recently, I mean, I did it just very recently too.
Let me ask this. Would it help you remember when you possibly sent this if you saw the email to my office?
Yes.
I'm going to pass the witness this. Just look at it and then provide it back to the court officer, please.
Yes.
All right, provide it back to the court officer. And what date was the email?
April 25th, maybe 2025.
And what's the date on the install this first to view on the far right.
Oh. April 3rd, maybe?
Okay. And is this what you,
Yes, this
All
is the screenshot of it.
Your Honor, I move to enter this next numbered exhibit.
No. But I recently also got,
Yeah. You recently what?
I recently, just days ago, got out the hard drive again, turned it on, fired it up, and tried to open the file on the Mac. It wouldn't open on the Mac, but then I made a copy of it to a thumb drive, took it over to my computer, installed the software on my hard drive like it says to install the software. The software went on and still couldn't open the files.
It was labeled, what is it labeled on this?
V8 or something like that.
But what's the individual date, the individual number?
I don't know. I lost my copy. Hang on. Gosh, this is not a good copy.
What are the letters by the number?
BP, so it's labeled BP, BP 4-15.
And in the file path, what is it labeled that it's from?
I can't tell,
Okay.
but I think it looked like it was video from the BP store.
If it was, did you ever, like that, did you ever see the file path ATM?
No. There was some bank footage that they provided, and I did go through the bank footage and try to watch it and see if I could see Zach coming through an ATM, but I didn't. It didn't clearly show the ATM, and I didn't see Zach come through.
What? You could look behind you.
And it's good to see you, by the way,
Yeah,
Ariane, the
thank you.
vegetarian. I think the prosecutors in this case are way worse than Adrian Love. And you can hold me to that. I didn't watch the first trial, but what I've seen from Amy Wyrick in these proceedings, she's trying these proceedings, and what I saw from Jennifer Nichols and Boswell on the stand, just a hot mess. Just a hot mess. And meanwhile, as much as I would have liked to see Adrian Love on the stand, and I think she's done unethical things myself, personally, I think she would have caved and maybe like cried on the stand, and I don't know. We'll never know because she wasn't made a witness, but I think these prosecutors, individually and especially collectively, have taken the number one spot. Kind of with some headway. And Nichols is a judge now. Nichols is a judge.
Do you remember seeing this video, Ms. Thompson?
This video right here doesn't seem to show anything.
Okay. Do you remember seeing it? Hold on one second. Do you remember watching this video?
Not specifically.
Okay.
Is it the video from the bank?
I can't answer questions.
I mean, that kind of helps the
It
incompetence
seems like it's a
claim.
video from the bank where it's showing the road and showing cars driving up to the bank teller window.
Did you change computers or hardware at any time leading up to your representation?
No, I had a Windows computer in my office.
So in March and April of 2017, when you were 2025, this year when you attempted to open. Is it because you had a new computer or a new system?
Well, I did get a switch over to Windows computer years ago.
Okay. And if you could turn around. Do you ever remember seeing, prior to these post-conviction proceedings, this photo?
No.
Do you,
Which is a still shot of that exhibit. We marked it as a long exhibit what?
101.
101.
if you had the timestamp of 11/12 of that photo, would you have used it in a jury trial regarding the timeline the state sought the jury to believe?
Yes, that's an alibi, partial alibi for the time that the state says he was committing the murders.
Did you have photos of that Silverado from being impounded by the state?
Yes.
You testified you were competent and diligent as an attorney in 2014,
Yes.
2015,
Yes.
2016,
Yes.
2017.
I think 2017 things began to change.
Were you competent and effective at the trial in September of 2017?
I don't think so. I think that I was still trying very hard, but I think there was so much material, and I was the only one working with it. I was the only one doing the trial, and even if I had wanted to pull something up and play something for the jury, it would have been a monumentous task for me to find it in the discovery. One of the things that the state did is they would come up and they would present the witness with a piece of paper and say, here's this. And I would say, what is that she's handing him? And she said, well, she got it in the discovery, Your Honor. Well, I got 4 terabytes the first day. The first day they gave me discovery, I got 4 terabytes. And then they kept adding on and on and on to that. So I wasn't able to pull things in trial and show them. I was barely able to cross-examine witnesses. And it's not because I wasn't trying or I wasn't a good attorney. It was because the situation that I was plopped down into, and with the judge being so rough on me and the state being so ugly to me, it made it impossible for me to be my normal zealous self.
Ms. Thompson, do you agree that a competent attorney has to get past sometimes the state's mean to you?
Right, that sounds kind of babyish, but the state was so ugly when I would make objections and so ugly in front of the jury, I was worried that they were poisoning the jury against me.
You knew this was a voluminous case in 24 when you received discovery.
Sure.
You knew you were going to a dense trial.
Yes.
You knew the important witnesses, did you not?
I did.
One of the, Jason Autry testified that he remembered in 2017 driving and seeing a man mow his yard. Remember that?
Yes.
Did you remember you had an IR?
I knew we'd had an IR to that effect.
Did you bring it to the jury's attention?
No.
Why not?
I don't know.
You knew Victor Dinsmore was an important witness.
Yes.
You knew Rebecca Earp.
Yes.
Did you remember Rebecca Earp was threatened with prosecution?
Yes. And it threatened that they would take her baby away from her if she didn't tell the truth.
I think Rebecca Earp is Zach Adams' girlfriend. So
Rebecca Earp.
Yes.
Did you remember Rebecca Earp was threatened with prosecution?
Yes. And it threatened that they would take her baby away from her if she didn't tell the truth.
Did you ever tell the judge right before the continuance, Judge, I'm upping my dosage of antidepressants?
No. And when I said the state was mean to me, I mean, that's not, people being mean to me is not a reason, but over time, just the continuous, when they threatened to put me in jail is really when things kind of changed.
Why didn't you withdraw them?
Well,
Judge, they're trying to put me in jail.
because I thought if I withdrew, judge was just going to put on some other attorney that would come in and plead Zach guilty. And I knew Zach was not guilty.
You thought you were the only attorney that could help Zach.
I thought Judge McGinley was not going to appoint a fiery attorney to represent Zach. And I believe that's true.
Were you a fiery attorney to the jury?
Not at that point.
In hindsight, do you think this should have been your first death penalty case?
Well, I think the death penalty didn't come into it much.
You don't think it impacted jury selection?
I think Jim Simmons had so much experience in death penalty that he was able to handle the death penalty part, and death penalty really didn't play into it much. Jim was doing the mitigation and the sentencing.
Do you think the death penalty affects jury selection?
Yes, you get a much tougher jury when you do death penalty selection.
It's been alleged that nobody looked through the discovery as much as you did.
Yes.
You have maintained Zach is innocent.
Yes.
You think if you had done a better job, the verdict would be the same?
I think so, because I think the way that we picked the jury and the way the judge was handling the case, I don't think the judge was going to let Zach get a not guilty. I think the judge was going to do what he needed to do in order to see that there was a conviction in that case.
It would hurt you professionally if it were your fault, right?
I'm not sure it would hurt me more than this testimony is hurting me.
It took you how many years to do the motion for new trial?
Several.
Why?
Because I just didn't, well, one, it took a long time to get the transcript. And then after the transcript, I just hated looking at the case. It just was so ugly. I just didn't want to go over that part again.
You have gone through and watched your trial from 2017.
Yes.
How is your cross-examination of important witnesses?
Well, Victor Dinsmore and Jason Autry was poor. In the past, when somebody lies and makes up stories, I've been able to go through their story very slowly and show all the lies. I mean, they get twisted up in their story. But Jason didn't get twisted up. He stuck with it. And so what I ended up doing was just nailing down, just confirming and reaffirming Jason's story instead of showing that he was lying. He was lying.
Did it ever cross your mind to call Mr. Scholl as an attorney or somebody from the state to discuss their plans for Mr. Autry?
No.
Senator Witness, Your Honor.
Cross-examination. Here we go.
You want me to break?
Well, no,
Are you
I'm
telling
saying I was going to
Yes,
break unless, I think it's gonna be excluded.
It will not.
So I don't think so. All right, we're gonna recess until 1:15. We'll start cross-examination. Thompson.
Okay.
We're recessed.
All right.
Okay, we'll skip the recess. For me, I am most interested. I mean, I think we're going to hear the state push back on a lot that was going on. But I really want to hear more about the decision on Luke Evans, this like very good defense attorney that seemed like by all accounts should have been able to join and help the defense team on this case. But the judge at the trial level, Creed McGinley, comes out and says, after speaking with Miss Nichols, who's the prosecutor, we've made the decision, there's a conflict. So Luke Evans can't come aboard. And Thompson goes to the Board of Review of Professional Conduct, and the board says, we don't see a conflict. This is fine. So they go back and ask, and the judge still says no. I want to hear more about that, because the way that's worded, that the judge comes back out and says, after speaking with Nichols, the prosecutor, it did not seem like it was an all parties present proceeding where this decision was discussed, argued, and then ultimately made. It seems like it was ex parte. And I want to see if the state's going to try to walk that back. I also really want to hear about the decision on strategy not to press on the prior inconsistent statements with the Dinsmore and Booth recording. So Brent Booth is TBI agent. He's the guy that when he took the stand during these proceedings said he rarely thinks victims are innocent, but when he saw Holly, he was touched because it reminds him of his own daughter. And we heard, although Nichols didn't want to concede, prosecutor Nichols didn't want to concede, we heard twice that contemporaneously, while this was all happening, she had concerns that Agent Booth was suborning perjury from Vincent Dinsmore, this guy that they travel all the way to Indianapolis to go do an interview with, and he ultimately tells them, they say, you need to give us something, you need to give us something. And he ultimately says, well, you need to talk to Dylan Adams. He's the slowest of the bunch. He's the easiest to get to talk. So those are the two. I'm very, very interesting on that. But we're going to time travel, you guys. We get to skip this break. They do take a break, though. And Amy Wyrick. We get to hear Amy Wyrick on this fine Sunday.
Thank you. Thank you. Ms. Thompson, when you were retained to represent Zachary Adams.
Oh, and to clarify, the woman on the stand right now is actually Jennifer Thompson. Jennifer Nichols was trial prosecutor and now judge, present day. We watched her testimony yesterday, and Jennifer Thompson is trial counsel, who's on the stand right now. Woman doing the questioning for the state is Amy Wyrick. So those are the names. Doug Bates is the counsel for Zach Adams presently.
How many jury trials had you had?
I don't know, a dozen.
A dozen? Of what grade of felony?
High felonies. I don't think I had any low felony jury trials.
Mainly in the Davidson County area?
Yes.
All right. And what was your typical weekly caseload of open cases?
I probably had 30 cases open at the time.
Okay. You had a solo practice, is that correct?
That's right.
And you had opened that practice in what year?
1998.
Before that, you worked as a computer programmer, is that correct?
Before law school, I did.
Before law school. For how many years?
Maybe 6.
Okay. So you worked in the professional world and then went to law school.
Right.
All right. Graduated with high honors, law
Yes.
school, correct? And I'm going to show you on the screen there something, if you could turn around, see if you recognize it. Is that your website?
Looks like it.
All right. Is that a fairly recent new website?
Looks like it, yes.
Okay.
She's still
When you
saying
scroll
she's
down, it says your
competent.
professional activities. You're a member of many organizations, correct?
Yes.
Board member, correct?
Yes,
In fact, voted super lawyer by your peers.
I was.
Serve on the criminal justice panel for the federal courts. Is that correct?
I do.
All right. You still do, or you did?
I do. I still do.
That's an elite group of defense attorneys, correct?
It is.
It's a lengthy application. It's correct.
Yes, you have to have lots of experience.
20 pages of information to fill out, and then you have to be approved by the federal bench. Is that correct?
Yes,
And how long have you served on the CJA panel?
over 20 years.
And you were named member of the year of the CJA panel, right?
Panel attorney of the year. Yes, I was.
The clerk for criminal court judge Gary Wade,
Yes, I did.
tactile board member, correct?
Yes, I was.
On your website, under notable cases, there's 3 listed. The first
Uh-oh.
one being State of Tennessee versus Zachary Adams. Correct?
Yes.
Those other 2 cases,
Uh-oh.
are they criminal cases as well?
Yes, it's 4 cases.
Oh, I'm sorry. All right, 4 cases, and they're all criminal cases.
Yes,
All right. When did you create that website or have it created?
probably 2024.
Okay. I'm going to ask document be passed to you. Well, actually 2. I'll save some time here. A 1-pager and a that for her and for the judge. Thank you, ma'am. If you could look at the 1-pager first and tell me if you recognize it.
All she did is have a mark for identification, 1-page CV.
I get the argument she's making, but people pad their resumes
Yes.
quite often.
I recognize that.
What is that?
It's my CV.
All right. And the second document that I handed you, the 2-pager. You recognize that?
Yes,
All right. And what is that?
it's an engagement letter between me and Zach Adams.
All right. Can I ask that the exhibit 134 be moved into evidence?
And 135,
And 135, yes, sir.
mark the engagement letters, exhibit 135.
Thank you. Was this a form engagement letter that you used on all cases?
I modify it depending on the case.
Thompson Law Firm will represent you in the matter of State versus Zachary Adams. The amount of the fee retainer is $50,000. Was that a flat fee that you were going to be paid? Or
What-
did, go ahead.
I think my
Let's do a exercise in the chat, guys. Do you think Jennifer Thompson putting the Zachary Adams case on her resume, do you think that's actually a net positive for her resume? Or do you think it's a net negative? Because would you want to hire her if you looked her up as reference, saw that this is one of the 3 things that she said was something that represents her performance, and you went and looked up this case? Would you want to hire her?
retainer says that if we get to the near the end of the fee and there's still work to be left done, I can request additional retainer.
Additional money.
Yes.
Correct. When setting legal fees, the Thompson Law Firm considers many factors. Some of the factors are as follows: the complexity of your case, the time, other clients, and other opportunities that the Thompson Law Firm must decline to take your case, the expertise and experience of the Thompson Law Firm in representing clients in matters of this nature, and the firm's best estimate of the amount of time which will be expended to represent you. Once counsel begins any work on the matter, the legal fee retainer will not be refundable and is considered earned when paid. And I'm assuming since this is signed and you began work, it was paid,
Yes.
and you began working on behalf of the defendant, Zach Adams.
Yes.
Did you go back to the family at any point for additional funds when that money ran out?
Not for me, no.
Okay. At some point, you got Judge McGinley to appoint you, correct?
Yes.
Is that typical for a lawyer that's been retained outside of the court system by a defendant to then be appointed by the court to be paid by state dollars?
Yes.
That is typical.
Yes.
You've had that happen many times in your practice.
Jennifer
I didn't say many
Thompson on the
times, but
stand.
It happens that if a person is first retained and then they get involved in a matter that becomes much more complex or a death penalty case, they'll be appointed.
Okay. And in this case, the death notice probably played a factor in that. Is that correct?
Yes.
All right. Do you remember when you were appointed by the court?
I don't remember.
When you agreed and executed this document,
Thank you, Amy.
at the time, you had experience.
Yes.
You'd been in courtrooms before.
Yes.
You'd talked in front of juries.
Yes.
You'd handled motions in front of judges.
Yes.
You knew your way around.
Yes.
And you were confident in your
Yes.
ability.
Yes.
Who's Brad McClain? You remember who Brad McClain is?
He's another attorney that does criminal defense work.
All right. Do you remember telling him at one point, I do great with juries. I can win this case. I will tear his ass up on cross-examination. Excuse my language.
No, I don't remember saying that.
Okay. Did you talk to him about this case?
Yes, at some point I did.
Was he one of the lawyers that you tried to recruit to help you?
Yes.
Do you remember telling him you've tried lots of cases with Jim Simmons? I love him.
Yes.
You do remember saying that?
Yeah, I love Jim Simmons.
Okay. All right. And you all had tried cases together.
We had tried several cases together. I don't know what a lot is. We had tried several cases together. Yes.
And if I said a lot, I didn't mean to, but you had tried cases together.
Correct.
All right. How many? Do you have any idea?
2 or 3.
All right. What were they? Murder cases?
Probably child sex offense cases. Sex offense cases, probably.
Okay. You testified on direct examination that around 2017, you started to question your, I guess, ability. Is that fair?
I don't know if I was really questioning my ability. I think around 2017, I became more complacent and didn't fight things. I wasn't objecting to things like I should have been.
Okay. When Mike Scholl shared with you that Jason Autry was going to testify for the state of Tennessee, you all had a conversation about that, right? He called you.
Yes.
He told you, he called the other attorneys.
Yes.
Do you remember asking Mike Scholl, when I walk my client out of the courtroom, will your client have any time to serve? Remember asking him that?
No, not specifically. No.
Okay. That sounds pretty confident, doesn't it?
Sounds pretty confident.
You always have that level of confidence when you go into trial.
I wouldn't say on every case. It depends on the facts of the case.
Okay. You billed, once you got appointed by Judge McGinley to be paid by the state of Tennessee, Explain to the court how that works. You do the work and then you submit the billing, correct?
Right, you do the work and then you have to submit the billing within 180 days from the day of the work.
4,000 hours.
Did you do that in this case?
Yes,
All right. Did you have a system set up in which you did that on a fairly regular basis?
yes,
And I think you testified earlier that you did work that you didn't even bother submitting to the state.
yes,
And then at some point you started growing the team. Is that a fair characterization?
yes,
Get some
Brought
blue
on
hearts
Jim
in the
Simmons?
chat
Yes.
for Amy.
Brought on Jerry
Thank you,
Gonzalez.
Amy.
yes. He came in late spring, early summer.
All right. You brought on experts.
Yes,
You attempted to reach out to other defense attorneys to help you, correct?
yes,
Some of the experts that you had a computer expert, correct?
yes,
A neuropharmacologist expert,
yes,
Dr. Pam Auble,
yes.
an instinctual trauma response expert. What is that?
I don't remember.
But you had one of those.
I guess. I don't
You-
remember that.
You had a cell phone expert.
Yes,
You had a gun expert.
yes,
You had a mitigation expert.
yes,
You had a memory expert,
yes.
a confession expert.
Now, these are people that we may have talked to. I'm not sure that they were ever fully engaged and paid money to, but these are people that we were talking to.
That you worked with, that you shared information with,
Yes,
all in the name of representing Zach Adams,
yes.
not on other cases.
No, this case.
Right. A memory expert,
Yes,
a confession expert,
yes.
a sound expert,
That I don't know.
a false confession expert,
Well, that would have been the same as the confession expert.
all right, a jury expert,
Yes.
a death penalty expert,
I don't know who that would have been, except for just Jim Simmons.
and a media expert.
No, we didn't have a media expert.
You didn't talk to anybody about how to handle the media situation around this case?
I don't remember that I did.
Okay. You also had two public investigation firms or private
He's so
investigation firms
sensitive
that were
about
working
that.
for you, AK and SAI,
Amy.
Yes.
correct?
Amy Wyrick,
How
not
long were they
Amy
on the
E.
case?
Probably from near the beginning.
You know-
AK probably came on a year into it, a year later.
I'm sorry, I didn't hear you.
AK probably came on after a year or so.
All right.
But Danny
You
Mulligan and
slim?
SAI came on right away.
And they would do the work and then you would submit to the state reimbursement for their work, or did you pay them out of your pocket?
Submitted to the state for reimbursement.
AK Investigations made $114,000 on this case. Were you aware of that?
I don't know the sum, no.
But you would have submitted the paperwork for it.
I would have submitted paperwork, yes.
SAI made $37,000 on this case,
Again, I wouldn't know what the total was.
but you would have submitted it.
No, Simmons submitted the paperwork for
Okay.
SAI.
But through the same system and in the name of the representation of Zach Adams.
Yes.
Okay. And you billed the state for $210,000.
I don't remember the final number.
Okay. I'm going to pass you the document. One for the judge and one for the. Thank you.
Wait, so 210 was the total bill to the state? Because I don't think that that's very high. Or is that for one portion of work?
You may or may not recognize what I've just handed you.
I don't recognize it, no.
All right. This is prepared by the comptroller's office, and it breaks down the billing that you sent to the state of Tennessee.
Okay.
I have here, Your Honor, if I may approach the witness. You'll flip through, Mr. Brown, as I've had here. See if you recognize those documents.
These are billing materials that I submitted to the court.
Do you know how many pages they are?
No, I don't.
Would the number 600 surprise you?
Yes, it would surprise me.
It would surprise me. Okay. Is your signature on those documents?
Yes, I'm sure it's on these documents.
So anytime you did work, it got reflected in a bill and submitted to the state. Is that correct?
Yes.
All right. Your Honor, at this time, I ask that the comptroller document be marked for ID only purposes.
All right, this will be marked for ID only, exhibit 136.
Here, take this. Take this.
And then we have a flash drive for the billing records, if those could be the next numbered exhibit.
Exhibit 137 will be on the billing records. Mrs. Thompson for her representation is now.
You ready? Thank you. So you testified, I believe, earlier that you as a team did not meet regularly. You and Mr. Simmons and Mr. Gonzalez and these 14 consultants and experts that I've just listed, you didn't meet regularly. Is that your testimony?
No, I think I was testifying that all the defense attorney teams didn't meet regularly. As the case grew on, it was towards the end of the case, we were not meeting regularly with Jim Simmons. I did have regular meetings with my investigators.
All right. And when you say regular, what does that mean?
I don't know, once a week, once every few weeks.
All right. Did you put together a focus group at one point?
Oh, I did it not a formal one, no.
Well, what's the difference?
Well, I gathered up some people and had them come to the motel where I was staying and come into the little breakfast area and sat and talked to them.
About what?
About possible theories of the case, different facts of the case, things like that.
How did you select the people?
I just kind of went out and asked people that I knew or people that knew people that I knew and asked them if they'd be willing to come over to the motel.
The motel here in town?
Yes.
Okay. And did you do this on one of your trips here on a court hearing?
Yes.
This wasn't during trial?
No.
This was, how far in advance of trial did you do this?
I don't know. Maybe that summer sometime.
And which of the other attorneys or team did you have with you?
I think Paul Bruno might have been there, but I can't remember now.
What did you share with them?
I can't remember now.
Well, I mean, you gather these people, it sounds like just off the street, you bring them into a hotel lobby and they're doing you a favor. They're giving you their time. Was this on a Saturday, on a Sunday?
I can't remember.
Okay. How long did you spend with them?
Oh, maybe an hour or so.
Had they all heard of the case?
I think so.
Okay. What did you tell them?
I don't remember now. I honestly just don't remember what I said to them. I told them
Was
about
there
the case.
wine?
Had the body been found when you did
Yes,
this?
the body was found early on before I got the discovery.
Okay. Had Jason Autry decided to join Team America when you did this?
Team America. Had he gone to the dark side? Is that what you're asking?
I asked you if Jason Autry had decided to testify for the state of Tennessee when you put together the focus group.
Yes, I think he'd already decided to testify.
Okay. And so had you talked to Mike Scholl when you put together the focus group and knew what Jason Autry was going to say?
Yes.
Had you talked with Matt Maddox and knew that Dylan Adams, you knew Dylan Adams had given a statement, right?
Yes.
You had it.
Yes.
Had you interviewed any witnesses?
Yes.
How many witnesses do you think you interviewed throughout the course of your representation of the defendant?
Me and the investigators, or just me personally?
You and anybody who would gather information and report it back to you.
I think we talked to lots and lots of witnesses.
50, hundreds,
Probably 30 or 40.
30 or 40? Okay. So you gather this focus group in the hotel lobby. What do you say to them? You say, I'm Jennifer Thompson. I represent Zach Adams, and I'm going to throw out a scenario for you. I don't know. What did you do?
I don't remember.
You really have no memory of this.
I really have no memory of it. It was just a very casual thing. They came over. I said, will you come by on this night or whatever night it was? They came by and I talked to them about different facts and said, does this fact
What
make you think?
facts? What facts?
I don't remember the specific facts of the case. I remember I would say, does this fact make you think he's more or less guilty? Does this fact make you think he's more or less guilty? How much does this fact bother you?
Didn't they all sign non-disclosure agreements?
Probably.
But it's to protect privilege. Oh my God.
Did you take information that the defendant had shared with you and share it with that group?
Wow, this lady is probably pissed because she probably went and tried to go find out what was being discussed and they couldn't talk about it. And not for nothing, maybe Amy's actually pulling a chess move here. Maybe she's trying to point out you're a competent enough attorney to make sure that there's an expectation of privacy while you're discussing anything that could go towards defense strategy, and that you had a defense strategy to protect in these communications. But I think there's still she's pissed off that she couldn't go and find what their strategy was. She didn't have a mole in there. She didn't have someone that would give her the information. So it could be a little bit of both, but I think at least her being pissed off that she doesn't know, she can't nose around in what's going on, is pissing her off in a way. Especially since she took such an issue right around the time of the motion to recuse Judge Creed McKinley, who seems to be very favorable to the prosecution team. You're surreptitiously recording me.
Well, then Were you reading IRs to them?
I don't really remember. I was just talking about the facts of the case. Zach Adams didn't have much to share with me about the case because he didn't know anything about it.
Right.
Right.
Why did you do that? What were you trying to accomplish in putting together the focus group?
Trying to figure out what kind of theme and theory we could go with for the trial.
What kind of theme and theory? So did you talk about Terry Britt?
Yes.
You remember talking about Terry?
I don't specifically remember talking about Terry Britt. I'm sure that I would have brought him up because he was an important part of my case.
Okay. When you finished the focus group, did it change the way you approached the case?
I can't remember now.
Okay. You mentioned that the defendant was not really saying much. In fact, do you remember telling Brad McLean, I get along fine with Zach Adams. He's not engaged in the case. He doesn't say anything. You remember that?
No, but that's probably how he was acting at the time. He was kind of methy.
It's kind of methy. You're smiling when you say that. Is that he's kind of methy?
Yeah.
You mean he was still on meth even though he was in prison?
No, I mean, his brain was still affected by meth and he wasn't thinking like he does today.
Gotcha. Okay. Who's Marjorie Fargo?
I think she was the jury expert.
Okay. Do you remember telling her he has no short-term memory because of all the drugs he's done?
I don't remember specifically saying that.
So she talked to
Did
Marjorie.
you put together any other focus groups besides the one you don't remember?
I remember the focus group. I just don't specifically remember what we said.
Okay. You solicited help from NACTL, correct?
Yeah,
National Association.
Do you guys get the impression that Amy Wyrick knows Marjorie?
Of Criminal Defense Lawyers?
From people in NACTL.
Yes. But contacts that you had within NACTL.
Yes, I did.
You solicited help from law schools for
Yes, I did.
interns? At one point, you were trying to get a large firm to hop on board with you, correct? Remember that?
Yes, I'm not sure if that was for the trial or for appeal.
When you needed resources, who holds the purse strings on an appointed case?
The judge.
The judge. So when you needed money, you had to ask Judge McGinley, correct?
Yes.
Was it something you had to put in writing
Yes.
every time?
Yes.
Okay. But you don't have to share it with the state, correct?
No.
It's all done under seal.
Yes.
Do you have any idea how many sealed requests for resources you made?
No.
Do you remember what you requested money for?
Some of the things I remember,
Like,
jury consultant, Marjorie Fargo.
were they paid by the hour?
I think the AOC does it where they mostly pay people by the hour and they don't pay people by the case. That's how I remember things.
All right. Do you remember a trip to Green Hills Mall to the Apple store
I've been to Green Hills Mall lots of times.
on this case?
I don't specifically remember going to Green Hills Mall in this case.
Purchasing $3,500 worth of Apple equipment? Do you remember that?
Was I buying hard drives?
I don't
Can't
know.
remember.
I'm going to pass you.
Does Apple sell
Receipt.
Pegasuses?
Have it passed to
Pegasi?
you, rather. Thank you. There's one for the judge. too. You recognize this?
I don't recognize it, but I can see what it is.
Did you purchase those things for the Zach Adams defense on December 31st of 2016?
Yes, I guess I did.
And what were they?
I think it's a hard drive, and then the plugs for the hard drives, cables for the hard drives, a cable to put the Mac computer onto a TV screen or video screen like this one. I think ways to hook a printer up to a USB cable. So these are adapters for that.
Did you know how to use all this equipment that you were buying? Or
Yes.
did you? You did?
Yes.
Okay. You don't have this. Ask the,
137.
thank you.
Judge, the flash drive, I think is 137.
My apologies, 138. The building records, 136.
Did Judge McGinley ever deny a monetary resource request that you made?
Now I think Jim Simmons made most of those requests, but I'm not aware that he did.
All right. Did you file motions in the representation of Zach Adams?
I did.
You know how many?
No.
And again, you filed motions that we can see that are public record, and then you filed motions that were under seal, correct?
I think most of the motions that were under seal were for funds.
Okay. All right. Do you recognize what's just been handed to you?
No.
Take a moment, look through it. Does it look familiar?
Well, it doesn't look familiar. I recognize what it is.
What is it?
It is a listing of all the pleadings that were filed in this case.
All right. And is it both the ex parte and the non-ex parte?
Yeah, so for the ex parte motions, it just says sealed envelope.
Yes. All right, John, I've asked that be marked as the next numbered exhibit.
Exhibit 139.
How many discovery review sessions did you have? You've talked about the one where Jennifer Nichols wanted you to look through everything. You didn't want to look through everything. Then you did want to, that, I guess that was the first one. Is that correct?
No, I don't, I think you're mischaracterizing what I said about the discovery examination in the Middle District of Tennessee.
Okay. Where was it?
It was in the Middle District of Tennessee
Where in the Middle District of
at
Tennessee?
the TBI headquarters.
Okay. And all the defense attorneys were there. You were there.
Yes,
Was that the only evidence viewing session that you attended in the Middle District of Tennessee?
we might have gone back for one more time.
All right. Did you ever go by yourself?
Yes,
Okay. Did you ever go to an area other than the Middle District of Tennessee to view evidence?
yes.
Where?
I went to Jackson and to Memphis.
All right. And did you go alone or with every co-defendant's attorney?
I went to Jackson alone. I went to Memphis with other co-defendants attorneys, and I may have gone to Jackson with other co-defendants attorneys. So I may have gone to Jackson twice. I don't remember.
Okay. At some point, did you sit down with some of the state's experts? Did you ever talk to the state's experts, the medical examiner, the cell phone expert?
Yes,
You did.
yes.
And you talked with them. Was the state there?
I'm not sure if the state was there when we talked to the medical examiner. I don't think the state was there.
All right.
I think I can't remember if the state was present or nearby when we talked to the cell phone expert.
All right. Then the cell phone expert offered to help you, didn't he?
I don't think he offered to help me. He offered to explain things to me, explain his report to me.
And let you ask him questions.
Yes,
And in fact, you asked him some questions about Terry Britt's cell phone. Remember that?
I don't remember that specifically.
These motions that are part of the exhibit we just handed in, were all of those heard? Do you know?
I don't remember any motions not being heard.
Okay. Did you attend all of those motion hearings, or were there times that you couldn't get there and Jim Simmons handled it?
No, well, some of the motions for funding, I didn't go,
Okay.
but I attended all the motions of substance for the case.
The substantive motions. Okay. You were there, and if it was your motion, you're presenting it. If it was a state's motion, you're defending it.
Yes,
And I'm assuming, like in all cases, some of your requests were granted and some of your requests were denied. Is that accurate?
yes,
You testified that you met with the defendant throughout the course of this 10 times. Is that what you said?
I'm guesstimating 10 times.
Okay. He was in prison or in jail.
He was in jail, yes.
Right. And so you would travel there, right?
Yes.
Did you ever have access to him over the phone?
I didn't have access to him that the phone calls weren't being recorded, no.
And when you met with him, did you talk about the facts?
Sometimes, yes.
All right. Sometimes what did you talk about?
You know, I don't have specific memories of what I talked about when I met with Zach Adams.
Okay.
We talked about the case.
Well, let me talk then maybe just in general terms. He was not the first client of yours that you talked to in a jail setting.
No.
Okay. What does that look like? Do you go in,
You go
you're in
in,
a private room?
they take you to a room usually. Usually it's got an old table and a couple of old chairs in it, and you sit down. Maybe it has a plug so you can plug in your computer and you can go over things.
All right. And did you plug in your computer and go over things with the defendant in this case?
I think so. I don't have specific memory of that.
Did you plug in your computer and go over facts of this case with other witnesses?
Which witness will you be referring to?
I don't know. What other witnesses did you talk to?
You know, right now I can't exactly remember what witnesses I talked to. I talked to Lisa Autry.
Okay. Did you
No, I
go
talked
over
to-
things with her?
I didn't plug in my computer. I sat and talked to her and tried to see what she would tell me.
Did you take notes?
No,
Did you use your recording pen?
no,
Did you use the other thing you said that was, I don't know, connected to your head or connected to something else, your recording device?
What?
no.
Okay.
It's a GoPro. That's the name of the camera.
Okay. Did you use your GoPro?
I didn't use my GoPro. The investigator was there, and the investigator, I think, was taking notes.
Taking notes about what Lisa Autry said.
Yes.
When you met with the defendant, was an investigator there?
No,
Did you take notes with the defendant?
not much. No,
Not much or no?
I can't remember. I couldn't find any notes that I had taken with during meetings with Zach Adams.
Well, if you, when
He didn't have anything to tell you.
typically meet- Had you ever represented anybody before charged with murder in the first degree?
Yes.
Okay. How many people?
I don't know. Half dozen.
6 people. Okay. Were they incarcerated when you represented them?
Yes.
And when you met with them, did you take notes?
I would take notes. Yes.
But for Zach Adams, you can't remember if you did or not.
Well, Zach didn't know anything about the case. So if I'm telling him information, I don't need to take notes on what I'm telling him. And he didn't have any real information to give me about the case.
So he sat there in silence.
Well, we talked. We talked about what he wanted to do. We talked about what I thought the case was looking like.
Okay, let's stop right there. What very first time that you met with him, to be fair, would have been at the arraignment, right? The first time you met, or did you meet with him before the arraignment?
I might have met with him before the arraignment.
Okay. And at that point, you didn't have any discovery, correct?
Right.
You knew about this case, what the whole world knew about this case, right? At the time?
Right.
What was
She's already testified that she tells all of her clients as a practice, don't say anything to me yet.
being reported in the media?
Right.
You meet with him, you introduce yourself. Did you know him before this?
No.
You were hired because of his cousin in Atlanta, correct?
Yes.
Okay. So you sit down and you meet with him on, the death penalty's not been filed yet, the notice, correct?
No.
And you tell him you're his lawyer. Did you ask him questions?
Probably just to get to know each other questions, because at that time I didn't have the discovery, and I don't usually like my clients to commit to lies, because it really puts a barrier between me and the client if they've lied to me a whole bunch and said they didn't do something. At that time I thought he was guilty. And so I really didn't want him to come out and tell me I didn't do this, and then have to come back later and say, okay, I really was involved. The evidence, there's DNA evidence that puts me there. So
And if you missed the beginning of this stream, she was told by the state that there was DNA evidence that was going to point to Zachary Adams, but that they were still needing to do the tests, meaning when they told her that, they didn't actually have the DNA test results. So, but that steered the way she approached her client.
probably didn't talk to him much about the case. We talked about what was going to happen in the case. I'd explained to him what a preliminary hearing, not a preliminary hearing, but what an arraignment would be, what the case would look like going forward,
Hey, Erin.
and how it would be handled.
It's a process. Here's the process of what's going to happen.
Yes.
But you never asked him, where were you on April 13th, 2011? In that meeting.
I don't have a specific memory of that meeting.
Was it your practice to ask clients, where were you on the date of the murder that you're accused of?
After I got the discovery, it is my practice to ask clients that question, or to tell clients that the evidence shows that you were present. There's videotape of you being present at the apartment. And so let's talk about that.
Okay. You said that when you first met with him, you thought he was guilty.
Yes.
You were basing that on what, media?
Because I don't think the state would indict somebody that they had no like against.
Honestly, fair point. +1 for Thompson here. +1 for Thompson here. I actually think her approach is great. Wait till you get the discovery, and the example question that she gave. Hey, they have this evidence that suggests this. Let's discuss that. I actually think that's a great way to have a conversation with clients. I'm not an attorney myself, but I feel like that's a lot more productive and can keep from things getting messy. So
just the fact that he was indicted.
Yes.
You thought he was guilty, even though the laws of criminal justice say the exact opposite, that you're presumed innocent until proven guilty.
Well,
correct?
that's a presumption, and who has the burden of proof? That doesn't mean that the state has a habit of indicting innocent people.
Okay. So you thought because he was indicted, he was innocent, or guilty rather.
I thought there was going to be some proof that he was guilty. Yes.
Okay. We'll talk about it in a minute, but that was your presumption going into that meeting.
Yes.
Okay.
now that she spelled this out a little bit more, it still makes me feel like she might not have given such a vigorous, or I think there was a time period where she was competently trying to work this case. I'm following what Doug Bates is putting down, that as trial approached and things got messy, everything just kind of internally combusted for Thompson. But I think this is a very valid point that actually it's not a guilt or innocence issue. I expect the state to at least have some evidence if they're going to bring such a serious charge. And I think that's a fair point.
So, and then you start getting discovery, correct?
Yeah.
Later that year, yes.
Yes. All right. And you talked about how the format of the discovery was cumbersome and awkward and unorganized and all of those things. Did you leave it in that format, in that unorganized way, and just try to make the best of it?
Mostly, yes.
Okay. Did you have people on your staff looking through the discovery?
My paralegal did, yes.
Did
The
she,
investigators did, yes.
did she change the organization of it, or did y'all just leave it in the unorganized mess that you got it
We
from the state?
mostly left it in the unorganized mess it was in.
Okay. Why?
Well, because I didn't want to go in and change the way, I wanted to be able to have a copy of what the state gave to me.
Okay. Well, then what did you, all this equipment that you bought, what did you do with that?
Well, I copied it onto a fast hard drive because the hard drive that I bought at Office Max was so slow.
Okay. All right. And what you got from the state throughout the course of this case, or from the Tennessee Bureau of Investigation through the state, was exactly what the state of Tennessee got, right? Okay. You got
I
a
don't
mirror
know.
image of what they received.
That I don't know.
Okay. You also received discovery, I believe, and correct me if I'm wrong, you all also received discovery on each other's clients. In other words, I believe you got Jason Autry's information. You got Dylan Adams' information. They got your information. Is that correct?
That I don't know about.
You don't remember getting,
Well, I don't know what the other people got. So
did you get it?
Did I get some information about them?
Yes.
Well, I got a copy of Dylan Adams' statement.
Right.
So that was later. I didn't get it initially.
What about jail calls
I got jail calls from Dylan Adams, yes. And I got jail calls.
from Jason Autry?
I don't remember Jason Autry, but I remember listening to jail calls from Dylan Adams.
Okay. All right. You get the discovery. Then do you have other conversations with your client?
I can't specifically remember what conversations I had with him.
What did he tell you?
Well, he told me that he didn't do this and that he wasn't there on that day. He didn't go near Holly's house on that day. He didn't go take her. He didn't rape her. And then he didn't even know the girl. He'd never seen her.
Okay. Did he tell you I was in Parsons at 11:12 in the morning?
Yes.
He did tell you that.
Yes. He told me that they had pulled out, that they had gone to get gas because they didn't have enough gas to get to Parsons. So they'd gone to get gas at the interstate. When he was there, he had seen his grandpa, and his grandpa said, that morning I saw them pull into the gas station because the grandpa was going by for work.
But the grandpa didn't testify to that at trial, did he?
I think he did.
Continue.
That the grandpa had seen them that morning and had written it down in his date book that he had seen Zach.
No.
Okay.
No, that was not a question.
I'm sorry. Please continue. This is what Zach's telling you, correct?
But then they were going to go get some Xanax bars. He'd gone by to pick up Shane. They were going to go get some Xanax bars from Shane's drug dealer.
Mhm.
They had all piled into the truck. They'd gone into Parsons. They'd gone to the ATM to get money to pay the drug dealer from Shane's bank account. He said there should be a video of me
Okay, stop right there. When did he tell you that?
early on.
Okay, what's your definition of early on? 2014?
Yes.
2014, he tells you there should be video of me at the ATM.
Yes.
Okay.
And he said he'd also seen Tony Weber at the gas station at the BP. I think it was the BP. And that he had seen him there. And there should be proof that Tony Weber was at the gas station. And
There wasn't, was there?
not that I could find.
Right. Okay, go ahead.
Then they had gotten Xanax bars and gotten high.
Do you remember what time Holly was abducted?
She was abducted between about 7:45 and 7:50 on the morning of July 13th.
In the morning,
Not July 13th, April 13th.
April 13th,
Yes.
2011. When you talked to your client in these 10 encounters, did you talk about the things that he'd said to law enforcement?
I think at some point we talked about all the different things he'd said to law enforcement, but I don't have a specific memory of it.
Okay. Did you ask him why he was washing a mattress leaned up against the house?
I don't remember specifically what his answer would have been or if I asked him that.
Do you remember asking him why he was seen by law enforcement officers who were hiding in the woods to vacuum out a black pickup truck for an hour and a half. Remember asking him about that?
I don't specifically have the memory of that, no.
Do you remember asking him about the scratches on his arms that were seen?
Yes.
And what did he tell you?
He got the scratches on his arms when he ran through Briars, running from the police at Natchez Trace.
Okay, which proved to not be true, right?
No, I think that's true.
You think it's true,
Yes.
but there was testimony at the trial that it wasn't true, correct?
I think that Rebecca Earp testified that it wasn't, that he didn't have scratches on his arms, or I can't remember, maybe she did testify that he had scratches on his arms.
And the law enforcement officer that chased him.
Said he didn't notice it.
I'm sorry, what?
Said he didn't notice it.
Right, okay. And then months after, he told law enforcement officers two different versions of where those scratches came from. One version was he got them from moving all of his marijuana plants. Do you remember that statement?
No,
So you didn't ask him about that?
I don't remember that statement.
Okay. This top document is already in evidence. It is sorry, Your Honor. 118. Who was Brian Smith?
He's the investigator for SAI.
Okay, I'm gonna pass you this on top, and then behind it are about a 3-inch stack of IRs. Do you recognize what's on top?
All those IRs, but they don't let Terry Dicus, they don't take Terry Dicus's write-up and turn it into an IR. All those other IRs, but the one report they don't want to have on file is Terry Dicus's.
What's been previously marked as exhibit, what did I just say, 118?
I don't recognize it, no.
You've never seen that?
Well, I'm not saying I've never seen it. I don't recognize it at this point.
Okay, well, take a minute, look at it. Recognize it?
Recognize it, but I can tell what it is.
Do you recognize the IRs?
An investigative report.
I don't recognize the IR specifically. I recognize that they are IRs and they are labeled from this case.
Do the IRs that are listed in the Zach's original stupid mouth list correspond with the stack of IRs that I just handed you?
They seem to. The
right.
first few correspond. Wait a minute. Yeah, they seem to be corresponding.
All right, Your Honor, I'd ask that that collectively be marked as the next exhibit. The stack, the top document's already in evidence.
All right, so you said it's 140 is a compilation of all the IRs that are referenced within Exhibit 118, is that correct?
Yes, sir.
Let's pass it to Mr. Mason and take a look at it.
Yes, sir.
Is there witness going to be testifying about them?
No, sir.
We'll keep looking at that. If you have an objection, I'll let you make it later.
That's fine, Your Honor. Under Rule 1006, if it's a summary, the contents of the item summarized need not be introduced. So it seems like it's, Judge McGinley carrying the coals to Newcastle is unnecessary.
Well, how's the court going to reference it in this case? I certainly don't have any.
But that's the point of the 1006 summary. If it's accurate, if they say it's accurate, you don't need the originals.
That's not a summary, though. That's a checklist. Exhibit 118 is just a listing. It
I
doesn't
see.
summarize what the statements are.
I see. I know the courts had a courts had a very helpful understanding of the IRs. I just asked, are they seeking to introduce the IRs for the truth of the matter?
Yes, I'm seeking to introduce these because they were produced by her team under the heading of original list regarding Zach's stupid mouth. And it's all the IRs that support that statement for the lawyers to review from the investigators that were hired.
Mr. Bates,
And that,
every INR that's been presented has been admitted.
correct.
I'm confused as to why we wouldn't want these INRs.
The folder name.
Reports,
Yes, sir.
That's correct. That's fine, Your Honor.
Right, I'm gonna let it.
Thank you, Your Honor.
All of these, again, collected exhibit of many IRs.
Yes, sir.
Exhibit 140, and it is the IR representative listed in it.
So I think the state was trying to get something on the record that shows that counsel had a folder. His older counsel had folders for things they put together that this all relates to some statement somebody gave to some investigator that Zach said some sketchy sounding thing. But the judge is like, we already have all of these IRs anyway. So I think the reason Doug didn't continue to fight is doesn't matter if all the IRs are entered as an exhibit. And the judge isn't trying to make an exhibit out of a folder name. And maybe the state could have clarified, but I don't think the state is going to fight that battle. I think that's what happened. That's my impression of what just happened. The state wanted like a screenshot of the folder name or something on the record as an exhibit.
Did you have at your disposal the IRs in which your client interacted with law enforcement in the early days, weeks, and months of this investigation?
I think so.
Did you review those with him?
I don't specifically have a memory of that, no.
Did you review the IRs?
Yes.
Okay. Ask that 1, 2, 3, 4, 5, 6, 7 IRs. These are all just about 25, 18, 28, 16, 15, 18. Be passed to you, and I apologize, Your Honor, I don't have extra copies of those. Do you recognize those?
Yes, these are the IRs that were in the stupid mouth folder.
Yes.
Did you review those?
I'm sure I did. I don't have independent memory of it.
All right. Again, I'd ask that those be marked as the next numbered collected exhibit.
Exhibit 141, 7 IRs, collected exhibit. Be some sort of descriptive. What are these about?
These are the defendant's interactions with law, IRs reflecting the defendant's interaction with law enforcement.
You say, Mr. Bates?
Yes, Your Honor.
And if those could be passed back to the witness, I'm sorry. Assuming these are still in the order that I hope they are, is the very first one, IR 2005,
Yes.
April 16th, 2011.
I don't see April 16th, 2011 on here
I
anywhere.
have the date wrong, but is that the right IR number?
It's 2005.
All right, is it Warren Rainey?
Yes.
Okay. Is the next number IR 1919 from April 23rd, 2011?
Yes.
And is it from Matt Ross with the FBI?
Yes.
Does it reference the scratches?
Yes.
Okay. And then IR 199, 525, 1650, 1828, and 2018. Is that correct?
I think this is countering, and this is what I was waiting to hear a bit more about, and I'm sure Amy Wyrick will make her argument as questions move forward, but I really think this is going to will be heard on direct on the decision to not press on prior inconsistent statements, particularly with Dinsmore and Booth and the other investigator, Jackson, and any of the other investigators, because she's showing these IR reports right now. And if there's a folder somewhere that's named Zach's Stupid Mouth, that could go to indicate that there was trial strategy in the works hey, these are all the bad IRs. These are the things that we don't want to get onto the record, because even if we want to ask one question about something that's within one of these IRs, there's this other stupid thing notated in here that Zach also says that's going to open the door for the state to come up there and read out loud and get that bell ringing in front of the jury. So I think this is all a long-winded, there was a trial strategy, and the name of this folder indicates as much. And it was a choice and not just incompetence to not press on certain prior inconsistent statements.
Those are all the different IR numbers?
Yes, sir.
I don't know about that one.
Those are all the different numbers that she's holding.
Give me all seven. So I can-
Yes, sir. You got the first two,
2005, 1919.
then IR 199, 525, 1650, 1828, 2018.
I don't have 2018. Hang on. They're not in the right order. Okay.
You don't have it?
I found it.
Okay. Do you know when Zach Adams told law enforcement for the first time that he was at the bank,
No.
at the ATM?
No.
Well, surely, did you find something in the file where he said that?
Well, I don't now remember it. I mean, if you're asking me, I don't remember if I found it in the file, and I don't remember when he would have told law enforcement.
Okay. Did you talk to any of those law enforcement officers?
I did not know.
Did you have people talk to them on your behalf?
I think so.
And those would have been your investigators?
Yes.
How early on would you have started having conversations with the defendant about whether or not he was going to testify in his trial?
Late,
What does that mean?
like probably much closer to trial time, not this early on.
And what would you use to have that conversation with him?
I would probably use a lot of his past statements and his convictions to have the conversation with him.
So the things filed in the 609, is that what you're referring to? The 609 motion or notice?
What's the 609 motion?
The notice that would have been filed by the state of Tennessee, putting him on notice of his prior convictions. If he chooses to testify, they would use those in cross-examination.
So yes, I would have used that. And I would have used his prior inconsistent statements. But I don't think we really had,
Which prior inconsistent statement?
I don't think we really had conversations about whether or not he was going to testify.
So you just wait for him to answer Judge McGinley's question? You're as surprised as everybody else in the courtroom?
No,
Did you talk to your client about whether or not he was going to testify?
yes, but I think I talked to him about it in a negative form. Like, I don't think you should testify. I don't think we sat down and had a discussion about what would it be like if you testified.
And surely he said to you, oh, no, I'm testifying.
I don't remember that.
He didn't tell you that?
I don't have any memory of that.
Who got his mother and his cousin from Atlanta up here to talk to him
When?
about testifying?
I don't know.
Did they talk to him about testifying?
I don't know. I don't have any memory of that.
So when Judge McGinley, at the end of the state's proof, when Judge McGinley turns to you and says, will there be any defense proof? What did you do?
Well, yes, we had defense proof.
You had witnesses you'd subpoenaed, right?
Yes.
Yeah, Max, I think the judge is looking back perhaps at his notes on the direct on this line of questioning, the same client's decision to testify and your role as a consultant on that issue, but not the ultimate determinator.
Come in.
I don't remember now.
Because he's back a few pages.
What category did they fall into? You subpoenaed expert witnesses, right?
Yes.
You had a cell phone expert?
Yes.
I believe you had a gun expert?
Yes.
You put on Mr. Bell, didn't you, to say that white truck was parked at my property?
Yes.
That white truck could not have been used to move the dead body of Holly Bobo because it was parked on my land. You put him on, didn't you?
Yes.
He said all that. The jury heard it, right?
Yes.
You had him subpoenaed. You subpoenaed Terry Britt,
Yes.
but the state put him on.
Yes.
You subpoenaed Terry Dykus, a TBI agent.
Yes.
You subpoenaed a host of people,
Yes.
okay? So at the end of all of your proof, you put them all on, right? Except for Terry Britt,
Right.
okay?
I think so.
What other experts did you put on?
Cell phone expert, the gun expert. I don't remember any other experts.
And did you put on Alibi?
No.
Your defense was my client couldn't have done this because he was in Parsons. You didn't put on alibi?
I don't remember, Amy. I don't have a specific memory of that.
Well, who would the alibi have been?
Well, it would have, it wouldn't have been Shane and it wouldn't have been Dylan.
But you listed them as alibi witnesses in your response to the request for an alibi.
If we filed a response for request for alibi, then we filed it. I have no independent memory of that.
You listed his co-defendant, Shane Austin, and Dylan Adams. You listed Rebecca Earp, and you listed his grandfather, Dick Adams.
Okay.
Did you put his grandfather testify to the jury that between 8 a.m. and 10 a.m. on April 13th, 2011, Zach was helping me clean out the shed?
No.
Did his grandfather say that between 8 a.m. and 10 a.m. on April 13th, 2011, Zach was at work?
No.
Did his grandfather say anything about his whereabouts between 8 and 10 a.m. on April 13th, 2011?
At some point, I think his grandfather had seen him in a car.
What time?
It was after 10, I think.
Okay. Who testified and said, well, let me rephrase that. I was jumping around and I apologize for that. So you put on all your proof, put on all your witnesses, state cross-examines them all, and then the big moment, the judge looks at you and asks, is your client going to testify, right? And what did you say? I don't know, Judge, we haven't talked about it.
No, we had talked about it.
Or did you say, Your Honor, he's not? I can answer that for him. He is not.
I don't have an independent memory of it, but I think it's more likely that I said he is not going to testify.
And that was the end of the conversation?
Well, I think they do is it the Moman
Right,
exchange?
right.
So I think they did that.
They did that. And by that, you mean Judge McGinley put him under oath, right?
I don't have an independent memory of whether or not he put him on the stand. Amy, I just don't remember.
Well, you sat through Moman hearings before, correct?
Yes.
Okay.
Yes.
Is it your experience that judges swear the defendant in before they answer the questions about whether they want to exercise their constitutional rights to testify or not?
Yes.
Okay. Do you have any reason to believe that Judge McGinley did not do that in this case?
No, I'm not trying to imply that, no, he didn't do that. I'm just saying I don't have an independent memory of that particular time.
Okay. And Judge McGinley asked him questions, correct?
I'm sure he did.
Did you at any time, did you believe he was answering those questions truthfully?
Yes.
That he did not want to testify?
I think he did not want to testify because I told him he shouldn't testify.
Well, did he say that to Judge McGinley? You know, I'm being railroaded by my lawyer. I really want to take the stand and she's telling me it's a bad idea. Did he ever say that?
No.
Did you ever say to the judge, I do things a little differently. I like to tell my clients, you really don't want to testify. Did you say that to Judge McGinley?
No.
He questioned him and he answered the questions, correct?
Yes.
At any time did he say, stop these proceedings, I want to testify?
No.
At any time during the course of your representation of him, did he argue with you when you said, I don't think it's a good idea for you to testify?
I don't think so, no. I mean, he didn't ever argue with me, no.
About anything?
Not really, no.
Okay. Do you recall where he would have met with his mother and his cousin to have the conversation about whether he was going to testify? Would the judge have allowed them to take a break and do that? Do you remember?
Yes, I think the judge would have allowed a break or he would have done it at a lunch break or something like that.
Okay.
He could have talked to them in the courtroom. I mean, in the courthouse, they had a little room downstairs where they were holding him.
Okay. Before trial, had you ever discussed with your co-counsel or with lawyers for the state of Tennessee your client pleading guilty? Had that topic ever been broached?
Yes.
Okay. And at what point between 2014 and 2017 did that first conversation happen?
I think that when we went to the TBI in Nashville to view the TBI evidence, when I went with, I can't remember, but I think we were out at the TBI headquarters because we were eating Mexican food for lunch at a restaurant there on Nolensville Road. And I was with Paul Hagerman, and Paul talked to me about the client possibly wanting to plead guilty.
All right. And you said absolutely not, right?
No, I said, what are you offering?
Okay. And what did he say?
So
I can't remember now.
this is all a conversation involving Paul? Maybe there was a series of conversations. Because we know, like, Jerry had a conversation with Paul and believes that, Jim Simmons was present, but that he was not sure if Jennifer Thompson was present in the hallway after they'd already talked about it in chambers. But Nichols was there. Nichols remembers a different phone call, 3-way call. But I don't remember Paul being part of Nichols' recollection.
Exactly what he said. He said, a 20-year sentence. I think it was more than 20 years, maybe 25 years or 40 years. I can't now.
Okay. That's what Mr. Hagerman offered you. Was that your testimony?
He offered me a sentence that was equal to second-degree murder or higher.
Okay. And what did you say?
I always have to ask the client. It's never up to me to make the decision.
Did you
do that?
Yes or no?
I'm sure I did, but I have no independent memory of it.
Do you have any independent memory of what your client said to you when you approached him with the idea of pleading guilty?
I remember he didn't want to plead guilty, that he said he would say things like, Miss Jennifer, I did not do this crime. I cannot plead guilty to it.
Okay.
So it sounds like they had conversations about this, but not a specific conversation in relation to that offer. Because she went to speaking generally. Listen to how she starts speaking generally.
I'm sure I did, but I have no independent memory of it.
Do you have any independent memory of what your client said to you when you approached him with the idea of pleading guilty?
I remember he didn't want to plead guilty, that he said he would say things like, Miss Jennifer.
That he said he would say things like. That's speaking generally.
I did not do this crime. I cannot plead guilty to it.
Okay. I want a trial, right? That's what he told you.
Yes.
I want a trial. But can we agree that that is one thing he was consistent in? I want a trial.
Yes.
Did he ever waver from that?
Not with me.
Okay. What discovery had you shared with him at that point?
That I have no memory of. What discovery I would or would not have shared with him.
What's your typical practice? Would you go over the whole file with him?
Usually, if a client wants to hear the information, I would sit down and go over all the incriminating evidence that shows that they're guilty. But in this case, there really wasn't. I mean, we talked about stupid stuff Zach said with Zach and how that was going to get him in trouble. But there wasn't any evidence to sit down and say, listen, they have your DNA at the apartment or your fingerprints are on this knife. They had no incriminating evidence against Zach. And even the phone records showed that his phone was in different locations than Holly Bobo's phone.
Do you know when Holly Bobo was last in possession of her phone?
No.
Do you know where Holly Bobo was shot?
Yes.
Where?
At the cell tower, right up there where her body was found.
Were you there?
No.
What do you base that on?
At the
On
cell
my
tower.
Reading of the proof in this case.
That she was shot where her body was found.
Yes.
That's your opinion.
That's my opinion.
Who testified to that at trial?
Nobody.
Oh, well, good. This Amy just made her look incompetent as heck. Why? How does this help the state's argument against an ineffective assistance of counsel claim?
Reading of the proof in this case.
That she was shot where her body was found.
Yes.
That's your opinion.
That's my opinion.
Who testified to that at trial?
Nobody.
Okay. Do you know when her body was left there at the cell tower?
I think when the phone started moving again the second time, they had left Holly's body at the cell tower and he was driving back towards his home.
They shot her there and left her there.
He did.
Oh, yeah, he who? Mr. Britt, right?
Yes.
Okay. All right. Was there any testimony to that at trial?
No.
Okay. How long after she was abducted was she murdered?
I think within an hour.
Were you there?
No.
How do you know that?
This is my theory.
Okay. Does anyone else have that theory?
I think that some of the investigators had that theory with me at the time.
Some of your investigators?
Yes.
Okay. And Johnny Walker had that opinion for a minute, didn't he?
Yes.
That she was, he made some statement, didn't he? That she was killed within the first hour of being abducted, right?
Yes.
And then he was asked about that by Mark Lewis and some others with TBI to say, where's this coming from? Do you remember this?
Well, I don't specifically remember.
And he admitted, you're right. I don't know that. Nobody knows that. He admitted that. You remember that?
I wasn't there during this conversation with,
There's hours about it.
okay, well, I don't have specific memories of those.
Okay. Do you know when her phone was thrown out?
I don't know for sure.
Do you know when her SIM card was thrown out?
No,
Lunchbox.
I don't know for sure.
Okay. But you know she was shot at the cell tower.
My theory is she was shot at the cell tower. Then he began to drive back by a different route than he came. And that's the point when he started throwing stuff that was left in the car out the windows.
Okay. And you shared this theory with your client.
Probably.
Okay. And you would have gone over with your client incriminating statements that he made.
Yes.
Okay. Give us an example. What are some of the ones you remember being problematic?
I'm going to take you out and tie you up like I did Holly Bobo. I don't have the statements verbatim, but I'm going to do you like I did her, or I'm going to take you up and tie you out back like I did her. Things like that.
No body, no gun. Before her body was found. Before we knew she was shot. Remember that
Sure.
one?
Sure.
Couldn't have picked a prettier bitch. Remember that one?
Yes.
Do you remember him threatening to kill his brother?
No.
You don't remember there being information, evidence. You don't remember him being indicted
Oh,
for trying to kill his brother.
for what happened at the courthouse, the O'Brien, or the courthouse where he said, you tell him if he doesn't, he told a guy that was sitting there allegedly, you tell him that if he doesn't straighten up, I'm going to put him in a hole next to her.
Yeah, that one.
I remember that.
But that didn't happen.
I think people had a lot of motivation to make up things that Zach said.
I think, didn't
Okay.
they drop that?
Did Judge McGinley instruct the jury on witness credibility?
So I'm pretty sure we heard from Zach that charge that they're discussing right now was dropped. And even though that may not have been a case that she had to work directly, or like she didn't have to work it because it was dropped, that would have been a very good time to point out what the disposition, what the ultimate result of that was. But I don't remember specifically I just remember Zach pushing back against Amy yesterday when we watched, Thursday, but we watched it yesterday. Okay, Simpson says, yes, they dropped that along with a bunch of other charges along the way. So this would have been a great area. It's disingenuous for Amy to even be asking it this way. Amy Wyrick, not Amy E. But the pushback here would have been great. And hopefully Doug gets up there and is like, are you aware what happened with that indictment?
I'm sure he did. I don't have independent memory of what jury instructions he read.
Did you go over videos with the defendant?
I don't have specific memory of going over videos with him.
Well, you've testified that you never saw the ATM video. So let's park that on the shelf for a minute. There were lots of other videos collected by TBI in the hours and days following Holly Bobo's disappearance, correct?
Right, like the M Farm video.
Okay. And you had all that, correct? And in fact, you received the ATM video in June of 2015, correct?
That I do not know.
Object.
I have it on my hard drive now that Mr. Bates says is the ATM video, but I couldn't get it to open.
Okay, but you received it in June of 2015.
Okay.
No, I'm asking.
I don't
Does
have a
that sound correct?
specific. I do not have a specific memory of that.
Okay. I could have one moment.
And it's a limited time frame. Not the surveillance video that they end up getting.
Yeah. What am I doing? I'm gonna. And that's only in evidence, right? Yes. Okay. Can you find the exhibit number for me? And there we go. Thank you. What number is it?
He did admit threatening as kids and generally, but he said not that specific threat that was quoted to him. So saying Zach admitted on the stand, I think context is needed there because yes, but no. But good to see you, Els. Click, 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 clack, clack, clack.
What was it about?
Exhibit 128.
Digital evidence and master case law.
Yes.
Okay.
I asked that these be passed off. Can I pass these to the adjourned?
Is it 128?
And exhibit 17. Yes, sir. All right, you would take a look at those. The copy of the letter that I handed you from then Deputy District Attorney General Nichols and now Judge Nichols dated June 15th, 2015. You recognize that?
Seems familiar.
Okay, and what is it?
It's a letter from Jennifer Nichols to the defense attorneys with documenting that she's providing discovery.
Okay, Your Honor, I asked that that be marked as the next number of exhibit.
Mark exhibit 142.
What's the date of it? June 15th, 2015?
I think that was it, but I don't remember.
Okay. And if she could add it, pass it back to her, I'm sorry. It references in the first paragraph, well, it's a letter saying, please find attached here to one external hard drive and one disk, correct?
Yes.
Contained therein is discovery pursuant to Rule 16, as well as additional material provided. This is an index to TBI's investigative reports, IRs, contained on the disk. The IRs are numbered 1 through 2,986. The first IR refers to the initial complaint investigation and is dated April 14th, 2011. So what this is a letter reflecting that General Nichols was sending you all a hard drive and a disk that contained everything in those IRs, correct?
Yes.
All right.
Thank you, Sheriff Chuck.
And if you could look at exhibit 17, which is IR 1845. See it?
Yes.
You recognize it?
I don't specifically recognize it, but I can see what it is.
What is it?
It is an IR listing. The following is a list of CDs, DVDs, and flash drives containing digital media obtained during the course of this investigation.
Okay. And contained in there is the ATM video, correct? And I understand you said you didn't see it. But that's one of the things it's referencing, correct?
Well, I still don't see it
You don't see what?
where it says there's an ATM video. Okay, I see now 48V8 BP/Com South Bank ATM, April 2011.
Okay, thank you. And a minute ago or before the lunch break, you were shown exhibit
A minute ago.
128
They time traveled like
Which-
us.
was a compilation of digital evidence sent to you, I believe. Do you have that, Maddie?
Yes, I have it.
All right. Exhibit 128, you would agree with me, is not a comprehensive list of all of the video evidence you received in this case.
I don't know that.
Take a moment, and look at it. See if you see on exhibit 128, I believe you just mentioned it, the Am Farm video.
I don't see the Am Farm video in here.
Right, but you had the Am Farm video, correct?
Yes.
So that exhibit can't be a comprehensive list of all of the video evidence that you were provided by the state of Tennessee in this case, correct?
So it would seem.
Thank you. And I believe have all of those documents been appropriately marked into evidence?
Leave it at.
All right, very good. And we're done with those for the time being. And you also testified earlier that Jim Simmons subpoenaed videos, right?
Yes.
Okay. So you had what the state of Tennessee provided you, plus what you were gathering on your own.
Well,
correct?
I don't think we got videos when they subpoenaed them. I think they came back and said there's nothing available.
Right. Because it was some years that had passed, right?
Yes.
This happened in 2011, and
Yes.
you're not brought on until 2014, correct?
Yes.
3 years have passed. All right. If we could have put on the screen the ATM video that you were looking at before we broke for lunch. Still. Still. Yes. Who do you see in that?
Go on one. All right, you witness speed jump, exhibit 101.
Who's in there?
I can't tell.
Thank you. Do you know how many?
Okay, so we're gonna, nice picture, but we're gonna take a detour. We'll leave this pause right here. Jumping over to Zach's testimony when he's asked on cross-examination, when Zach's on the stand, he's asked on cross-examination by Amy Wyrick about what we just heard about the indictment for threatening his brother. Captions.
Yes, ma'am.
Okay. You were also indicted at some point for threatening to kill your brother, Dylan Adams, correct?
I don't recall that.
You don't recall being indicted for that?
Miss Wyrick, from February 28, 2014, you know how many times the TBIs came, they've dropped the charges, recharged me. I've been charged with so many things. I couldn't even tell you how many times y'all have dropped charges, recharged me, charged me with stuff, tampering with evidence, all kinds of stuff that never went to court over. So if you was to tell me that, I wouldn't. I don't recall, but I wouldn't doubt it.
The jury heard testimony that you tried to get Jason Autry to kill Dylan Adams, your brother.
Absolutely not. That's a total lie.
The
I
Jason-
love my brother with all my heart.
The jury also heard testimony that you got word to Dylan Adams that he better keep his mouth shut. Was that a lie too?
No, I did say that. I was upset, and that's the reason that all this happened is the lies that he told.
When Miss Thompson came to meet with you each time, you spoke to her, right? Like you answered.
I don't know if they
y'all talked. You got along.
I don't know if they continue with this. She's talking about subpoenaing witnesses to the trial. So there you go. There you go. Back to, I almost said real time, but we're rewatching Friday's hearing.
How many witness folders you made in preparation for trial?
No.
Over 200 made by you and your team. And you had a strategy, right? With all of this information, with these hundreds of thousands of pages of information, with endless hours of video, you had a strategy, correct?
I think we did.
And what was it?
Our strategy was to show that Terry Britt had committed the crime and not Zach Adams.
Right. Terry Britt did it. Some other dude did it, and his name is Terry Britt, right?
Sudi defense. Some other dude did it.
And if that's, and you also had the alternate defense of, and our client didn't do it, correct?
Right.
Was mitigation information being gathered as well while you're also investigating the facts of the case?
Yes.
All right. And who was there a point person on that?
Yes.
Who was that?
AK Investigations came on as mitigation when Lee Norton withdrew.
Okay. Why did Lee Norton withdraw?
I don't know. She said she couldn't take it.
Couldn't take it?
Yeah. I don't know why she withdrew. I think she didn't like the case anymore and she withdrew.
Could it be because she knew, as she put in a memo, that your client was going to be found guilty and it was going to be very hard to keep him off death row?
I don't
know.
remember
that?
No.
And that she said she would have to no longer work on this case because that bothered her so. Do you remember that?
No.
Did they put together mitigation reports for you? Your team?
Yes. But I think Jim looked at that more than I did.
Were you familiar with it?
No.
You never looked at it?
I can't say I never looked at it. I have no memory of looking at it now.
Well, do you have memory of there being concerns about mitigation proof?
No,
No memory of anybody bringing to your attention issues with mitigation proof?
no,
Do you remember your client shot his mother?
yes,
Okay. Do you remember that being something that they pointed out?
no, but I see that that's a very bad factor.
Okay. Do you remember them having concerns about the mitigation because of his criminal history?
I don't have any specific memories about concerns about the mitigation. It's not that I didn't know it at the time, but at this point, I have no specific memory of it.
Okay. Because I guess your role was different. Your role was guilt innocence, and Mr. Simmons' role was the mitigation. Is that
Yes.
a fair assessment?
Fair.
Okay. Who's Crystal? Crystal and Danny.
Danny is one of the investigators.
I'm going to ask that this packet be passed to you, and there's a copy for the judge. See if you recognize this, Ms. Thompson. You recognize it?
No,
Who's JST?
it might have been Jim's daughter.
You've never seen this.
I don't have any memory of it.
We'll take a minute and look through it. Does it look like anything having to do with this case? Did you ever have conversations about any of these things with the team? Spoke with Joe Walker, stated Zach shot Cindy because she wouldn't give him money. Dick Adams, Frankie Cecil Adams. I mean, are any of these names ringing a bell?
I think Frankie Adams was Zach Adams' uncle.
Is the information in this document ringing a bell with you?
Some of it is, some of it's not.
Do you question the veracity of this document that I passed you?
No,
Was Jim Simmons' daughter, I believe her name is Miss Tarkington, right?
yes,
She was on the team.
yes,
Did she gather information?
I'm sure she did.
Did she bring that information back to the team?
I'm sure she did.
Well, you were on the team, correct?
Right.
Okay. So did you ever have any conversations with her
I don't remember having a conversation with her about this.
about anything?
Yes, I had conversations with her
Okay.
about this.
And Crystal is who?
I don't know who Crystal is.
Who's Danny?
Danny's the investigator.
All right. Your Honor, I'd ask that this be marked for identification at this time.
Thanks.
No objection for identification.
For identification, we mark it exhibit 143.
Did you ever ask your client about some of the mitigation concerns, about the shooting of his mother?
I didn't ask him about mitigation concerns, no.
Okay. Did you go over his 609 with him?
I
We're
don't have
going
a
to
memory
call
of that, no.
Simmons.
Okay. What about his 404?
That's prior. Bad
I don't
character.
specifically remember going over 404 with Zach.
Okay.
All right. That's if they don't call Jim Simmons, I feel like the state might actually call Jim Simmons. I think in December we're going to get into the state kind of doing their like what would be a case in chief for the sake of these proceedings. But if we don't have a discussion on potential mitigating factors or what could be aggravating factors as far as a sentencing phase, a penalty phase of the trial, before we have Zach making a decision, if he was even directly provided the information on the offer that the state was willing to make for the 20 or 40 years, Thompson didn't seem very sure to recall what the offer was. Wasn't sure if she had a specific conversation about the information of that plea offer with her client. But all things considered, if we don't have an informed discussion on mitigating and or aggravating factors that could be presented during the penalty phase, can't really make an informed decision about the plea that's on the table at a different moment in time. So
Testified earlier that pretty early on, you had a plan regarding Terry Britt, right?
Yes.
When? Starting when?
Oh, I think starting sometime in the spring of 2015.
Did that ever change?
No,
He was a good target, right?
yes,
Here's a sex offender that lives down the road.
yes.
Right.
They had been stalking blonde hair, blue eyed girls
Right.
in the same neighborhood.
Right.
Yes.
He was a good target to put this on.
Yes.
And you built a defense around that
yes.
with the added layer of our client didn't do it either. Correct?
Right.
Okay. You testified a moment ago about meetings that you all would have as a team, correct?
Yes.
Were they held in your office?
Yes.
All right. And who would typically attend?
My paralegal, 2 or 3 of the investigators. We had 3 investigators on the case, but I really think only 2 investigators were working diligently on the case.
Okay.
I think the third one, she was more the owner of the business, and I don't think she was really working on it. And sometimes Jim Simmons would come.
Okay. And did you all work from, did you just sit around and spitball, or did you have kind of an organized format to these meetings? What set the stage for us?
I think it depended, and I don't have any specific memory of the meetings at this point.
Okay. I'm going to ask that a document titled Global Case Goals be passed to you, a document titled Global Task List in red be passed to you, and a document titled Global Task List 1 in blue be passed to you, and ask if you recognize those. And I have a copy for His Honor. Do you recognize those?
They look familiar.
I'd like you now to listen to an audio recording.
We can handle these.
Oh, I'm sorry. Yes, sir. As an X3 numbered exhibit. I'm sorry.
No, if I can just get the order figured out.
We can just make them a collective exhibit.
Whatever's easiest on the court and the court reporter.
Collective exhibit 144.
Just short.
This is all Judge, for the record, I'm going to start this audio at 13 minutes and 48 seconds.
All right.
Do you recognize?
Okay.
Do you recognize your voice yet, or is it
I
not?
do.
Okay. Who else is there? Do you know?
Sounds like Jim Simmons.
So all of that's been incorporated in what you're doing. Right. Okay, let's just, I want to make sure we all agree as to what we're going to focus on because we have such a short time frame. I think, Lee's also really made this impression and she had a lot of influence on me.
Is that Lee
We
Norton?
need to finish the Terry Britt investigation.
I'm sorry. That's Lee Norton that you're referencing?
Yes.
Okay.
I know that under almost all circumstances, you don't try to prove who did it. You try to just create doubt. But in this case, because this is it's a different case altogether. It's got so much notoriety. Zach is hated. Everybody in the whole area knows about this case. They've all been keeping track of it on topics. That we really need to show that somebody else did it. Just to show that Zach couldn't have done it, I don't think it's going to be enough. I think that the jury's not going to have a trial and not convict somebody. Somebody's going down for this. And they're not going to walk out of the courtroom unless they're confident they know who did this. Just a whole bunch of mystery and reasonable doubt is they've got to solve this case for the family. I really, really think there is good evidence that Terry Britt did do this. And Zach did not do this because he has alibi evidence that shows he was in another place at the time.
Stop it right there.
First, the thing on Facebook.
What evidence?
I can't remember now. I'm sure what we had talked about. His cell phone he was on Facebook at 8:30 in the morning.
Who testified to that?
Nobody I did not put that proof in at trial.
Okay. Did the state put on Facebook proof?
They put on some Facebook proof, but not Facebook proof that he had been modifying his wall at 8:30 in the morning, but there was records in the discovery that I received that at 8:30 in the morning, he had modified his
arguing.
wall and said something like, that bitch ain't all that, referring to Rebecca Earp. And it had been done from a landline telephone number at Zach's grandmother's house.
There was also
Like dial
evidence
up?
that he had been on his phone before 8:30 in the morning with Jason Autry, right?
Yes.
Hit play.
Hey, Aaron, here's your paper. They're all just.
Yeah, I was just about to say, I was waiting for a good pause here. Sheriff Chuck, you beat me to it. Says, well, you should have put that in at trial. State just added to her not doing a good job. So we're listening to a recording that's before trial took place, planning on strategy, but then we abandon the whole strategy when trial's taking place, which is consistent with what Jerry Gonzalez, his whole impression of what was going on when he stepped into the case was.
There. First, the thing on Facebook and his phone records, plus they have receipts from what they were doing that morning. So we know.
Where are those receipts?
I think that we have the ATM records from things that they were doing
That show what?
that show that they had been to Sonic and to the ATM.
But they weren't timestamped, right?
Timestamp, no.
So that's not really an alibi, is it?
No.
That
It really, and I feel like this is a trap that attorneys fall into. This isn't exactly the type of proceeding. This isn't the right vehicle to relitigate the case, to relitigate the trial. And I feel like that's a little bit of what Amy's doing here. And what I'm thinking of is Amy's no stranger to the media. I think some of what she's saying here might be because she knows that people, especially people that might be new to this case, are watching. So maybe she's either falling into the trap of relitigating something where this isn't really the time or place to relitigate the facts of the trial, except to discuss points of argument, a petition for a new trial that relate to evidence that wasn't presented to the jury. But also there's a lot of attention on these proceedings. So
down this way. And so I just think in this case, we've got to finish the Terry Britt investigation. And the more we dig into this, the more we are going to find. And the more it's really, because this incorporates a lot of our goals. One, it makes the state look foolish and silly. Like they are absolutely incompetent and can't do stuff. It makes, it gives them someone to blame and someone to hang their hat on, so the jurors don't have to walk out knowing there's still a deeper mystery for the family. They get closure. And I really do think that this is the guy that did it. I mean, this also brings justice. Not that it's our job to bring justice, but it brings justice. And we can, and even if our guy confesses under oath to being the guilty person that did this, if we can show that that confession cannot be true because Terry Britt did it, the jury's not going to get hung up on some stupid shit he said to Ben Hendrickson.
We'll proceed to justice with jury.
Yes.
Exactly.
Yeah. So do we agree?
Danny is our focus point on Britt.
But do we agree that that's really the way to go, Jim?
I think we have to be careful not to convince ourselves that Britt did it, because right now we have a lot of smoke, but we don't have any concrete evidence that Britt did it. We don't have any DNA. He's got some sort of an alibi. I think we have to be careful going there, because it's easy for us to say that Britt did it, but what proof we had that he did it?
Maybe it's as simple as not always.
We've got to complete the investigation, but right now, what I think we have to do is make sure Dykes is on board.
Maybe it's kind of like not always getting that mind frame, so to speak, like Danny's gonna be focusing on that. But same time, I agree, if we're gonna have to look at it as, hey, what if our guys did do it? Let's make sure we don't miss something here. You know what I'm saying?
Right.
I mean, you know what I'm saying? Just make sure we don't.
That's Brian Smith talking.
Brian's
All right, I don't so much. Okay.
Sales here, but two folks on hung up on.
No, how many more minutes? All right. And we would ask that that be marked, Your Honor, and we'll take care of the mechanics of that at the break.
Right. Exhibit 145, audio recording of strategy meeting of Mr. Adams' attorneys.
What day was that audio recording on?
I don't know. We can't tell. What other audio recordings were there that disappeared?
There were multiple other audio recordings made with that same pin.
Where are they?
I have them stored on my Mac computer, my desktop. And I thought that I had them stored inside the Dropbox folder, but they were not stored inside the Dropbox folder. And when the hard drive crashed, I lost it all. Everything in Dropbox was backed up, but the other things were not.
But everything else in the file of Zach Adams is fine.
It was
That's the only part
on a
that's
different
missing.
hard drive.
Just your recorded conversations with your client and all the witnesses and co-defense, co-counsel, those are all lost.
Yes.
Did you have a file that was labeled Zach Adams didn't do this? And here's why.
I can't remember.
The documents that I've handed you, the global case goals, was this kind of a your manual, how you went about putting your case together and working the file and gathering and checking information? What is this?
Yes.
Okay. The blue document, global task list, Terry Britt did it. Self-explanatory, correct?
Yes.
This is what the team was working on to show that Terry Britt did this, right?
Right.
Was this the execution of the idea that Lee Norton planted in your head to finish the Terry Britt investigation?
Yes.
Okay. And so this document became the footprint or the manual for doing that, the blueprint. Correct?
Yes.
Okay. And then the red document, Zach Adams didn't do it. Correct?
Is that a question?
Yes, that's what this is.
This
red.
red document is that Zach Adams didn't do it? Yes.
And the same thing. You've got witnesses listed there and dates and information. And did you follow up on that?
I have no memory.
Did you gather information to show that your client didn't do it?
I have no specific memory of that.
You have no memory of finding any information that would prove your client's innocence?
I have no memory of what information we gathered and whether or not we gathered information based on this chart right here.
Okay. Well, put the chart aside. Do you have memory of gathering information to show your client could not have done this?
No. The problem is if it's hard to prove a negative. If somebody didn't do something, like if I say to you, you know my birthday, it's hard for you to prove that you don't know my birthday. I can say, you know my birthday, and I can say, because on my birthday, you sent me a card. So it's easy to offer proof that somebody did do something. But if it's negative, it's hard to find proof that somebody didn't do something.
Did you gather proof to show that Terry Britt did do it?
Well, yes, we went through and prepared what Terry Dicus had gotten together.
Mm-hmm.
We solidified that, but I don't think we found additional information that Terry Britt did it, because at that point I didn't have law investigation authority to go in
and all you have to do is convince one juror, right?
Yes.
How long did the jury deliberate?
I don't know. I don't remember.
Does 2 days sound right? They were out a long time, weren't they?
They were.
Would it surprise you to learn that your trial prep file alone was 9.8 gigabytes of information?
No.
11 hours that you spent compiling witness folders? Does that sound right?
Sure.
2,000 individual files on your client alone, correct?
Okay.
But not one file on anything that he told you. Is that your testimony today?
I don't have any memory of that. If it's not in there, then you would be telling me, because I don't specifically remember what's in the file and what's not in the file.
You subpoenaed over 80 people to trial. Does that sound about right?
Sounds right.
You had 4,500 individual files alone on Jason Autry. Remember that?
We had a lot of material on Jason Autry.
You mainly dealt with Mr. Hagerman, didn't you? Wasn't he kind of your point of contact within the Shelby County DA's office?
Who I specifically talked to,
Mhm.
I would have talked to Paul.
Paul Hagerman, right.
Yes.
Was he pleasant?
He was pleasant.
Okay. You've testified that Miss Nichols wasn't pleasant to you, but Mr. Hagerman was, right?
Mr. Hagerman was pleasant.
Was there any time that you asked for something from the state of Tennessee or from the Tennessee Bureau of Investigation that they said no?
I think I asked them to sit down with me and show me what the discovery was. Tell me about the discovery.
You had the discovery.
But tell me what it was in there, what the different things meant and what the different parts meant. And I think they didn't want to do that.
Okay. Do investigative agencies and prosecutors' offices always do that with you?
Always do that? No, sometimes yes.
Okay. And was there ever any request for that you sent for discovery that was denied you?
No.
Okay. Do you know how many hours you billed for this case?
I don't have any specific memory. No.
Would the figure 2,870 surprise you?
No.
You kept the defendant off death row, didn't you?
Yes.
You and Mr. Simmons and Mr. Gonzalez. That wasn't an easy task, was it?
No. Every morning before trial, I would get here early and I would take his clothes downstairs that he was to wear. I would iron his shirt the night before. So I was ironing his shirts, or I took him to the cleaners here in town. I would go downstairs and he had these terribly dark circles under his eyes, and I would put makeup on him. I had bought special makeup just for him, and I would put makeup on him under his eyes to hide his dark circles.
Every day.
Every day I would do that.
And then after the verdict came back, you began talking with the state about the second phase, right?
Yes.
About taking the death penalty off the table, right?
Yes.
And you accomplished that, right?
Yes. At first they offered to take the death penalty off the table, but without any right of appeal.
And you even got them to change their minds on that, right?
Yes. I advised Zach that if he had gone through with the death penalty, he'd at least have 2 attorneys working for him on his appeal. But if they took death off of the table and took away his right to appeal, it would really be in a bad situation if he's saying he's not guilty. And so they agreed that they would do, and I think that's a lot of the Bobo family. I was very grateful for that. That they would take death penalty off the table. He would retain all his rights to appeal, and he could plead guilty. Not plead guilty, but they would sentence him to life. I think it's life without parole.
Right. You thanked the Bobo family after trial, right?
For taking the
For
death
allowing
penalty off the table. I mean, they were very gracious about that.
Right.
Yes.
But the state had to agree too, right?
Right.
Okay. And you even told Eva Pilgrim with 2020 how thankful you were to the Bobo family
Yes. I
for
don't
taking
think
the
it's
death penalty off the table.
It's not the Memphis DA's office that took the death penalty off the table. It was the Bobo family.
Say that again?
It's not the Memphis DA's office. It wasn't their idea to take death penalty off the table. I think it was the Bobo family that took it off the table.
That's your testimony.
Yes.
The Bobo family stood before Judge McGinley and said, we're taking the death penalty off the table.
Well, the family has to agree to it, but I think that it was really coming from the Bobo family.
Family doesn't have to agree to it.
No, I
Correct?
said the DA has to agree to it. That's what I
Right.
meant to say.
You said the family.
I misspoke. The DA, of course, has to agree to anything.
And the
But-
4 assistant district attorneys assigned to this case agreed to it, right?
Yes.
They're the ones that went to the Bobos with the proposal, correct?
I don't know who went to whom with the proposal.
Did you go to the Bobos with the proposal?
No.
Okay. Each day after court, Mr. Hagerman would advise you and your co-counsel of who the witnesses for the next day would be, wouldn't he?
Sometimes. Not every
Sometimes?
day.
Okay.
Not every day. Sometimes they changed it. Sometimes they didn't tell us.
Well, sometimes things happen with witnesses, right?
I think they intentionally weren't giving us
Okay.
people that were going to be testifying the next day or several days in advance.
Okay. So when if Mr. Hagerman's recollection is that, with the exception of Jason Autry, and he made that clear that they were not going to tell you when Mr. Autry was going to testify, that they told you each day who to focus on and who not to worry about the next day. Because the list of witnesses was long, right?
The witness list was 200. That's
Right.
why we had 200 witness files.
Right. Right. You cross-examined many witnesses, right?
Almost all except for 4, I think.
Almost all except for 4. All right. You remember Brian Vitt testifying?
What did he testify to?
He was the TWRA agent who was actually out mowing his lawn the day that Holly was abducted,
Yes, I remember him testifying.
like Mr. Autry had said. Remember that?
Yes.
Okay. And he did testify at trial. And you cross-examined Mr. Autry at great length, correct?
Yes.
You brought out many aspects of what was troubling, inconsistent, concerning with his testimony and his credibility, correct?
I really wasn't able to break him from his lie. He really stuck with it.
Okay. But you questioned him extensively about inconsistencies and about his record and about his credibility and about what he was telling the jury, right?
I did.
Okay. And his story never changed, did it?
No.
And in fact, you pointed out to the jury that he had a federal immunity agreement, right?
Yes.
Right. And you also went into great length cross-examining Victor Dinsmore. You remember that?
Yes.
You cross-examined him about, was it the 3 different statements that he gave to law enforcement?
Yes.
Right? All of that was heard by the jury, correct?
After I've gone back and listened to it, it was not effective what I was doing.
Did you cross-examine Victor Dinsmore about his prior inconsistent statements?
Yes, but
Okay.
I couldn't get him to admit that he had made prior inconsistent statements or not.
Well, are you
not well.
always able to get every witness to admit everything you want them to?
Usually,
Really?
yes.
Okay. And you also cross-examined Brent Booth extensively, right?
I did.
And you cross-examined witnesses about Dennis Benjamin, correct? About his relationship to Dylan Adams in this case. That all came out. The jury heard all that, correct?
Some of it, yes.
There was a hearing in front of Judge McGinley about the Luke Evans issue, correct? You
Yes.
wanted Luke Evans to come on the case. The state opposed it. We bring it to the court and we let the court decide. That's how this works, right?
Yes.
And was there testimony?
Yes.
Who testified?
Luke Evans.
Who cross-examined him?
I don't know.
Was it Ms. Nichols?
I don't have a memory of that.
Okay. The judge denied your request, correct?
Yes.
And you appealed that, right?
Yes.
And where did you appeal it to?
The Court of Criminal Appeals in the Western District, I believe.
And what did they say?
They said no.
They affirmed Judge McGinley.
They affirmed Judge McGinley.
Did you file a motion for new trial in this case?
Yes.
How many grounds?
I can't remember.
56? Does that sound right?
Okay.
The things that you have shown a light on here today, did you bring those out in your motion for new trial?
I don't remember. I just don't have any memory of this. This is all so many years ago, and I just don't remember specifically what was in my motion for new trial.
Did you work on the appeal?
I did.
Do you remember that?
Yes.
Okay. Did you raise these issues in front of the Court of Criminal Appeals?
I don't remember how many of them I raised.
Were any of them granted?
No.
Were any of the grounds for the motion for new trial granted by Judge McGinley?
No.
Do you remember Marco Ross testifying? The
No.
medical examiner, I'm sorry.
The medical examiner?
Yes, ma'am.
Yes.
And I'm sure he was on the stand for quite some time. Is that fair to say?
Yes.
And do you remember his testimony? He was asked by, I believe, Mr. Christensen. Direct examined him. Do you remember Mr. Christensen?
Yes.
Okay. He direct examined him and said, well, actually, this is Dr. Ross answering. What a .32 caliber bullet is, by my understanding, has a measurement diameter of 0.32 inches. Do you remember this testimony?
I don't specifically remember it.
By converting to inches, the size of the defect in the back of the skull, that's about a 0.36 inch defect. You remember this? It's in the transcript. Do you remember this testimony?
Page number
1147.
I did go back and review his testimony before I came to testify today.
Okay, so you remember this.
I don't remember specifically question for question, but yes, I remember them talking about the diameter and the size of the bullet diameter converted to English, not from metric to English measurements.
Again, what page?
1147. May I continue, Your Honor? By converting to inches, the size of the defect in the back of the skull, that's about 0.36 inch defect. So anything 0.36 or smaller could have caused that defect. So that would be consistent with a .32 caliber bullet causing that defect. This is Dr. Ross testifying in front of the jury.
Yes.
Okay. And then General Christensen follows it up with, so anything larger than a .36 would likely not have caused that wound.
Yes.
You remember General Christensen's question, and do you remember Dr. Ross's answer?
Yes.
He said, correct. Anything larger than .36 would likely not have caused that wound. You mentioned earlier today Ms. Nichols' closing argument. Do you know exactly what Ms. Nichols said to the jury?
I don't have any memory of exactly what she said.
0.38 was excluded because the defect
Good
was
dog.
0.36 or smaller. That's what she said. That's consistent with what Dr. Ross testified to, isn't it?
I don't have independent memory. I mean, you're telling me what he said. I don't specifically remember what numbers he testified to.
Do you take issue with the transcript and record of the trial of State versus Zach Adams?
No.
Do you agree with me that 0.38 is bigger than 0.36?
Yes.
I love that this is our second trial. We're like, look at Doug.
You testified earlier how co-counsel made you feel. It wasn't a great working relationship. Is that fair to say?
Fair to say.
Your opposing counsel.
Okay.
All right.
Same there.
Okay. It's fair to say this case was stressful
Yes.
for everybody involved.
Yes.
Starting with the morning of April 13th, 2011 in the Bobo family and continuing on until today, correct?
Yes.
And you testified about your concerns about the other defense attorneys, Matt Maddox and Paul Bruno and Michael Scholl and Robert Paris, and that they just weren't putting in the hours that you were, right?
I think I said that I didn't think they had shut down their practices. I didn't say they weren't putting in the hours. I don't know what hours they were putting in. I said they hadn't shut down their practices and gotten rid of all their other cases. And I said I didn't think they knew the discovery like I did.
And that's probably fair. I think the testimony in this court over the last several months is that nobody knew this file better than you did. Were you ordered to shut your practice down?
No,
You made that decision.
yes.
You further testified before the lunch break that one of the reasons you didn't get off this case was that you were worried Judge McGinley would appoint an attorney that would plead Zach Adams guilty,
Yes,
right?
yes.
That's not how our criminal justice system works, though, right?
Of course it is. I mean, I don't know what you mean.
That a defense attorney can come in and plead somebody guilty without the client being there and being a part of that and being questioned by a judge.
Defense attorney has great influence over their client and whether or not they plead guilty.
Okay.
They don't have the final say, but they have great influence. And I think Zach could have been easily pressured into pleading guilty if I had been so inclined to push him on it.
Have you pressured anybody to plead guilty before?
I've had clients where they really needed to plead guilty, and I did really put a lot of pressure on them to plead guilty. It's ultimately their decision.
It's ultimately their decision. Have sometimes they made what you thought was the right decision?
Sometimes.
And sometimes they don't, right?
Sometimes they don't. Yes.
And you additionally said that you had concerns about Judge McGinley.
I think both of them are a mess right now.
And that he was going to make sure, no matter what, that this
It's the
case
sausage
ended in a
being
conviction.
made.
Isn't that what you said?
Yes, I think that's true.
Is that a backhanded accusation of jury tampering
No.
against Judge McGinley?
No, I think he was just going to make sure that the proof came in and that he guided the proof and that he.
You said an elected judge was going to do whatever he could to make sure someone got convicted. Is that your belief?
I think that.
How is this an issue? Why are we doing this? Tell me what's an issue here. For what purpose?
For credibility, Your Honor. It's an outlandish statement.
And the court can take that into consideration.
All right. May I
Is
ask
it
one follow-up
outlandish?
question?
One follow-up question.
Did you report him?
No, and I never said that I thought he was going to influence the jury. I didn't mean it that way.
You still have the case of Zach Adams listed on your website. You've testified in front of Judge Bradbury that you did not provide constitutionally sufficient representation to Zach Adams in the final year of your representation of him. Is that right?
For 6 months, 8 months.
Did you report yourself to the Board of Professional Responsibility?
No.
Nothing further.
Thompson, you need
No, I can go longer.
I do.
I can go.
Yes, sir. Look at this.
Oh,
5 minutes?
5 minutes.
5 minutes.
All right.
she's ready now. She's like, please, now that Amy's done with me, I'm fine.
Is this Mr. Bates' book?
I do think the website thing makes her look stupid. It's just like such a give me, even though like I don't think, me personally, I don't think the point lands because people will put whatever and tell you all the good parts about the things that they did. Like, hey, I used to work at this company. It's a great company. Hire me again. And they don't really put the reason they stopped working there, you know. But still, it's just such a give me. You're going through this high profile proceeding, post-conviction proceeding, and your website's right there saying you are making it your #1 example of the work that you do. We got a nice zoom in on the woodwork.
We're going to wait on our court reporter.
There we go.
Did you take your time when you were ready?
She ran all the way. I'm ready, Judge.
All right, Mr. Bates, are you ready?
Thank you. Witness be passed exhibit 46, please.
46.
46. Ms. Thompson, do you identify this exhibit 46?
No,
Okay. Have you ever seen it before?
well, it doesn't, it looks like something that I might have gotten from a CLE or something, you know, the forms that you kind of fill in to, so it looks like the theory of the case is innocence, strategy, to do, disprove confession, establish alibis, Brit. So it looks like something that I would have put together, somebody in my team put together for the case.
In the recorded meeting, you said words to the effect, it's not enough just to show Zach didn't do it. We need to establish Britt did.
I thought that in this case, because it was so highly charged, that yes, it was going to be important to show somebody else could have done it, not just that Zach didn't do it.
You had 3 goals of established alibis or to-dos: bank records / video, cell phones of Zach Autry Dillon, and text messages.
Yes.
In discovery, did you receive document I'm handing you, IR 2015? And page 2, final paragraph.
While she's looking, we'll mark it exhibit 146. This is IR 2015.
Okay.
All right. Where R. Austin recalled Shane used Community South Bank at that time and gave agents the account number with the account. Also provided agents with a withdrawal slip of Shane's from this bank.
That's huge.
Why?
Because the state had the evidence that would have shown a timestamp on it, and the state didn't turn it over.
Can you look at exhibit 23?
I think this is going to sanctions for misconduct, not just for the failure to disclose, but also pointing out that there would have been a reason to withhold the a working file of the BP file that was disclosed. But in addition, once the defense found out, once the petitioners found out that the file, the video file from the BP was just short in duration and they needed a longer time and they needed to go try to acquire the full video, a longer video, they were fighting them on the subpoena and then sidestepped and did their own little secret subpoena. So, yeah. But if the state can get up there and say, no, we turn this over in discovery too, then we're back to just failure to produce at trial. Which would be on Thompson.
You recall that?
I don't specifically have a memory of it, no.
And you're looking at IR 2743.
Yes.
Is there any reason to believe you didn't have this at your disposal leading up to the trial?
No.
And if you look at the end where it shows withdrawals and other debits, POS purchase at Mapco, Parsons, Tennessee, POS purchase at Shell Service Station Holiday, ATM withdrawal Community South Parsons, Parsons, Tennessee. It also has on the page before that $6.78 from Sonic, $9.84 at Shell Service Station. Do you see that?
Yes.
You had these at your disposal, did you not?
I guess I did. I don't see that they have a timestamp on them.
You had Shane Austin's cell record showing him at 11:16 in Parsons, correct?
Yes.
You, of the three established alibis, number one, bank records. You never even had Joe Walker under subpoena, who issued a judicial subpoena to the bank to merely bring what he received. Did you?
This receipt right here says 04/11/11 on the back of it.
Right. The bank record shows there was also an ATM withdrawal on 4/11. Look through on page 5. Do you see that?
Yes.
She was looking at the earlier part of the
Do
statement.
you have any excuse for not introducing this to the jury?
No, I don't think it shows. It's not quite the smoking gun.
You had the records that show that they were in Parsons.
Yes.
You had Joe Walker say that the other places were not covered by our videos.
Yes.
You could have.
Guys, and what I think just happened there, she has like a full like packet, and it's the bank statement with like transactions going back what seems like all the way to at least 2011, and she was looking at the wrong page because she didn't go to April of 23rd or April 13th. She was still looking a few days previously. So that's why you see her like, he says go to page whatever, she goes to that page, and then now she sees what would have been the correct day to be looking at, 4/13/2011, rather than 4/11/11.
Subpoena Joe Walker to come to court and vouch for what he reported on September 30th, 2014, correct?
Yes.
Consistent, are these records consistent with your understanding of where Zach was, where Shane said he was, where Dylan said he was throughout your representation?
Yes.
And it never got to the jury, did it?
No.
Thousands of hours of work, right?
Yes.
Leading up to telling the jury your best evidence.
Yes.
Did you do it?
I suppose not. Not if I didn't. Well, yeah, I mean, this doesn't exactly say what time they were there. phone records show that Shane's phone was in Parsons, but the bank records don't say what time they were at the bank. The ATM information would have been more helpful.
He's half trying to blame it on the missing, they don't have the complete ATM video. She's fighting this a little bit. She's trying not to actually fall on her sword. Or maybe she's putting on a really good act like she's not trying to fall on her sword. I don't know.
When an agent, the state of Tennessee says, this ATM transaction is not covered by our videos, do you trust them?
Yes,
Why? It's what they do for a living, right?
it's what they do for a living.
We can't trust TBI, who can we trust?
That's right.
Zach was on Facebook at 8:39 a.m.
Yes.
Did that ever get to the jury?
No,
Why not?
I don't know. I should have put it in front of the jury.
There were multiple phone calls going on that morning, correct?
Yes.
Did you ever connect to the jury where Holly's phone and body was purported to be during this time?
I mean, I don't know what you mean by that. Connect to the jury.
Explain to the jury. These phone calls are going on, ladies and gentlemen, while the state says Miss Bobo is being raped and killed.
Gloria?
No.
One of your to-dos in this exhibit was subpoena Facebook. And you had the document that shows he's on Facebook that morning.
Yes.
You argued that multiple people said different things that were not true.
Before we move on from that Facebook issue, I thought it stood out to me when Zach was on the stand at the hearing on Thursday. We watched that yesterday. And he knew how many communications, that there were a lot of messages being sent on Facebook. And it's kind of an unusual thing to be so assured of years later. And in my mind, that's an indication that someone was just given a piece of the evidence or the records themselves to review. They're very familiar with it right now because they just looked at the document that would give them that information. So I'm curious if Doug came in and subpoenaed this information from Facebook, where, what's it called? Where Zach is now aware that, yeah, he changed his wall, and that was something that they knew at trial because they could see on his wall there was a timestamp from that day and from a certain time that he changed something on his public timeline. That's why they knew about that before trial. But as far as his interactions in the messages, he's incarcerated. He doesn't go and get that to provide himself, and they don't subpoena it, but somehow they have it present day. And he's back and forth, texting back and forth with Rebecca Earp, arguing with her.
Correct?
Yes.
Do you remember what Brent Booth said? The phone call changed it all. Do you remember that at trial?
Yes.
And who made that phone call?
Dennis Benjamin called 911 saying that somebody had confessed to Holly Bobo's rape and kidnapping.
Do you remember who Sheila Kilser was?
Not exactly.
Okay.
So I found out, was it while I think we were in the watch party, but it wasn't. I think I just sent a screenshot. So that's why I don't remember saying it out loud. We were over on Discord and I saw with Katie Spirko in the podcast, in August, there was an officer involved shooting in Tennessee and someone dies. And that person that dies is Jason Kilser, the son of Sheila. Sheila makes this call and tells Brent Booth, hey, like 6 or 7 months ago, I heard this suspicious thing. I'm going to tell you now, though. She doesn't make that call until after her son Jason and Dylan Adams are picked up on those federal gun charges. Well, Jason Kilser's gone. He's no longer an available witness. And I wonder if they discussed that while they were off the record. Because this may have been the first set of hearings since that August news.
You had if you look at this document, do you remember seeing FBI documents in this case?
Yes.
The third paragraph, Lita Bowen. This statement says, 2 to 3 weeks ago, Darnell came to the Bowen home to watch television. The subject of Holly Bobo's disappearance came up. Darnell asked Bowen that if she knew who abducted Holly Bobo, would she provide this information to law enforcement? Bowen responded that she would do so to help the girl and her family. Darnell said he knew something about who abducted her. She told Darnell that if he told her the information, she would contact law enforcement. Next paragraph. Darnell then told Bowen that Victor Dinsmore had told him the day he abducted Holly Bobo and took her to Miss Dottie's. Do you remember seeing the FBI reports like this in discovery?
I don't remember this particular report, no. I'm sure it was provided to me. It has a stamp on the bottom. This is Bobo and has a date stamp number.
And you didn't think Victor Dinsmore did this crime at all?
No.
But you didn't use this to attack everything Victor Dinsmore said?
No, I did not.
You never issued a subpoena to Miss Bowen, did you?
No.
Can we,
Your Honor, I've moved to mark.
I want to run this IR back. What is this whole report? Dinsmore, Darnell, and Lita Bowen.
The third paragraph. Lita Bowen. This statement says, 2 to 3 weeks ago, Darnell came to the Bowen home to watch television. The subject of Holly Bobo's disappearance came up. Darnell asked Bowen that if she knew who abducted Holly Bobo, would she provide this information to law enforcement? Bowen responded that she would do so to help the girl and her family. Darnell said he knew something about who abducted her. She told Darnell that if he told her the information, she would contact law enforcement. Next paragraph. Darnell then told Bowen that Victor Dinsmore had told him the day he abducted Holly Bobo and took her to Miss Dottie's.
What? So Vincent Dinsmore is the same individual that Jackson and Agent Booth go all the way to Indianapolis to talk to this guy. And, you need to tell us something or we're looking at you. You're looking real ripe right now. Well, you need to go talk to Dylan Adams. He's the slow one. He's the one that you'll get information out of. What the heck? And Victor was another key witness. So when we watch this trial, are we going to hear from Victor and Terry Britt at trial, and the state's going to tell the jury how great and credible they are as witnesses and couldn't ever be a suspect?
Do you remember seeing the FBI reports like this in discovery?
I don't remember this particular report, no.
So your strategy, Sheriff Chuck's on it. Your strategy is a third-party culprit defense. Sure enough, specifically, you want to lean heavily into Terry Britt. But you have these IRs talking about someone else is saying, and really a lot of the damning stuff against Zach Adams is someone saying something, something, something. So if that's what the jury gets to consider, and you have the option to go and say, hey, look, there's someone else saying it was someone else. What weight? It's something that the jury could give the same weight to and then say, hey, we are not beyond a reasonable doubt that this was Zach because the community, there's other people in the community that think it was somebody else.
I'm sure it was provided to me. It has a stamp on the bottom. This is Bobo and it has a date stamp number.
And you didn't think Victor Dinsmore did this crime at all?
No,
But you didn't use this to attack everything Victor Dinsmore said.
no, I did not.
You never issued a subpoena to Miss Bowen, did you?
No.
Your Honor, I moved to mark this into evidence.
Objection.
No.
Exhibit 147.
Yeah, and there's no, the major issue there is what strategy call would you make regarding that piece of evidence that you'd say, hey, strategically, we think this is going to harm our client if we try to bring this up. And we didn't get to the full document read out loud. But, I mean, if all that was about Bowen and Darnell, how is that going to have anything negative for Zachary Adams? What would be the strategic reason not to bring that in? I'm okay. Yeah, oh yeah, and biased because yeah. And not for nothing, but if there's rumors that like Dinsmore was where drugs could be procured and money issues get back, I don't know, that could kind of fit a shorter timeline. Abducting someone, shooting them in the back of the head and moving about your business. In contrast to like a several hours or days long, weeks long trafficking theory.
I want to take you to the transcript. Of Dr. Ross.
It's going to be about the gunshot wound.
You have your transcript? His testimony began on page 1128, but I'll take you back to 1147. You admit, page 1128, Dr. Ross says, I'm former forensic pathologist and the deputy chief medical examiner at the West Tennessee Regional Forensic Center. You understand the difference between a pathologist and a ballistic expert?
Yes.
What is it?
Well, a pathologist can't give expert testimony about ballistics.
All right. Page 1147. Line 3, the witness says, well, what a .32 caliber bullet is, by my understanding, has a measurement diameter of 0.32 inches.
The whole chat would, if we were watching this live, I bet the whole chat would have been like, objection.
By converting to inches, the size of the defect in the back of the skull, that's about a 0.36 inch defect. So anything 0.36 or smaller could have caused that defect. So that would be consistent with a .32 caliber bullet causing that defect. Did anybody on your team have a red flag go off and say a pathologist is saying what his understanding is of a
Objection.
.32 caliber bullet?
No,
Are you aware it's not .32?
no,
Do you, General Nichols argued to the jury, do you think she just randomly pulled out .38?
no.
What was she referring to?
The bullet that was found next to Holly Bobo's skull.
Do you agree it was your job to convince the jury that bullet was not excluded?
Yes,
Did you do it?
no.
That's a big issue. It's going to be so interesting watching the trial after watching this. Like, what a rare thing that we get to do.
Those are my questions, John.
What a way to
Wait, I
end.
apologize.
Look at Amy.
Can I check with co-counsel?
Hold one second.
Nothing further, Your Honor.
You put on proof that the defendant, your client, was in Parsons at 11:16 in the morning, right? That's what the cell phone records proved through your expert, Jonathan Reeves, right?
That his cell phone was there. Yes,
Right, but it's your theory today that he was with it,
yes,
right? Because he got up and he wanted to go get Xanax and they went to Parsons.
yes,
So he was in Parsons with his phone at 11:16 in the morning,
yes.
right? The jury heard that. It showed you these still from the ATM video. How would you have admitted that into evidence without your client testifying?
I don't know.
Mr. Bates just handed you an IR regarding a conversation that law enforcement had with Shane Austin's parents in February of 2014. And you and Mr. Bates left the impression that what was turned over to TBI was a document that would prove the innocence of your client, correct?
That's how I read it today.
Would it surprise you to know, and we're going to throw it up on the screen there, you would agree with me that Holly Bobo was kidnapped, raped, and murdered on April 13th of 2011, correct?
Right.
Okay. When was the first time your client mentioned being at the ATM?
Oh, I don't know.
Would it surprise you to learn that he never said that to law enforcement?
I don't know.
Would it surprise you to learn that Shane Austin never mentioned to law enforcement that he was at the ATM in Parsons at 11:12 in the morning or whatever it was? They never mentioned it.
Okay, I mean, is there a question?
Would that surprise you?
To learn that they hadn't mentioned it?
Right.
No.
Do you know how law enforcement even found out about it?
Rita Austin, I'm guessing.
She called and said, we have reason to believe that our son took out some money at 11:12 on April 13th, 2011. Okay, great. We'll come talk to you. So they did. And the Austins provided, oh, we need the remote, Your Honor. This receipt that's mentioned in here.
Yeah,
Counsel, it's like, It's loose.
This one's just super loose, actually. Yeah, so every time you turn one,
Is that this old house?
Are you trying to get some set on your house?
it's travel hands.
Oh, is it?
What are we
What's the
doing?
date on that? No. I had it.
I mean, it sounds like an ATM boop, but then it keeps cutting into random other.
It looks like it's 11/11/14.
Not the date Holly Bobo was abducted, murdered, and raped, right?
No.
It was a receipt they gave the law enforcement so that they could perhaps use that account number to find the video that you received.
Actually, it might even be 02/26/2008.
Who knows? But it wasn't April 13th, 2011, was it?
It doesn't seem to have that on the receipt, no.
None of the bank records that you just looked at or the receipts have any timestamps on them, do they?
No.
You did cross-examine Jason Autry about his phone use. You went into great detail about catching him in the fact that he's testifying to the jury about what he and Zach Adams are doing to Holly Bobo, and he's making a phone call. You asked him about it. You drilled right down to it. Remember that?
Yes.
You did ask him about it.
Yes.
The Facebook records were in discovery. You had the Facebook records.
Yes.
And what they showed was a mobile posting at 8:30 in the morning, not someone sitting in front of the computer, correct?
No.
Your testimony is they did not.
There was a landline. At least one of the interactions was through a landline, which suggests to me like dial-up, DSL, whatever.
Right. They showed that the post came from, I thought it came from
Who are you looking at to get your answer from?
I'm not looking at anybody. I just was lifting my head up trying to think of the word. I'm having some trouble with word finding.
Okay.
That the post came from a landline telephone.
That's your understanding.
That's my understanding.
Okay. And there wasn't a bullet found by Holly Bobo's skull, was there?
There was a casing.
And it wasn't by her skull. It was in the area. It was in the area.
I don't
Her
know.
body, the remains of her body were found in a ditch, correct?
Well, her skull wasn't found in a ditch.
Right. It was in a totally different place, right?
Yes. I mean, I went out there to the spot.
Right. It wasn't all just there neatly together.
No.
There was other ammunition found out there as well, too, wasn't there?
There were, I don't know if it's ammunition or case shells or bullets. I don't know what else was found out there, but there was
Things that
other
are-
things.
Things that are shot from guns
Yes.
also found out there, right?
Yes.
Nothing further.
Mr. Bates, pass the exhibit 7.
So we're gonna have a little bit of redirect. But I'm a little bit confused because it seems like I would keep this in my pocket if there's a retrial, that your star witness, Jason Autry, his claims, he's the one that gave police early on, or maybe it was his parents that actually provided. He's the ones that give them something misleading to alibi himself. A printout of a receipt. That's not the same thing as the phone record. Doesn't counter the phone records from that day. So what that would put at issue is if Shane's phone record puts him somewhere on April 13th, Shane cannot use his separate ATM transaction printout receipt to say, hey, I had my device on me. This receipt shows it. Other things would need to show that. But that should just mean that Jason Autry and how you approached him you should have had better concerns before you made him a deal to cooperate. But then you put him on the stand and you vouched for him. But let's get this little redirect.
15 and 7 to the witness.
Let's wrap it up.
I know, Your Honor.
Is this going back to the bank records?
17 and 7.
Ms. Thompson, very briefly, I've handed you Exhibit 17, IR 1845, author Mark Lewis. Do you see that?
17, yes.
Could you have issued a subpoena to Mr. Lewis to bring what is listed as item 48 V8 BP Community South Bank ATM April 2011 to the trial?
Yes.
Exhibit 7. This photo was the impound you see of the Chevrolet.
Silverado.
Yes.
Same Mark Lewis.
Yes.
You see that? You could have issued subpoenas to both of these, correct?
Yes.
And you did not.
No.
Final question. You were asked that Shane Austin did not keep his receipt from April 13th, 2011 of the ATM withdrawal. Right?
Right.
No, that's not.
Well,
at
I
all.
don't think I was asked that
The
question.
Thank you. Ms. Thompson.
Okay. They both agree.
Objection is sustained. So let's rephrase that question.
Right.
Mr. Mayor.
Nowhere in discovery was Shane Austin keeping a receipt from the ATM withdrawal from April 13th, 2011, correct?
I don't think so.
Who did keep his receipts from April 13th, 2011?
Terry Britt kept his receipts locked in a safe from
Nothing further.
April 13th, 2011.
All questions?
No, sir.
Ms. Thompson, thanks for your testimony. Step down.
Thank you.
Doesn't look like they have any housekeeping, but let's see, because this should be the last day of hearing for November.
Judge.
I used to keep ATM receipts before, at least for a little bit, to make sure the deposit would go through.
I believe that you definitely conclude the proof of the day. So
Yes, Your Honor. Can I advise the court if proof rests after today? I don't have anything else for today. The only thing I anticipate is attempting to prove up the ATM subpoenas I attached to my motion. I don't think it's in dispute.
the ATM subpoenas were issued by a Ferguson that are entered as identification only.
Correct.
There were two-page, I don't know if it is elected exhibit or I'll let you discuss that with the state. If that's your only intention. Let me ask this. Is there any objection to those being moved into evidence? You want to see them first?
Yes, sir. I can't even remember what they look like.
Let's find them. About when were they entered yesterday?
So this is for,
125 through.
this is a contentious subpoena. I feel like the state's going to call Jim.
Well, it's at the very end of Judge Nichols' direct.
Judge, we're fine with moving, stipulating that it is a proper administrative subpoena from TBI. It should be moved into evidence.
I thought they were already in the record, so yes,
Well,
that's fine.
You objected because you couldn't authenticate them, and so I moved them in for identification
Gotcha.
only.
Yes, sir.
Without objection now, exhibit 125 is moved into evidence. That's it. Mr. Bates?
Petition arrest, Your Honor.
All right. Thank you, Mr. Bates. Based on my calendar, let's make sure we're still all on the same page. We are scheduled to be back here December the 29th for 2 days. And if the state, let me ask this, the state think they can be done in 2 days,
Yes,
including closing?
probably.
Mr. Bates? If you can do a closing, whatever time's remaining in those 2 days?
I don't know how much time will be remaining.
know.
I would anticipate requesting 1 hour for closing.
Well, I mean, I'll listen to an hour at 9 o'clock at night. If we have to do it, I don't want to do it, but
Right.
if we can get done in those 2 days, that would be a great goal. Let's just leave it at that. If we can't, we have further time set aside in January.
Well, could the state at this point anticipates calling 6 witnesses? Would it be a better use of the court's time to do it all in January? And instead of coming back in December for proof and then coming back in January anyway for closing, or running into a problem where we don't get all the proof on, but we've got 3 days in January, correct?
They don't want to do this between Christmas and New Year's.
I only had 2, the 7th.
Oh, okay. Okay, then scratch
We
that.
have set up an 8th, 2 days.
Okay. We had 3 on our side, but that's all right.
We can look at another period. I mean, I had a trial the next week, and I know it screws everybody's calendars if we, the next week, which is the week of the 12th, and
Currently-
the 13th through the 16th.
I currently have a murder trial in Hickman County that week.
Oh, we got to watch that.
All right, let's just leave it
Yes,
where we
sir.
got,
Yes, sir.
the 29th and 30th, and I'm not opposed, I'll throw this out there, coming back on New Year's Eve on the 31st. So if it means we can get done, if we can't get done, I'm not forcing you into that decision now, okay? Just leaving that as a possibility.
Yes.
Right now, we're set for 8:30 on Monday, December the 29th. We will recess until that time.
Yes, sir.
All right.
I've got
Great.
lots to get here, so
So that is the end of, the evidentiary portion that the petitioner is going to put on. So that's Zach Adams' side. So state's going to respond, 6 witnesses. I mean, I think that they're going to call Jim Simmons. I think they're going to call Jim Simmons. I would like that because I'm messy. But yeah, we'll see. Yes, Bates does trials. Yes. So if that would be fun to watch. So I think in January, if we could find a way to watch that, because it's probably not very likely that courtroom has camera access, but if it does, I think we should watch a Doug Bates case. As far as a decision from the judge, it's going to have to come after the close of these proceedings. So if they stick to this calendar and get it done in December, I think he's been very efficient with his rulings. But this might be a longer decision. I feel like end of January if they close out in December. Assuming no issues come up, right, during December. Like what if they need to appeal some issue that comes up? I would say end of January. He's quick with his orders in relation to smaller motions, but this is going to have to be a longer decision. What do we got, guys? We have the Discord that if you have not joined, now's the time to do it. There should be a link in the description for Replay Crew. I think we'll get together. It is 3 p.m. my time now. I do want to make sure I got to switch my laundry to the dryer. And get a little stuff going in the kitchen, prep some dinner, get stuff marinating. And then maybe in 30 minutes, so like 3:45, 38 minutes from now, we can do a watch party over on Discord. We'll go through like Instagram, other information from this case, continue on what we did yesterday. I think it'll be a good time. So come hang out. I'll explain when you get over to Discord. I'll paste a little instruction on how to join the area of our Discord server where you'd actually watch with us, and explain how to make sure you can participate in the chat. Because on mobile, you got to like press the chat bubble to get it open. And we'll make sure you're in there and able to hang out with all of us. So one last time in the chat, we've got the Discord link. As far as if you guys want, let's go say hey to somebody that's doing something right now. Brooklyn, did you say Brother Counsel was going live, or are they done already? To talk about Fraser Bohm. And I think it was Brooklyn, I think it was Brother Counsel, and I think it was Fraser Bohm, but I could be wrong on any one of those details. We've got, let's see, YouTube Studio. Who's live? Okay, yep, Brother Counsel has on Alan Jackson talking about Fraser Bohm. So if I can redirect over there, we can go say hey to Brother Counsel. I know you guys love Alan Jackson. At least a lot of you do. I shouldn't speak for absolutely everybody, but seems to be the common consensus, at least in this neck of the woods. Yep, I can redirect. So that is successfully saved. That'll travel you over there. We're going on a trip. Say hello. Come hang out in the Discord. And again, I'll post in the Discord right when we're about to fire up the watch party. That way you'll know it's time to join. Yeah, Dustin Tabby's going to come hang out. Heck yeah, heck yeah. GV's in there. Going to figure out how to use it. It's okay. I'm still on a Discord learning curve, but I'll help you guys out. Don't worry. It's not as nerve-wracking as it seems. And then let's see. Anything else, you guys? I do want to say, I said thank you, but I do want to give a more proper thank you to Sheriff Chuck here for gifting 5 memberships earlier in the chat. I forget what we were watching, but I was like, thank you so much. And then I was just riveted by whatever was going on in the courtroom. But big thank you for Sheriff Chuck for hanging out with us today and dropping 5 gifted subs. Thank you again. Also, Classy had came in here and dropped some gifts. Slim Life had made herself a member. She said, why am I not green anymore? We had some hippo stickers coming in from Love Amy E. We also had KLB dropping some love, and maybe KLB will be able to come hang out with us again over in Discord. It was great last night. And then also Classy being here for 16 months, which is like feeling like a million years at this pace. So let's go. And here's Amy. Sorry I've been saying Amy so much, by the way, today. Every time I'm raising a complaint about Amy Wyrick, I'm not talking about Amy E. So that being said, you guys, let's go say hey to Brother Counsel and get back together in half an hour-ish in the Discord to do some random deep diving into this Zachary Adams case. See you guys in a bit.